in a city that never sleeps. A lone guitarist makes his leaps, fingers dance, strings sing a tale of a dream that feels so frail. Echoes fill the silent night. A lost love, a heart so tight. But in this cold, hard world, hope's just a fleeting word. Oh, trees whisper, oh, trees sigh. In the darkness they take flight. Heartbreak echoes, lonely cry. In the cold, hard light, guitar soars through the stormy skies. A melody that pierces the eyes. Love's a memory, a distant dream. In this world it seems fingers glide in the fading light. A final note, a last good night. Lost in the shadows, lost in time. Dreams are all we find. Oh, dreams whisper, oh, dreams sigh. In the darkness they take flight. Heartbreak echoes, a lonely cry. In the cold, hard light.
In the shadows where whispers dwell,
1.3.
slight guitar sings of love's farewell.
10-4, I just wanted to know if
Echoes of the heart once bold, now lost in the night's cold fold.
Yeah, I'll be 23 back on the
Secrets hidden
property
deep
I'll be 70 seconds
within,
of the Williams Road address.
tales of love that couldn't win. Promises made in moonlight's glow, now broken like a shattered show. Sorrow in the guitar's cry, resilience in the sky. Through the night we'll find our way, carrying secrets, holding on today. Memories of laughter and tears, in the silence they appear. Whispers of a time so true, when love was all we knew. Lost in the echoes of the past, wishing for what we had. In the dark we search for light, holding on to what we fight. Through the pain, through the night, we find strength in the fight. Sorrow in the guitar's cry, resilience in the sky. Through the night we'll find our way, carrying secrets, holding on today. to give.
21.
Starting a card for a parking problem.
Foreigner 23.
Yeah, that's where I'm gonna 28 on truck when you're ready.
Good morning, everybody. Sorry about that. Just taking care of technical issues and stuff like that. So Jen will be on in a little bit. Kate, I hope Matt. I haven't talked to him. Matt doesn't usually tell me ahead of time when he's coming, but he's usually here. We are all towels. No, we're not. No, we are not. So yesterday, after so we this with the way they ended yesterday, that caught everybody. Thank you, Joan. That caught everybody by surprise, including Court TV, Channel 5, Fox 25. No audio. You saying there's no audio? Can you guys hear me? Someone's saying there's no audio. Somebody give me a sound check. Let me know if you can hear me. Somebody please let me know if you can hear me. Thank you. Because someone is saying there's no audio. So, all right. Thank you, Ken. Thank you, everybody who's saying that. Thank you, Elizabeth. All right. So, but it turned out the reason they stopped early yesterday was because there was a motions hearing on primarily on the ARCA guys. I think actually exclusively on the ARCA guys. And so I ended the show because all the other things were ended, and it's a long day for us. And thank you, Cindy. And then I find out quickly after that there's a motions hearing going on. I'm like, damn. So I'm ready to go live back on the air, but I couldn't find it on anywhere. I couldn't find any channel covering it. I went to Court TV, Law and Crime. I went to WCVB. I went to the local Fox 25. Nothing. So I had no choice. I had dinner. But before I had dinner, I actually found that one channel that was covering it was local NBC 10. So I went. It's okay, Susan. Don't worry about it. So then I went. We all have our tech issues. Trust me. That's what I was helping Jen with this a little bit earlier, and it's okay. We all have them. So I went to and I covered the motions hearing a little bit after it played. So around 5:30, 6 o'clock last night, I went live and covered it. But I forgot to save that too. So maybe I can find a clip of that for you guys this morning. I mean, it was about 15 minutes long, but we don't need to hear all of Alessi's. Let me see if I can. One of the main takeaways from it. All right. I guess, I don't know. I got a decision here. Do I try to talk to you guys or try to find this? Let me see. NBC 10. Sorry, I should have tried to find it before I get on, but just doing other things. Let's see. All right, I got this. I think I got it. Okay, I got it. All right, then. All righty, then. I'm going to pull this up and I'm going to maybe try to fast forward through it or skip to the parts because we don't have a lot of time. All right, so this NBC was the one channel that was smart enough to stay on this till the end. All right, so this is not a live fan. This is a fan from yesterday.
So we'll have a quick hearing on paper now 682 and 680. First, Commonwealth's motion to enforce compliance with the court's April 16th, 2025 ARCA discovery order. Mr. Brennan, you said you could be brief on both of these, so we'll hear you.
Your Honor, I'll get right to the point.
I mean, just consider the exasperation in the judge's voice. She's determined to not let this trial take 10 weeks and to keep it on track. But yet she has to stop this over an hour early yesterday just so they can do this hearing. And now, as we're going to find out, she's moved the voir dire for the ARCA guys up to this Friday. So again, it's just these legal maneuverings have made it impossible for her to keep this going fairly. And really, well, you're going to maybe some people consider this bias, but it's the shady moves of the defense, as always here.
On the motion for compliance, our position is that the defense did not comply with your order. This has been an ongoing issue which relates directly to the credibility of potential ARCA witnesses. This is information based on the history and representations made in this case that we're entitled to. I did note before these were produced that we have watched video footage from unaired video from the documentary. We clearly knew that there were text messages and correspondence beyond what was represented to the court. It is not a surprise that I did receive these lists of text messages and calls after I made those comments. However, there is no text message content. There is.
So important to note here, it was only recently that the prosecution got the 400 hours of unedited footage from the Discovery ID HBO Max documentary, The Body in the Snow. And there must have been something referenced in that unedited footage talking about the text to ARCA. And Hank Brennan picked up on it. So he is rightfully saying, where are those texts? That's Rule 14 discovery material. It should have been provided. Where are the texts? And he only knows about this because Terry Dunmure, the owner of Unsolved Videos, has the moral integrity to not fight this and to turn over all that unedited footage before the trial. So that we're slowly getting to the truth on this scurrilous team. This team is really scurrilous. Wouldn't have happened without Hank Brennan, wouldn't have happened without people like Terry Dunmure.
Is 99 texts to Mr. Wolf, 6 texts to Mr. Lenchler. That does not reconcile.
Just think about that. Last year, David Yannetti, as the trial was beginning, told the court, you're not allowed to lie in court, that the only communications that they've had with the ARCA guys was to arrange travel. That's it. But here we see that there are 99 texts just between Dr. Wolf and the defense team alone, and several more. What did he say? 16 between Dr. Rensler. So they're liars. They stand up before a judge. They don't just lie to the media. Lawyers think it's okay to lie to the media because it's legal. See, in the way most lawyers seem to operate, they don't have a moral. And I'm sorry if this offends some people. And I welcome lawyers to push back at me on this in private messages or whatever. But it seems to me the majority of lawyers, rather than have a moral or ethical standard that guides their life, or at least their professional life, what they have is the law. And it's easier to say, well, if it's legal, it's moral. And so if you're a lawyer, you think it's okay to lie to the media because there's no law against it. But David Yannetti lies and Alan Jackson lies to a judge in a court. That's not legal. Now, it's difficult to prove sometimes, right? So there's no question it's happened. There's no question that Hank Brennan knows that that's what's going on. There's no question that Judge Cannoni knows that's what's going on. But can it be proved is a whole other matter. So as we're going to see, these texts have been deleted by the defense team. And so because they're deleted, we're going to have this voir dire, and ARC is going to come in Friday, and they're going to be asked about it. And I'm going to bet you, I'm going to give you heavy, heavy odds that ARCA is going to say, Dr. Wolf is going to say, oh, I deleted mine too. And they're going to say, why did you delete it? And he's going to say, well, I delete it every month. My phone automatically deletes it. This is scurrilous. It's skanky. Bullshit. It's bullshit is what it is. But you can't disprove it. There's no way to disprove it. Because it's their word against yours, and you don't know what's in those texts. So unless you can somehow recover those texts, you have no idea what Alan Jackson, sorry, I couldn't think of the famous lawyer's name, and Dr. Wolf were talking about. But for 99 texts, I don't think they were talking about where their kids are going to college. If that's what it is, get up and say it. But they certainly didn't have 99 texts talking about travel. And what Alessi's going to get up is going to say, hey, we had no court order ordering us to preserve those texts, so we're in compliance. Which, again, is just so freaking shady.
With the past positions and representations of the defense to this court and to the Commonwealth. In addition, there are a number of phone calls. And those phone calls, again, I would suggest do not reconcile with the past representations. We have 52 minutes of phone calls on 5 calls with the ARCA mainline, 133 minutes, 20 calls with Dr. Wolf, 57 minutes, 23 calls with Dr.
So almost an hour of phone calls with ARCA on their main phones, and double or triple of that with Dr. Wolf alone. The state has a right to know what's being discussed in those calls. Now, lawyers famously understand that if it's not in writing, it doesn't exist. So that's one of the games that they play. But in addition to that, you have those texts that is in writing, and that should be in discovery. And sorry, I'm playing this on a faster speed. This is not Hank's natural voice.
Dr. Rensler, I find it difficult to accept that these are all for scheduling purposes. We also had your Honor's order, not just for the communications, which are not a complete or a fair production, but there was a order by the court to provide all correspondence, text messages, emails, not just with Attorney Jackson, but with the entire team, including the defendant, Karen Reed.
So an order by the court to provide not just emails, but all correspondence. However, what the defense is going to say is those text messages were deleted before that. And what the judge is going to say is, but you have a right. I mean, so you have not a right. You have an obligation, a legal duty to maintain any communications relevant to your client.
And we have received nothing. This is important because if we look at the first half of ARCA's potential testimony, which is limited to their prior report, we cannot fairly and effectively cross-examine the witnesses until we have the information we're entitled, and that's why I've also asked and suggested that ARCA should be ordered and required to provide that evidence as well, so that we can see what is there. It is concerning that there are this many texts, this many phone calls, and the fact that this is totally in contrast to what was represented in the past. So before there's even a thought of ARCA testifying, I think we're entitled to the full discovery that we asked for, the full discovery that the court has ordered. I don't see anything to do with billing or anything else beyond these text message and phone call logs. I want whatever content is available. I think it's relevant material. It's pursuant to your order, and this is woefully incomplete. Should I dive into the second motion?
Yes.
Move quickly. The second motion, part of it is moot in some respects. I won't go through the tortured history of discovery. We've gone through it too many times. We don't have time for it. But inevitably, it is clear that we have played by the rules, met our discovery obligations. And as we stand here now, the defense is proposing new opinions, new testing, and they don't even have the parts of that testing yet. This is 2 weeks into trial after we picked a jury. This is at the time of the opening. It is ambush. It is unfair. And we have no ability at this point to reconcile or deal with new opinions and new information. Importantly, the defense's position.
All right. So to explain this, and Alessi's going to have an answer to this that's partially fair, but this is why this is also brilliantly played by Hank Brennan. So the answer that the ARCA guy, so first the state hired their own accident reconstruction company. I think they hired them this past fall, called Aperture, and they've done their own testing and studies relevant to the case. The results of those studies have been kind of turned over to the defense. I'm not sure when they were first turned over. I think maybe February. But the defense will say, but what was in it was incomplete, didn't really explain what the testing was. And so there was a lot of back and forth on that. Now, how substantial that is or not, for instance, I don't know. But for instance, unless he's going to say that we had that Aperture redid the image of 34 Fairview, and we found that image to be a problem. So we had to go back and forth on that and over the last several weeks. But does that really tell us anything about the testing that was done by ARCA? So what happened was, by Aperture. And I don't know the answer to that. So you're trying to split hairs here and who is being fair here or not. If the state is turning over evidence of testing from Aperture that is not very complete and they don't really get that up to date till April, you can understand why. Now, so what happens is the defense has hired ARCA with the permission of the federal government to run their own tests to try to rebut the tests of Aperture. So this again shows what ARCA is. ARCA is not, they will not be allowed to be presented as an independent expert. In this case, they won't be because they never have been. They're not hired, for instance, by the defense to see if those new tests done by Aperture actually shed new light on the case. They can pretend they were, but they weren't. The defense didn't say, oh, you think the defense hired them and they're going to come back and say, yeah, we did some tests and it turns out that those Aperture guys got it all right. No, that's not going to happen. That never happens with defense experts. You have those rare experts like Jen Coffindaffer that if she looks at something, at the evidence, she'll get back to the defense and say, yeah, you won't like my opinion. So they don't hire her. So she gives up that contract because she has integrity. But that defense, you won't see that in an expert because Jen won't get hired for that case. So what that defense team will do is find an expert that will tell them what they want to hear. And so they go through this shopping process until they find someone that will do that. And, it's not this naked, like, hey, we're putting out this evidence to a list of experts. We're a defense team, and let's see who can help come prove that we're right or help rebut the prosecution's experts. No, it's understood. It's understood by the experts that the defense team reaches out to that they're only going to get hired if their testimony, if their testing helps the defense. That's understood. It's obvious. It's self-evident. So they're not asking anybody to be corrupt. It's just understood that if you're not going to help them, they're not going to hire you. So the ARCA guys were tasked with rebutting the Aperture experts. They weren't tasked with trying to find out if the Aperture experts were accurate. Now, there is still a little bit of a quandary perhaps when you're an expert like that, because if you look at the evidence and you realize, wow, we're going to look really, really bad on this, then and so for selfish reasons, you might say, kind of like Phelps. I believe Phelps ended up coming down on the side of the conspiracy not being true. But I don't think it was for ethical reasons. I think it was because once he realized how embarrassing this conspiracy theory was, which he bought into last summer, once he realized that, he didn't want to ruin his professional reputation. He's published almost 50 books. And he considers himself a mainstream journalist. He didn't want to ruin his reputation. But that's okay. We can live with that. the bottom line is Phelps still did the right thing and gave up selling a lot of books or selling a lot of documentary, not books in this case, I'm sorry. In this case, making a lot of money off his podcast to do the right thing. He cared more about his long-term reputation. And so is a chance that somebody like Arca might feel the same way. They may want to help Karen, but they may sit there and say, you know what, we're going to look bad on this. But I don't think that's going to be the case, because I think with experts, smart people can always find some way to attack the other side, whatever the other side is, whatever their opinion is, whatever experiments they've done. And if I don't want to say Dr. Rensler came off as arrogant, but Dr. Wolf came off as one of the most arrogant human beings I've ever seen. And that guy does not want to ever admit he was wrong. Right? I mean, that guy got up on the stand and just like the Karen Reed YouTube empire, they consider Dr. Wolf science with an echo in the room, science with a capital S, right? It's like Mount Olympus. Dr. Wolf is science. He might as well put on flowing robes and a long white beard, because he is science and he is going to tell us what the truth is. And Dr. Wolf seemed to feel that way about himself, that's what he was. So, Dr. Wolf is going to want to try to help Karen Reed. And he obviously became close to them too.
They may or may not have a report by May 1st. Our expert will be testifying somewhere at the beginning or middle of May. He is away. He is not available. And so anything we receive at the beginning of May or end of April, we'll have no opportunity to look at, vet, test, reconcile, or even engage in our own testing. This was my concern all the way back in November. I'm not Nostradamus, but this obviously was something that worried me that actually occurred. And so at this point...
I love that line. I'm not Nostradamus, but I did foresee this. And you don't have to be a psychic to know it. You don't have to be a fortune teller like Nostradamus. You just have to know what you're dealing with here with this particular legal team.
It would be fundamentally unfair for the defense to get a benefit for failing to comply with discovery orders by waiting until February to seek permission with ARCA. They could have called any expert, asked for any expert they wanted. They didn't. They chose this method, and this is the consequence of it. And at some point, the defense has to bear the burden of their decisions. We will not have the ability to rush through, have Dr. Rensler come in days before his testimony, try to reconcile, be inadequate. I've had a brief correspondence with him. It's simply impossible. That's why we suggested, although we certainly didn't want to move the trial date, that was the only remedy if the court was going to allow any new opinions, evidence. I say to the court that they should not be allowed to offer absolutely anything new, not only because they missed the discovery deadline, that's technical, but the reality is we're all trial lawyers, we've all tried a lot of cases. It would be a disadvantage, fundamentally unfair, and because of their own choosing. And so anything new we will not be able to reconcile. We would not be able to proceed with our expert in a fair manner. Thank you.
Okay. Mr. Leslie, is this you? I'm going to ask you to be as brief as you can be, please.
Your Honor, I understand your request to be as brief as possible, but this is...
She does it in her motherly voice, but she still can't hide her exasperation. Please, Alessi, don't take 20 minutes to tell a 1-minute story.
The first opportunity the defense has had to respond to almost every allegation that's been made. We haven't had an opportunity, so I certainly respect the court and what the court's request is, but it is going to take a bit of time to put facts out. And I want to separate two categories that the Commonwealth has conflated. The Commonwealth has conflated the issue of what text messages exist, which text messages don't exist, what's been turned over pursuant to orders. And I would like that to be clear to the court factually, because the Commonwealth has misstated just now 3 times the facts.
So I asked this morning, there were 100 or so texts referenced in the exhibit, whatever was presented by you folks. I asked if Mr. Jackson, if he provided them, because my order was clear, they would be provided. And he said no. And I asked you at sidebar whether they were deleted. And you said yes, in due course.
So she's pointing out, I asked if these were provided, and the answer is no. And were they deleted? Yes.
No idea what that means, Mr. Leslie. Why don't you explain that?
Well, thank you for the opportunity to explain. Here's what it means. Like anybody's phone, those text messages are 2 years old. They don't exist.
So can you also tell me,
They are not 2 years old. The very first time that ARCA could have communicated with the defense was March of 2024. So at the most, those messages are 13 months old, which is a lot closer to a year than 2 years. It's basically a year. They're basically a year old.
aren't the ABA guidelines the council is supposed to keep everything in a case for 5 or 7 years?
I do not believe that is the ABA rule with regard to experts. I'm unaware
In
of that.
regard to your client, and this was in regard to your client's case, right?
I'm sorry, Your Honor, I didn't hear you.
Records kept regard to your client's case, which these are experts that were, I mean, there's 100 text messages leading up to trial when I was told that by you that there was a pause email and then all of a sudden out of the blue a bill appeared in July. This shows that's not true, Mr. Leslie.
Your Honor, that was a different question.
And just to give you guys an update as we're getting close to 9, I do have, this is not live. This is from the end of the day yesterday, a motions hearing. I am monitoring the live on Court TV, which is about a 45 seconds behind the other live feed, but it's already on. But I am monitoring it, so nobody's going to miss anything with the trial today.
That Your Honor asked me back then. That was about emails. That was not about text messages.
Have emails been provided?
Yes, Your Honor.
Okay.
All emails have been provided. And that is why we are in compliance with all orders. And I will say also with regard to text messages, we have provided pursuant to every order, every single text message that exists. Mr. Brennan just said, I believe there has to be more there. There's not more there, and I don't believe there can be an order of preclusion based upon the speculation of opposing counsel that there must be more. We affirmatively created a document, Your Honor, to be more transparent than the records, where we summarize all of the communications. Yes, we don't have the text of the text messages, but we were completely forthright and set forth every text that was made. Plus, we turned over from Ms. Little, the only other person on the defense team who communicated.
So we do have live fan. So I'm going to go to it in a moment. I am watching it on another monitor, but I'm going to skip to the judge's conclusions here. So you got the gist of this here. So unless he goes into the difficulty of having this late time to respond to,
He can address them.
papers.
If he thinks that we're wrong, we're misstating, he's got the opportunity to speak to ARCA and ask those questions. Your Honor, it is important.
Right, so as you all know, I previously wanted you to have a seat, Mr. Leslie.
So what the goal here of Hank Brennan is to not allow any new testing by ARCA to be used. He wants it so that all ARCA can do is get on the stand and explain what they concluded in their original analysis. That's it. That's the goal. And so what Alessi is saying is you don't have to do it. There's another remedy. You can ask the ARCA guys anything you want during voir dire. But of course, you can't really ask about conversations on the phone, and you can't ask about deleted messages.
Thank you, Your Honor.
I previously found, and believe Mr. Alessi, when he was talking about the rules of professional conduct, did say, I agree, a violation of Rule 14, but not regarding rules of conduct. At a prior hearing, I found a violation of the defense's reciprocal discovery obligations. It was clear to me, and I found that it was deliberate. This appears to me, contrary to what you've argued, Mr. Alessi, that this is another violation of my order and of the reciprocal discovery violations. We need to figure all of this out before you're allowed to call these witnesses. So I'm going to have a voir dire hearing this Friday. I know we planned on having the view. I need the ARCA witnesses here Friday morning. So we need a voir dire.
Okay, so apparently Friday was scheduled for the view, not for the witness testimonies. I don't mean ABC's The View, obviously. I mean, let me go into the courtroom. We're talking about viewing the location. All right. So wanted to put this up so you guys don't get worried. So the judge made clear that she disagrees with Alessi. This is yet again an intentional violation of discovery. And more than that, it's really just not telling the court the truth. It's deliberate. It's not accidental. But, again, back to that world of the moral world of lawyers. If you can't prove it, it doesn't exist, right? So if you can't prove that Alan Jackson and the defense team deleted those messages because they showed that there were improper communications between the defense and ARCA, if you can't prove that that's why it was deleted, it doesn't exist, right? So, but judges have common sense too. So she knows what happened. And Hank Brennan said, I'm not Nostradamus yet. That was a great line because he's saying this was predictable because this has been visible in the behavior of this legal team since day one. So, these guys are all defense lawyers, right? Hank Brennan's a defense lawyer. So they've been all very respectful to each other in court. But that's breaking down because Hank Brennan understands what this team is. They've been playing outside the rules since day one. So I asked a few weeks ago on Court TV, I asked Joe Kraus, or I challenged Joe Krowski and Vinny. At the moment, only the three of us were on. And I said, I don't really understand. When I grew up, I used to read the books of Alan Dershowitz. I never really wanted to be a lawyer, but I did. If there was any time I did, it was really that. And he had represented some loathsome clients and got them off. But he explained very effectively to my high school ears that this was an important part of defending all of our rights by vigorously defending the rights of even the most scurrilous people around, the most loathsome criminals around. And he did that. But he said that strengthens everybody's rights. And I found that to be convincing. But I told Joe and Vinny, I said, now I don't know if I ever could have been a defense lawyer, because the idea that anything to help your client, anything legal to help your client. So if the law lets you do it, then you should do it, right? So if you can smear innocent people like Allie McCabe, like Jen McCabe, like firefighter Nuttall, if you could smear them, all's fair in love and war, right? So all's fair in love and lawfare. I don't think I could do that. I could never have got on the stand. I could never have stood before as a lawyer like David Yannetti did, to intentionally make it seem, to intentionally falsely analyze the evidence, the Life 360 evidence regarding Allie's travels that day, to make it seem like she was covering up a murder, to destroy this young woman. Was she 19 or something, 17 at the time of John's death, to destroy her whole future by making her whole town and everybody think that she's a murder accomplice. Just when you know that it's not true, you're a lawyer, you know that your client did it. You know that you're deliberately distorting that data to make it seem like Allie McCabe was doing something that she wasn't. You know it. There's no David Yannetti understood what he was doing. And actually, I don't think, like, say, for instance, Alan Jackson or Turtle Boy or Karen Reed, that David Yannetti is a psychopath. I don't believe so, because when I watched him doing it, to me, his face looked uncomfortable. He knew what he was doing was loathsome. He knew that. And that tells me there's a human there, but that human has been shrunk down to a nub inside there because of this idea that all is fair in love and lawfare. Anything legal is okay, because that's the moral universe. If it's legal, you can do it. And so even, I love Joe Krowski, but Joe Krowski had answered that question that day. It was very humorous. He said, hey, look, if I had to put my mother up to use my mother for a third-party culprit defense, I would. It was a great line. It was hilarious. And then later on the next segment, he said, my mom just texted me that I better take that back. But I got his point. And this is, so I guess I couldn't be a defense team. I could not just my mother, I could not take a young person like Allie McCabe and distort that data to make it seem like she was somehow complicit in a murder cover-up. I couldn't do that. So I guess I couldn't be a defense lawyer. Jen will be with us when she can. She's on Court TV from 9 to 10. All right, I'm going to change to the NBC feed because this one works pretty good, and this is also the feed that carried the motions hearing yesterday. The Court TV feed is good, but it's about 45 seconds behind. All right, here we go.
Seated, court is in session. 22 CR 117, the Commonwealth versus Karen Reed.
All right, so I was told council wanted to see me about something.
Yes, good morning, Your Honor.
Morning.
Oh.
Last night, we received 19 new exhibits. One of the witnesses that the Commonwealth intends to call today, Trooper Garino. Many of these reports are Cellbrite reports that are run with new software and not addressed in any corresponding report. Some of them include data that have never been discussed by Trooper Garino. There's at least one PowerPoint that is hundreds of pages long that appears to be cut and copied text messages and various phone calls. But again, we received at 10:45 last night. This is in violation of Rule 14, and we're asking the court to exclude, at the very least, the lengthy PowerPoint of phone calls and text messages that have been copied and pasted into a PowerPoint because we have no ability to go through in a timely manner and review them for accuracy.
What do you say about that, Mr. Brennan?
Your Honor, all of this information is from the phone discovery, which they've already had. There are a number of different select PowerPoints that were introduced.
When did they get it?
Last night,
No, when did they already have?
2023.
Okay.
And so what you may remember from the last trial is that there is, for example, Mr. O'Keefe's entire phone log, and then it's separated by his phone calls with the defendant, perhaps another witness. And so what we did is we tried to consolidate. Instead of having 50 of these things, I try to make them more limited. We did use more updated software. The only difference is it shows emojis. In addition, we took the phone calls and the emails or the text messages, which was presented at the last trial. Content has not changed. We just put it in a PowerPoint so that when it's read, instead of just reading the text messages and then searching for the phone calls, where Trooper Garino would then refer to a separate document, it's simply an order. There is a presentation of a different PowerPoint, which is from the old data, 2023, but it is information that was not introduced at the last trial, although it was clearly provided to the defense in advance. And what it is, it's healthcare data of the defendant's watch, and Jennifer McCabe's watch. And what it does is it tracks her heart rate from midnight all the way through the next morning. Now, although that information was available to the defense, they could have done what they wanted with it. That information was never put in a PowerPoint presentation. I will not and do not expect Trooper Garino to talk about it during his testimony. He's a witness I'm going to ask the court to recall. The reason I turned that over was to be transparent and to be collegial. We would not introduce it on direct, but as Your Honor ordered, there was an order not to get into third-party culprit evidence. Jennifer McCabe was never identified as a third-party culprit, yet in the opening, the defense suggested something about 227. If the defense is to cross-examine or suggest that a phone call occurred at 227, this would be to rebut that information. I could have waited until after the cross-examination and then sprung this as a surprise upon the defense because it is powerful evidence showing her heart rate is inconsistent with being in a criminal conspiracy, yet we provided it in advance so they'd have notice days before Trooper Garino would even testify about it.
So the PowerPoints that were provided last night, you don't intend to use either one of those in your?
The presentation I would regarding the text messages and phone calls. At the last trial, Trooper Garino read the text messages from the screen, and at the same time, he would look at the phone calls and he would go back and forth between the papers. This is simply putting the phone calls with the text messages in the chronological order so that on the screen, rather than read text messages and then refer to the phone calls and state there was a phone call, it can simply be shown on the screen.
What do you say about that, Ms. Little? It's content you had, it's messages that came in at the last trial.
The problem, Your Honor, is this is not from a Cellbrite report. It's been individually.
I need to see it. I need to take a look at this. Do you have an extra copy for me, Mr. Brennan?
I can provide a copy, Your Honor.
So Trooper Garino is not going to be your next witness after Ms. Roberts, is he?
It's going to be Peggy O'Keefe, and then it would be Trooper Garino. As I said, I can recall him, and I expect to because there's a number of other events. If it becomes an issue, him to authenticate the phones that we'll need for our further witnesses, which is Ian Whiffen and Jessica Hyde, and then I can simply recall him. I don't need to read these to the jury today. But there's nothing new in it. There's nothing surprising, but I will make this as easy as possible for
All
everybody.
right, I'd like to be able to take a look at this. I'd like the defense to take a look at it. You're right, Ms. Little, you're entitled to be able to spend some time looking at what the Commonwealth intends to put into evidence today. So, yeah, so I just took, I guess, Mr. Lally's copy. So if you can get me, Mr. Clerk, would you give this back to Mr. Lally? If you can get me another copy today, that would be great.
He's really being called to authenticate documents.
Okay.
The defense may have other plans for him. There's no need to introduce any of this today through Trooper Garino.
Okay.
He will be not only a fact witness for downloading and authenticating, but he is essentially our reader. I can bring him back today. I can bring him back in 2 days. It really doesn't matter. I don't want to deprive the defense of time to review.
Okay.
And so whatever is the time they need, I'll defer.
Okay. So that's what we're going to do.
Thank you.
All right. And Ms. Little, if you can take a look at them by tomorrow and let me know if you have any objections tomorrow. Does that give you enough time?
Yes, thank you.
Okay. All right. Was there anything else before we started?
Not for the Commonwealth. Thank you.
All right.
Your Honor, I did email Mr. McDermott yesterday evening. We did speak with Dr. Wolf yesterday, and he is not available on Friday. Is there another day that works for the court reasonably soon that we can have him come in?
We could do it tomorrow afternoon if tomorrow is a better day for him. Yeah, they're just in Pennsylvania, right?
Could we do a Zoom hearing tomorrow?
No, he needs to be here in person. Mr. Alessi, I issued an order late yesterday. You were the one yesterday talking about this voir dire. I assume that you folks provided that order to the ARCA witnesses. We don't have an address to serve them. We don't have enough time.
I provided a copy.
All right, so we could do tomorrow afternoon.
We have to make travel arrangements for them to get here. Yes. And that's, he has a conflict that begins on Thursday and goes until Friday. And so is there a day next week that works for the court?
Well, we could do Monday, but what I'm going to order is if it's continued all the way until Monday, the testing that he outlined that you were contemplating or were going to do, that has to be done by then. So we can do it Monday, but that testing has to be done by then.
We'll make every effort to make that happen. I don't have a status on some of the shipping components that they need for the testing.
Okay.
So I think we'll do the best.
All right. So that'll be done by Monday. We'll do this Monday. I don't want to devote a whole day where, I mean, Friday was easy to devote a whole day because the jury thought they were only going to be here a half a day. Can we do this just in the afternoon?
Your Honor, I am unclear as to what the subject matter of the voir dire is going to be.
So I am indifferent to this voir dire. All right. I'm trying to help you out by having the witnesses here because I found a violation of your reciprocal discovery. So I don't know how long this is going to go. I would assume I'm giving you the opportunity to put them on and the Commonwealth an opportunity to cross-examine them.
First, in terms of time, we can do it within a half a day.
All right. Do you agree with that, Mr. Brennan?
Regarding an afternoon voir dire of ARCA on Monday,
Yes.
we'll defer to the court whenever is available.
I mean, I'd like to keep the testimony going. I've already told the jurors that they have a half a day Friday. So Friday we'll be back to where we were at the half a day.
Will we have a chance to be heard on rulings regarding ARCA? Because I still have the same concern about new information.
Yes. What do you mean? When?
Whenever it's convenient for the court, but I have concerns about these witnesses bringing in new opinions that we will not have an opportunity to consider.
All right. Can we do that the day of the voir dire?
Whenever it's good for the court.
All right. So maybe we'll break with the jury at 12 on Monday. Now they're going to have 2 half days in a row, but we'll break.
Will we still do the voir dire and I'll have witness testimony prepared for Friday?
Yes.
Okay.
Your Honor, may I have one further follow-up question?
Yes.
Thank you. The reason I asked for, and I appreciate the opportunity for the voir dire, it's not lost on me. But what I'm trying to understand is I want to hit the target, whatever the target of the court
So
is.
one of the targets, one of the big concerns I have is that 105 or more text messages were deleted, and you said in due course. I have no idea what you mean by in due course. It's a pending case. We need to figure out, I need to figure out that at least. And there, okay.
In Your Honor, the 30-day, if you may recall, the defense had this very same issue with a matter with District Attorney Morrissey. So you said, I'm unclear what deletions are, and we're happy to have testimony, our witnesses can discuss it.
They're to bring them if they still have them.
Exactly, that is also very helpful, but this 30-day auto delete, a lot of attorneys do that. District Attorney Morrissey
So
did that.
I need something in writing about that. That's not my understanding on how you keep records in a pending case. And remember, you still said out of the blue, months later, a bill came. This gives me pause about that, frankly. Okay?
We're happy to
So-
discuss that as well, Your Honor.
All right. All right. So,
Get the clarification.
all right. And there'll be more. I'm not limiting it to that, but those are my big concerns.
Appreciate it.
All right. Are we ready to start?
Judge, I just have yeah.
So let's figure that out. Do you want to, you know what? Let's see counsel at sidebar about schedule.
All right, this is not the judge's fault, but this is starting to look like trial one, where this is going to get bogged down. This is not going to be done in 6 to 8 weeks. This trial is just not going to be. It doesn't. We're seeing how the legal system works. So we go from sidebar to sidebar, and in between, there's a little bit of a trial. Now, yesterday was much better, I admit. Yesterday, it seemed to run much smoother than the first trial. Both the entering of the evidence, good morning, Wicket, the entering of the evidence exhibits seemed to go much smoother, and obviously, a lot of this, that may be something they worked out. And then Hank Brennan is much more efficient than Adam Lowy was, so that helped. But we're falling back into this quack. So even yesterday, the trial doesn't get started on time, and it ends an hour and 15 minutes early, so they can do a voir dire. And so, no, Chick, I agree. It is mostly the defense, but I'm just saying that this is, we want to have a trial that gets done in the time that you told the jury that it'll be done. And I don't think that's going to happen.
All right. So are we ready to bring Ms. Roberts back in? I can take 5 minutes while we line the jury up if you want.
Ready, Your Honor.
Okay. All right. Do you want me to get off?
All right.
I'm back. And so is the fan. But we're going to the fan as they're bringing in the jury. So Carrie Roberts should be on the stand within 5 or 10 minutes. Carrie Roberts and Brendan Kane were on Good Morning America today. They did a great job. So we'll see today, the rumblings in the insane turtle, free Karen Reed, Glare world is that the defense is going to cross-examine Carrie Roberts. They didn't cross-examine her last time, so we'll see. But again, this is where it goes, the kind of hearings that we're hearing, the rumblings that we're hearing. Again, this defense team has no ethics at all. Is Friday half day? I'm not sure. It sounds like it was originally going to be not only a half day, but a day that we don't have to do anything in terms of streaming, because they were, or maybe just a little bit, they were going to take the jury to view the crime scene and the Lexus. And I think the judge left for the jury to enter, if I remember if that's how they do it. Thank you, Dynamite. I won't try to say your first name. Wow, that's a beautiful first name that I can't say. So then at the end of that, Hank Brennan said, well, then should we prepare to have witnesses on the stand Friday? And the judge seemed to say yes. So I think I don't know if this Friday will be a half day. My sense of it was that it won't be. But I don't know. No, actually, I take that back. I don't know. It wasn't clear. So maybe the judge is a half day on Friday, because maybe it's Monday. They're going to do witnesses in the morning and then do the voir dire in the afternoon, or vice versa. Not really sure. So maybe Friday is a half day. Personally, I kind of hope it is, for my own personal reasons, because I won't be able to be here. But Just seeing what other questions you guys might have while we're in this quick break. Oh, I got a couple of thank you. So Frank Perry, the defense thought the feds were going to hide all this information. Now, with the change at the U.S. Attorney's Office, everything is coming out. So this information, this new deleted text, really has nothing directly to do with the U.S. Attorney's Office, although that was a little bit earlier in the food chain, wherein we started to realize that there were messages. I don't know. I'm not sure what role the feds played in any of that. But basically, here, the prosecution learned of these text messages from Karen and her team, the unfettered access that Karen and her team gave that documentary. And they must have been mentioned in one of those clips in the unedited footage. And so from that, they know there were texts. And so they've asked the defense, okay, you've deleted the texts, but you can tell us how many there were because you can get those from the phone record. So they had to come clean on that because the judge could have ordered a subpoena on that. And that you'd be able to get that from the phone company. And so they didn't lie. So it was 99 texts between Dr. Wolf and the defense team. So shady. And Mark Jude, thank you for the donation. And Mark says, thanks, Kevin, for always analyzing this case with logic and clarity. So, I mean, I can't always promise logic. I try to go by that, but I can always promise fairness and truth. Fairness, truth, honesty, asking questions until you get to the truth. That's what everybody should be doing. That's what the other content creators don't do.
Before the Honorable Beverly
On the other side.
Justice of the Superior Court, now holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
22-117, the Commonwealth versus Karen Reed.
All right. Good morning again, counsel. Good morning, Ms. Reed. Good morning, jurors. Thank you for your patience. The lawyers and I got some work done this morning while you were waiting for us, and we do appreciate it. So I do have to ask you those 3 questions. Were you able to follow my instructions and refrain from discussing this case with anyone? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instruction and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or should. All right, thank you very much. Can we have Ms. Roberts back in, please?
Mr. Roberts, I'll remind you, you're still under oath. You take the stand.
Thank you. Good morning. Whenever you're ready, Mr. Brennan.
Thank you, Your Honor. Good morning, Mrs. Roberts.
Good morning.
Yesterday, you told us a little bit about when you went into John's home at Meadows to look for him.
Yes,
And I recall you said that you did not see him there.
correct.
At some point you left?
Correct.
When you went into Meadows, who did you go into Meadows with?
Karen and Jen McCabe.
Have you ever seen any video from a Ring camera depicting you and the defendant and Miss McCabe going into the home?
Yes, I have.
Your Honor, may I approach?
Yes.
Actually, I've moved to introduce a Ring video. It has certification, and then a smaller clip of that Ring video if there's no objection.
Did you say if there's no objection or there is no?
If there's no objection. There's no objection. May I introduce Your Honor?
Sure.
Exhibits 12A and 12B.
Thank you. And one final. It's a 12C would be just fine. Thank you. Your Honor, if I may note, 12A is the Ring video from 12 Meadows. 12B is the certification from Ring. And 12C is a clip of a piece, a portion of 12A.
That's accurate. Yes, thank you.
Thank you. With the court's permission, I'd like to play 12C for the jury.
Okay.
Thank you. Ms. Roberts, you've seen that video before?
Yes, I have.
Is that you and the defendant and Ms. McCabe going into Meadows?
Yes, it is.
When you came out of Meadows, did you have a chance again to look at the defendant's tail light on her Lexus?
Yes, when we left the house, she pointed it out to me.
Did you stop and get a closer look?
Yes, I did.
I want you to describe to the jury your best memory of what it looked like.
Karen pointed out and said, look, my taillight. And she said, do you think I hit him? And I said, no, I don't think you hit him. What are you talking about? Let's just go find him. But the taillight itself, the piece was missing. And as you got closer, there's a metal sort of square, and one of the pieces was sort of sticking out. And I only remember it because I thought if someone walks by that, they're going to catch their jacket on it.
How long of a time did you have to actually look at the taillight?
Under a minute.
How close were you to the taillight when you looked at it?
I was in front of it. I could see.
And when you talked about the taillight, you said a piece was missing. Is this the left side or the right side of the Lexus that you saw the piece of the taillight missing?
It was the right side, so it was the passenger taillight.
May I approach?
Yes.
Should I remain, Your Honor? Sure. Thank you. May I recognize what is in that photo?
That is Karen's SUV.
Is it similar or a fair and accurate depiction of how you saw the vehicle that morning?
Without the snow, I can't be positive, but this square piece was missing, as is in this picture.
The photograph you look at is not the car in the snow in the driveway the day you saw it.
Correct.
Putting that aside, is that a fair and accurate depiction of the damage that you saw to the right rear taillight of Ms. Reed's car that morning?
Yes.
I move to introduce this as an exhibit, please.
Any objection?
No objection. Thank you. With the court's permission, I'd like to publish Exhibit 13.
Sure.
Ms. Roberts, I'm going to ask you to take a look at the photo that you just described. Do you see the white area in that photograph?
Yes.
Is that where the taillight had missing part?
Yes.
And where was the metal in relation to that white part that you see?
If you look at the white part, it's the upper left. It's sort of like a rectangle, but it's vertical, sort of.
And that's the metal part that you were concerned about?
Yes. One of the side, it's almost like an encasement, but the right side, I think it was the right side, was sticking out a little bit, like out from the car toward me.
Did you express any concern about the metal sticking out?
Yes, because I thought at that height, it could clip someone's coat or something if they were walking by.
You mentioned the defendant asked you if you thought she hit somebody.
Correct.
How many times did she ask you that?
She asked me that in the driveway. How many times? She said, do you think I hit him? Do you think I hit him? And my answer was, no, I don't think you hit him. I'm sure you hit something because your taillight's broken, but I don't think you hit him. Why would I think that?
Did you have any reason to think at that point that she hit anybody?
No.
Did she ever repeat that phrase or question in the same or similar manner again that night?
She did at the scene where we found John,
Before or after you found John?
after we found John.
Okay, so we'll get to that then. Could we please take that picture down, Ms. Gilman? How far of a ride is it from Meadows to Fairview?
I don't know, maybe 8 minutes.
So when you left John's house at Meadows and you traveled to Fairview, you said you were driving.
Yes.
Was there any comments or conversation from the defendant on that ride?
There was talk of Bella's mom, who lived near Jen's sister. There was talk, and I said, where is Fairview? And Jen said, it's off of Chapman, so it was near Spring Lane. And I knew of somebody previously that John had dated on Spring Lane, so I brought it up thinking, could he have gone there if he was walking home? I don't know. I didn't know where he was or why he was missing.
Describe the mood in the car.
Well, it was scary driving, and Karen was, frantic, and she was yelling. I don't even remember at this point what she was yelling, but she was yelling. She had an elevated voice. She would be in between us while I was driving, and she would sit back in the back seat and be in between us.
Did you have any words with Miss Reed?
I told her to shut up several times because I was trying to drive and I couldn't concentrate. I told her to sit back and buckle up because it was bad driving. I didn't want to get into an accident and her not have a seatbelt on.
How often was the yelling on the way to Fairview?
Oh, several times. It was like you couldn't control her, and I was trying to drive in a blizzard.
You went down Spring Road before you get to Fairview?
No, Spring Lane is before Fairview off of Chapman.
And did anything remarkable happen on Spring Lane?
I'm sorry?
Anything remarkable happen on Spring Lane?
No.
More of the same?
Yes.
Now, you mentioned yesterday that when you got to Fairview, the defendant began kicking your door.
Yes.
When you looked out, you didn't see anything.
I did not.
And at some point, you ran over to where Miss Reed was.
Yes.
Tell us what your first observations are when you get close to the defendant.
Well, it was a shape of a body, like the length of a body, shape of a body. She ran over and I said, oh my God. I jumped out of the car. I ran over and she was lifting up his shirt to try and warm him, I guess. So I went over to his head and I began to dig his head out of the snow.
Can you take us back and describe for us what you're seeing?
His body was completely covered, but his head was completely covered. So I started to dig around his face and his eyes, and his left eye was fine, but his right eye looked like it was huge, like he had something happen to it. And after that, I told Karen to get off him. We were going to start CPR. I had been certified at work through the American Red Cross, so I knew chest compressions were more important. So I started to do chest compressions, and I yelled to Jen and told her to call 911. Karen was trying to do mouth to mouth. I don't know if she knew what she was doing, but I knew chest compressions were more important, so I concentrated on that. I yelled for Jen. I carry blankets. I have 2 kids, so I carried blankets in the car. So I yelled to Jen to get the blankets. I don't know what I thought I was doing with blankets, but I wrapped them around his head, just thinking we're trying to warm him up. He was covered in snow.
When you first ran over, you mentioned that his head was covered in snow. Was his head fully covered in snow?
Yes.
When you look down, could you see who it was at first?
At first, no. I had to dig him out.
When is it that you realized that this was your friend John?
When I cleared the snow off his face.
Did you feel his skin?
Did I feel what?
His skin.
Yes.
And could you tell us how it felt?
It was cold. Like he had been there in the elements for a while.
You mentioned that his head was covered with snow before you brushed off the snow. Was other parts of his body still covered in snow?
Yes.
Can you share with us what you saw?
His legs were covered. His arms were by his side. He was on his back. Karen had lifted up his shirt, so now his shirt was down, but I was doing chest compressions so you could see his clothing. He had blood coming out of his nose and his mouth. And when I put the baby blankets under the back of him, there was blood on the blanket. So I think he had a cut on the back of his head.
Was the blood from his nose and mouth frozen or running?
I don't think it was running. It was not gushing.
You said that you brushed off the snow from John's face.
Yes.
Did you brush it off from both sides?
Yes.
Did you brush it off to the extent that you uncovered his entire face and head?
Yes.
So did you have gloves on?
No.
Bare hands?
Yes.
And that's how you felt the temperature of his skin?
Yes.
When you brushed off both sides of his face, did you ever feel any pieces of glass sticking out of his face?
No.
Did you ever see any pieces of glass sticking out of his face?
I did not.
How long did you give chest compressions for to Mr. O'Keefe?
Oh, I can't be sure. I would say 4 minutes, 5 minutes while we were waiting for the EMTs. I had Jen take over at one point. And then the EMTs came. So however long it took for them to get to us, 6 minutes.
When you were trying to save your friend John, did the defendant say anything?
She was just running around screaming, Carrie, Carrie, Jen, Carrie, Jen.
Was anything said at that point about her taillight?
About what?
Her taillight.
No, when the EMTs were around and they were working on the body, she was running around and saying, did I hit him? Did I hit him? Is he dead? Is he dead?
When you were waiting for the police and EMTs, just briefly, what was the temperature like and the visibility like?
The temperature was freezing because I remember at one point I couldn't feel my knees, which is why I had Jen take over. And the wind was still whipping and the snow was still coming down.
At some point, did help arrive?
Yes, they did.
And when help arrived, what did you do?
I stood back and watched them work on him.
Did you see first responders trying to give first aid to Mr. O'Keefe?
Yes.
How long were you outside for that morning?
At that point?
Well, the entire morning.
Oh, maybe a half hour.
When the first responders were trying to save John, what else were you doing?
I was calling my husband. I called my mother. When they put him in the back of the ambulance, I then made a call to Mrs. O'Keefe. I think I called Mr. O'Keefe first, but he didn't answer. So I called Mrs. O'Keefe and told her John had been in an accident. And she screamed, I can't do this again.
What did you do after that phone call?
The police put Jen and Karen in the back of a cruiser. And I was looking in the ambulance to see what was going on with my friend. So I was standing outside of the cruiser. They were inside. I was standing outside just watching. And Karen was saying, is he dead? Is he dead? Is he dead? And I said, no, they're working on him. I can see tubes moving. I can see them moving. Something, if he was dead, they wouldn't be working on him. She grabbed the front of my shirt and said, are they working on him? And I said, yes, they're working on him. At this point, I think I was in shock. I didn't know what was going on. I didn't think he was dead. I thought they could save him. I knew he was in the ambulance with the EMTs. And I was just hopeful that they were going to be able to do more than I could.
You said that at one point, Ms. McCabe and the defendant were in a car, and then you mentioned at some point the defendant grabbed you. Did she grab you when she was in the car or out of the car?
She was in the car. I was outside of the car.
At some point, did the defendant, Ms. McCabe, get out of the car?
Yes.
Did you go over to the ambulance before it left?
Did I go over to the ambulance?
Before it left?
No.
Did you watch?
Yes.
At some point, did you see the defendant get out of the car, the police cruiser?
No, I didn't see them get out, but they were out at one point.
They were what?
They were out of the vehicle, but I didn't watch them get out. I was watching the ambulance.
At some point, you saw them out?
Yes.
And were they near you when you were watching the ambulance?
Did what?
Were they near you when you were watching the ambulance?
I don't know. I wasn't concentrating on either one of them. I was concentrating on my friend in the ambulance.
When you were trying to save Mr. O'Keefe, did you ever see any signs of life?
I did not. And I checked his pulse. No, I did not.
After the ambulance took John to the hospital, tell us what you do next.
I left. I told Mrs. O'Keefe, I said, I'm going to come get you. She said, well, I'm going to have Braintree Police take me to the hospital, which was in Brockton. And I said, they're not going to take you to Brockton. I will come get you because neither of their cars had four-wheel drive. So I asked if I could leave, and they said, give me your number and we'll follow up with you. And I took Karen with me. We drove down the street. At some point, she was on the phone with Erin O'Keefe, John's sister-in-law, and Karen was saying, I think he's dead. I think he's dead. I grabbed the phone and I said, I don't think he's dead. He's in an ambulance. He's been in an accident. At this point, I didn't know what was going to happen. At some point in the car, as we're driving, she was on the phone with her mother. And I think when we were driving, we got all the way to the elementary school. And Karen said to me, if anything happens to John, I'm going to kill myself. You're going to have to take care of the kids. And I said, nobody's dying. Nobody's killing themselves. Let's not think about that. And then one of the officers called me and said, do you have Karen Reed with you? And I said, yes. And he said, could you please turn around and bring her back? Her parents are saying that she's suicidal, so we're going to take her to the hospital and section her. I said, okay. I didn't get far, so I turned around, went back. At some point, she was on the phone with her mother, and I got on the phone with her mother and said, I'm going to be heading to the hospital. Let me give you my phone number. It's the same hospital John's at. I'm assuming they're going to the same. That's where Canton takes everybody. And her mother said, please make sure that they don't let her have her bag. There are things in her bag, medicine I don't want her to have. So I said, okay, I will. So we got back to the house, and she got in the ambulance, and one of the EMTs asked me for her phone. So I handed that over, and I said, the mother wants to make sure that she does not have her purse because there's medication in there that they don't want her to have.
Did you see the defendant leave with medical personnel?
Yes, I did.
Before we move forward, I want to step back for just a moment. Did you see when the medical personnel, the first responders, lifted John from the ground and then put him on a bed?
Yes.
Shortly after they moved John from the ground and brought him to the bed to bring him to the ambulance, did you go back to where John lay when you first saw him?
Yes, I did.
Why did you go back to the spot where John was lying when you first saw him?
When they lifted him up, there was grass underneath him, and I could see his phone. So I went over and picked up the phone and the two baby blankets that were left on the ground.
So let me ask you, when you went back to where John was lying on the ground, you said you saw grass. There was not snow under him?
No, there was not.
Was there many inches of snow around that area?
Yes.
But none where he was lying under him? You said you picked up a couple of items?
Yes.
Could you repeat that again, what you picked up?
I picked up John's phone and two blankets, the blankets that I had Jen get out of the car.
What did you do with John's phone when you picked it up from the ground?
I put it in my pocket and gave it to a first responder when they came over, or I handed it off to a first responder.
And the blankets you picked up, were they in the ground area or on snow as well?
They were, I don't remember.
Okay. How long after you put the phone in your pocket, do you remember when you gave it to a first responder, how long you had it for?
I don't remember.
Do you remember the time that you picked up the phone?
I do not.
Have you seen video of that event?
Yes.
And does that video have times when you went over and picked up that phone?
Yes, but I don't remember, somewhere around 6:12, 6:19.
And you don't know how long you kept it in your pocket before until you gave it to a first responder?
I do not.
At some point, did you get in your car during that morning before you left and drove from the scene?
Yes.
Do you know if John's phone was still in your pocket when you first got into your car?
I don't know.
Was your car heated that morning? Did you keep it
Yes.
running?
Yes.
And was the
I
heat
I
on?
think I
and-
kept it running the whole time. I don't even think I shut it off.
I see. I want to now step forward to where you left us when you said that you had spoken to John's mother, Peggy. And did you decide what you were going to do next?
After I dropped Karen back off at 34 Fairview to get in the ambulance, I then made my way to Braintree, barely. I was on the highway. I was the only one on the highway. I spun out a couple times.
Can you
right
describe
near-
what you mean by spun out?
Well, the driving was, no one else was on the road. The driving was horrible. So I spun out almost at the Braintree exit to get to their house. And then I got to the O'Keefe's house and I said, we are not taking the highway back to Brockton. We're going back roads, which is a much longer way, but there was no way I was putting us in the car and that treacherous.
When you went to the O'Keefe's house, you mean Peggy O'Keefe and John O'Keefe Sr.'s house?
Yes, John's parents.
That's different than Meadows Road.
Correct.
When you got to their home, did you go in?
Yes, for a second. They were ready and waiting for me. They wanted to get to the hospital.
When you say they, can you tell us who was waiting for you?
John's parents, Mr. and Mrs. O'Keefe, were waiting.
What happens next?
Mr. O'Keefe said something about a Dr. Rice and that they were trying to warm John up. We got into the car. Mr. O'Keefe got in my passenger seat. Mrs. O'Keefe got in the back seat. Mrs. O'Keefe's niece worked at Good Samaritan, so we were trying to get in touch with her to see if we were going to be allowed in because there was still COVID restrictions. John's brother was already on his way there. And Mr. O'Keefe at some point said, "He's gone, Peg." And he slammed his hands on the dashboard. But they didn't actually know if he was gone yet. At one point, Karen called me from the ambulance. And on the phone, Mrs. O'Keefe said, "Karen, what happened?" And she said, "I left him at a party." And Mrs. O'Keefe said, "And you just left him?" And Mr. O'Keefe said, "All right, that's enough. She's been through enough." Then we hung up with her. I said, "We're on our way to the hospital."
Let me ask you a question. When the defendant said that she left him, did she say whether she left him outside or inside?
No,
Was the question, follow-up question, never asked?
no.
Was there any other conversation with the defendant at that point?
Not in the car, but when I got to the hospital, she called me multiple times from the hospital room.
We'll get to that.
Okay.
How long did it take for you and the O'Keefes to get to the hospital?
I would say maybe 45 minutes to an hour.
Share with us the mood in that car.
I think I was in shock, and I think they were in shock. There wasn't, other than talking to Mrs. O'Keefe's niece, trying to find out if we could go in for COVID reasons, there wasn't much talk.
When you finally get to the hospital, take us through your first steps. What happens?
We finally get to the hospital. We walked in. Paul, John's brother, was there. We went over to him, and then Susanna, Mrs. O'Keefe's niece, came out from her office and offered to take me to the bathroom to wash up because I had blood all over my hands. So I went into the bathroom and I asked her afterwards if she could take me to the chapel so I could say a prayer. So she did. She took me to the chapel. And then when I came out, she took me into her office and explained to me that a Dr. Rice was going to come talk to the family and take him into an office and talk to the family. And then the family would be able to go see John.
Did you get a chance to see John?
I did.
Would you be willing to tell us a little bit about what you saw?
I waited in the waiting area. I spoke to my mom. Phone calls were coming in because people had heard what happened. And Mrs. O'Keefe, the family went in to see Dr. Rice. I watched them go in. I watched them walk down a hallway. And then when they came back out, Mrs. O'Keefe told me he was gone.
Strike that statement.
Without telling us what anybody said to you, please just share with us what you saw.
I went into the hospital room, and John was in a neck brace. At this point, there was a trail of blood going toward the gurney or the bed that he was on. This time, both eyes were filled with blood. They looked like raccoons. That's the only way to describe it. I thought he was going to look better seeing him in the hospital because he had been worked on, but he was not. There was much more blood.
Were there any other ways that John looked different in the hospital than when you first brushed the snow off his face in the front of Fairview?
When I brushed the snow off his face, his left eye was fine. It had an ice cube on it that I pulled off, but the right eye was out to here, like a golf ball. When I got to the hospital, both eyes were swollen with, it looked like blood. They looked purple.
Your Honor, may I approach?
Yes.
May I quickly approach sidebar?
Okay.
With the court's permission, may I approach? Ms.
Yes.
Thompson? Thank you. I'm going to show you a photograph.
Yeah.
Do you recognize it?
Yes, I do.
Is that how John looked?
Yes, he did.
I asked that the camera not film that, please.
I'd like to mark this as an exhibit. I will not publish it. May I approach her?
Yes.
Thank you.
Are you ready?
Yeah.
After you last saw your friend John, what did you do?
After the hospital?
I'm sorry, ma'am?
After the hospital,
Yes.
I drove. Well, we went back into the corridor with the family. And Karen at one point called from the hospital asking me, she said her father was on his way and could I go over and greet him or bring him to the O'Keefes when he arrived? And she described him. Her father did arrive, so I went over and said, "Are you Mr. Reed?" or something of that nature. And I said, "Mr. O'Keefe would like to speak to you." So Mr. Reed went over and spoke to Mr. O'Keefe. And Paul and John's parents and I, we didn't know next steps. We were waiting to see if we could leave or if we have to give information. And eventually we were able to leave. So I drove Mr. O'Keefe home and Paul drove Mrs. O'Keefe home to John's house.
Before you left John, did you take a bracelet from him?
When Mrs. O'Keefe and I went in to see John in the hospital. There was a bracelet that was on his right wrist. It was a blue, like rubber bracelet. And that bracelet was made when his sister passed away, and her husband, and he wore it all the time. Mrs. O'Keefe still wears it to this day.
Did you drive the O'Keefe back to their home?
I drove Mr. O'Keefe back to John's house, and Paul drove Mrs. O'Keefe back to John's house.
You went back to John's house on Meadow.
Yes.
When you arrived at Meadow with Mrs. O'Keefe, did you go in?
I arrived with Mr. O'Keefe, and no, I did not go in.
What did you do next?
I went home.
At some point after you went home, did you return to the O'Keefe residence or Meadows?
Not that day. The next day I did.
Where did you go?
Where did I go?
Yes.
I went to go to see the family the next day.
And where were they?
They were at John's house at Meadows.
So they were then staying at John's house at Meadows?
Yes.
Did you go in and visit them?
Yes, I did.
Why did you do that?
Because my friend had just died and I wanted to be with the family.
Were there other people that were coming and going?
Yes.
Describe the level of traffic of people coming and going to Meadows that next day.
There were people coming from all over. John's friends, people from Canton, people we went to high school with. There was people coming in and out, dropping off food.
When you were there the next day, how long did you stay for?
Several hours. Maybe like 2.5, 3 hours.
Did you ever see the defendant there?
I did not.
Now, you told us that you had only met Miss McCabe once before that night.
Yes.
And after that night, shortly after what happened, did you speak to Miss McCabe again?
Yes.
How often?
Very often. We wanted to know what happened to our friend, so she would call me.
I'm going to allow that. Not what you said. Next question, please.
Would you speak to her on the phone often,
Yes.
regularly?
Yes.
And so things changed
Yes.
after that moment.
Yes.
Did you start to see her in person,
Yes.
spend time with her?
Yes.
For somebody who was not your friend, why did you, at this point, form this close bond?
I think because we went through something horrific together. We bonded over it. Mrs. O'Keefe at one point did say, you two need to sit.
Did you ever write down a list of things that had happened to try to remember?
Yes.
When you were spending time with Miss McCabe, did you become friendly?
Yes.
Friends?
Yes.
How close of friends did you become
She to this day is a close friend of mine.
to this day?
Yes.
When you were at the scene, when you were trying to help John, there were police officers and first responders?
Yes.
Now, you're from that area,
Well, yes. I'm from Canton, but not that side of town.
and you are active in the community at all?
Yes.
Sports, children?
Yes. Yes.
Do you know a lot of people from Canton?
Yes.
Did you know any first responders?
Yes.
Who did you know that you saw that night as a first responder?
That morning.
Yes, I'm sorry, that morning.
Mike Lank is my friend's daughter's father. No, my daughter's friend's father. I'm sorry.
Your daughter's friend's father. And
Yes.
does he have children that are friends with your daughter?
Yes, his daughter is friends with my daughter.
How close are his daughter and your daughter?
There's a group of 5 or 6 of them that are best friends.
Are you on a first name basis with Mr. Lank?
Yes,
When you saw him that morning, did you recognize him?
I did.
Did you speak to him?
I said, Mike, is that you? He said, yes. That was it.
Are you friends with Mr. Lank's wife?
I am.
How often had you been to their house with the children or on your own before that day, before that morning when you found John?
Well, often when the kids can't drive. So when they do sleepovers or whatever, you drop them off, pick them up.
Your children would sleep over each other's house?
Yes,
So you had a friendly relationship with Mr. Lang before you found John?
yes.
And do you continue to have a friendly relationship with him?
Did what?
Do you continue to have a friendly relationship with him?
Yes,
Did you go to his house the day after you found John?
I did.
Who were you with?
Well, Jen and I had gone to the O'Keefe's house together with, I don't know if it was one or two of her daughters and both of my kids. And then when we were leaving, my daughter said, "Can you drop me off at Mike Lank's daughter's house?" So I dropped her off.
And did you do that? You dropped her off?
Yes, I did.
When you dropped her off at the Lank house, did you speak to anybody?
His wife came out and got into the back seat just to find out how I was and how the O'Keefes were and
How were you?
how were they?
How were you?
Oh, I was not well.
And did you have a long conversation with Mr. Lank's wife?
Yes,
Was Miss McCabe with you?
yes,
After you left the Lank house, you left your daughter at the house?
yes,
You remained in the car?
yes.
At some point, did you speak to Mr. Lank's wife again?
Yes,
Are you friendly with her?
yes.
Did you ever try to get inside information about this case?
No,
After this case began, did you ever come to court?
did I ever come to where?
To court.
Yes,
And what was the reason you came to court?
to support the O'Keefe family.
At some point, did you stop coming to court? And
I
don't answer just yes or no.
Yes,
Okay. Were you aware or watching about any type of news or publication on this?
yes,
As you were watching and learning information, did you begin to contact people at the district attorney's office?
yes, I did.
Did that include victim witness advocates?
Yes,
Did it include law enforcement assigned to the case?
Objection.
The form of the question, I'm sustaining the objection.
Who did you contact?
specific names?
Yeah.
Steve Nelson, my victim advocate, Yuri Buchanan, who was a state trooper, and at one point I contacted Michael Morrissey's office.
Do you remember at any time being interviewed by police officers or state police about this case?
At my house on January 29th.
So that same day you found John, you were interviewed?
Yes,
Do you remember who interviewed you?
I do not.
Do you remember your mental state at that time?
I was not well. It was in the evening at some point.
Were you interviewed at a later time by any other law enforcement?
Yes,
Okay, and where were you at that next interview?
I think I was at Jen's house. We were making a timeline together when two law enforcement showed up to question her. But I happened to be there, so they took us in separate rooms and questioned both of us.
Were you sober at that point?
Yes.
And what was your mental state then?
Still, we hadn't even had a funeral. So I was still, I couldn't believe what was happening.
And after John's passing, did you still continue to help out with the children?
Yes.
With the court's permission, I would like to play an exhibit that's already in evidence.
Okay.
It's Exhibit 4.
Right.
Before you start it, ma'am, I'm going to show you a video from the scene that night, okay? Ms. Gilman, is this sound? Thank you. Could we start at 6:09:50, please? Could you stop there, please? Ms. Roberts, do you see yourself in that video?
Yes,
And where were you in that video?
I'm over near the flagpole.
What were you doing in that video before you stood up?
I think I was picking up the phone and the blankets at that point.
You see the first responders getting there?
Yes.
Okay. Continue, please. Is that you with the fur on the hood?
Yes.
That's you in the middle of the street?
Yes, I'm to the right of the car.
Could you stop for one moment, please? Ma'am, you see the other two people in the middle of the screen right now? Do you know who they are?
That's Karen and Jen McCabe.
Do you see the proximity or the closeness between them?
Yes.
You are not close to Jen McCabe in this video.
No,
Is there a reason why?
I didn't really know her. And Karen was running around like you saw. I didn't want to be near her. I just found my friend.
Okay. Could you continue, please, to 6:15? You can let it run, please. Stop, please. Thank you. Ms. Roberts, is this when the first responders were moving John from where he was laying?
Yes.
Please continue. Could you continue to watch the area near the flagpole, please?
Oh.
Stop, please. That last 15 or 20 seconds of video, did you pay attention to that, Ms. Roberts?
Yes, that was the moment that I picked up the phone and blankets, not before. I don't know what I was doing before when you asked me.
And that location where you picked up the phone and blankets, was that where John was lying?
Yes, it was.
And is that where you saw the ground that did not have snow?
Yes, it was.
At that point, had you put the cell phone in your pocket?
Yes.
If there's no objection with the court's permission, I'd like to watch a little more of the film, but if we can double speed it, so we get an opportunity to view it. I want to get to another moment in it.
Okay, any objection?
No objection.
Thank you.
Around 16, 17 would be fine, Ms. Gilman. Stop, please. The person in the blue jacket, do you know who that is on the right side of the screen?
That's Jen McCabe.
And well, you can't see you now. Do you know where you are at this point?
I don't know where I am.
Continue, please. What are you doing, Ms. Roberts?
Cleaning off my car.
Could you please stop? Did you mention at some point you went back and the defendant, Ms. McCabe, were in a car?
They were in a police car at some point.
Did you do anything with them when they were in that car?
At one point, Karen asked us to say a prayer, to pray. So we said a prayer.
Was it before or after this moment on the video? Do you know?
I don't know.
Okay. If you could continue, please. Stop, please, just for a moment. Do you know where you are at this point, Ms. Roberts?
No.
Okay. If you can continue, please. Was that you walking by, Ms. Roberts?
Yes, it was.
Note the time is 6:21:22. Do you know where you walked?
No, I
Are
do
you
not.
behind this car, this dash cam view?
Say that again?
Are you behind the view of the dash cam?
I think it looks like I went over to the right of the vehicle.
Okay. Stop, please. This is, for the record, 6:23:08. At 6:23:08, are you still beside or behind the view of this car?
I believe so.
And do you know where Ms. McCabe is at this point,
No,
or the defendant?
no.
Please continue. Ms. Gilman, when it reaches 6:24:18, if you would stop again. At this time, 6:24:18, are you within view of this camera angle?
No,
Where do you think you are in relation to this camera angle at this point?
I'm still either to the right or behind the dash camera.
And do you see the defendant or Ms. McCabe in this view?
No,
And this is at 6:24:18. Could you continue to 6:26:25, Ms. Gilman? Did you notice the first person that came from the right and the second person that are not law enforcement?
That was myself, and I think that's Jen McCabe.
62625. Continue, please. And do you know who that is on the right with the police officer?
That was Karen.
Do you know where the cell phone is at this point, Mr. O'Keefe's cell phone?
I don't know. I could have handed it to a first responder at this point, or it could still be in my pocket. I'm not sure.
Ms. Gilman, if you could next stop at 63448. Was that you walking by in the street?
Yes.
Do you know who you're speaking with?
I don't know.
Mr. Brennan, at this point, can we pause this and take our morning recess, please?
Yes, Your Honor, pause, please. Thank you.
Folks, why don't we take 15, 20 minutes?
Court, all right, please. Jurors, close your notebooks, leave them on the chairs, and follow me.
You are muted.
All right, so the morning recess is coming early. Perhaps the juror or the judge has to use the bathroom. Normally, the recess comes at 11. Now, I noticed something interesting there in that film that I never noticed before. Gonna run it by you guys, see what you think. I'm hesitant to bring it up, but it looks to me, again, it's a little dark, but where John seemed to be found was a little bit different than what I had thought. He's actually seems from, and now it could be a trick of the angle from the dash cam, but he looks to be actually past the flagpole. Not only past the flagpole, obviously towards the street, we knew that. I mean, towards the driveway. But he looks like he's actually somewhat past the flagpole towards the house. And that's what I was thinking as I was watching it. Maybe I didn't have it on big screen when I watched it in the first trial. I don't know. But that's what it looked like to me. And so then I wanted to see where will Carrie Roberts be when she goes back to pick up the phone. And when she goes to pick up that phone, she picks it up from right next to the flagpole. Now, remember, they've said that that phone fell out of John's back pocket, and they have evidence that he put it there or stored it there normally because he put it there. I guess it's visible, him putting it there in the waterfall video. So if John went past the flagpole at an angle and ended up somewhat deeper into the yard, this would mean, obviously, more trivially, it means. So John had been described as being found, I think, 6 to 8 feet or 7 feet from the street. And when you go and look at the house, the flagpole is not, I think the flagpole is maybe 4 or 5 feet from the street. Good morning, Jen.
Good morning. How are you, Kevin?
Thanks for being here. Were you hearing the thought process of what I was just going through? I just want to finish my thought and see, and if you heard it, see what you think of it.
Please do.
All right. So looking at that video for the first time, I noticed that where they seemed to be working on John, where he was found, was closer, is past the flagpole towards the house. So not just past the flagpole towards the driveway, but also further from the street towards the house, which would actually be, so they've always said that he was found, I think they've said 6 or 7 or 8 feet from the street, right? And the flagpole looks to me like it's only about 4 feet. I've never measured it. So I always thought that maybe the issue was they had a false sense of where the street was because it had only been plowed up the middle of the street. So they had a false sense of where the curb was. But now I'm wondering if he actually was further deeper onto the lawn than I thought. And when I looked at Carrie Roberts, she went back and picked up the cell phone, which presumably came out of John's back pocket right next to the flagpole. And what that's just to me, the possibility, no one know you think about it, that John struck his head on the flagpole.
Huh. Interesting. Interesting. I've never thought about it, that was a possibility, but I see what you're saying. We are seeing so much more footage. I mean, Brennan really wants these jurors to get the full feel. And I'm going to now have to really review and look at it in that light. That ground would have been so very frozen and not packed with snow when the event occurred. And I know they're going to, I believe, have an expert talk about that, right? We've got the weather person. But that brings up a very interesting question. I'm going to have to relook at that.
Yeah, you'll have to. The only way to really think about it is to look at the video. So thank you, Nicole, just sent me a picture. But the problem with this picture, Nicole, is that it doesn't show the flagpole, I don't think. So We need a picture that actually shows the flagpole. This just shows the area where John was found and where he was found, and she's got it circled, but I don't really see the flagpole in this picture. I don't know. It's just an idea. I'm not saying it's correct. I'm not saying that John didn't injure his head on the ground, as the experts say. They're experts. I'm not. But it just presents a possibility to me that maybe they didn't think of it. If you went by, we'd have to look and see where the actual the estimation of the area of impact was as identified by Trooper Paul, and see if there's a straight angle from that to where John was that where his head could have hit the flagpole.
Yeah, I'm just trying to picture it, and I think also it'll depend what the medical doctors say. I mean, we heard in the first trial they were so wishy-washy, really.
Yeah, I had to go by her. Yeah.
It could have been Colonel Mustard with the candlestick.
Right.
According to her. So, but that's interesting. I've always believed it was the ground based on where he was found.
Susan Vaughn says it was reported that he was found 9 feet from the shoe, but we don't know if that was also at an angle too. It probably would have been at an angle because the shoe would have been knocked out of his shoe. So that doesn't mean that John was found 9 feet from the street. It means he was found 9 feet from his shoe at an angle. Good point, though. Thank you. It just we'd have to calculate. That doesn't tell us the distance from the street. So Jen D points out that Hank Brennan today made a point of asking Carrie, was there any glass on John's face? Obviously, keep thinking of Karen, what she said I forget if she said that in the documentary. And obviously, Carrie said no. And
Right.
Carrie was the one that cleaned off John's face. Karen's reaction was to take off John's shirt and lie on him to warm him up. And if Carrie's memory is accurate, she is saying that Karen basically left John's face covered in snow, and Carrie got there a moment later and started wiping the snow off his face. So she was the first to really see his face.
Well, remember, Carrie testified that she didn't know who it was until she cleared the face.
Yeah.
But Karen, this brings up the point, Karen knew who it was. She absolutely knew who it was. Even though you couldn't see a face, she knew. And so she ran and lifted his shirt and tried to warm him. She didn't need to see the face to know who it was. Right.
And people like Turtle Boy were trying to say yesterday, well, if that phone was outside, it would not have been the temperature that it was when it was later found. As though they don't understand that John's body temperature was 81 degrees when he was found. So that's cold for a human being. That's hypothermic for a human being. But it's still 81 degrees. If you're 81 degrees in your house, that's when you turn on your air conditioner. So that kind of body heat lying on top of a phone is going to protect it from the weather.
Absolutely. I believe it was 80.1, but nevertheless, about 80 to 81 degrees.
Yeah.
And that is completely hypothermic. Anyone who has a temperature below 82 degrees, I mean, you're going to die. That is just absolutely hypothermic, at the point of death, essentially.
Right. Human normal body temperature is 98.6, right? But 81 or 80 is still plenty warm enough to keep a phone from becoming 20 degrees.
Absolutely. And the body doesn't instantly dissipate all of its heat.
Right, exactly. It's a very slow and well-defined rate. So exactly that. So maybe a couple hours earlier, John was in great danger, but I don't know what temperature is officially hypothermic, but so you're in grave danger if you're 90. But that's still plenty warm enough.
Yeah, absolutely. And that's what we've always said, why that phone was warmer. He kept it warm and insulated.
Did you get to see any of the hearing today? I know you were on Court TV until 10, right? So.
Yeah, no, I was watching. Julie and I were watching, and yes, I was able to see all of it, really.
Oh, okay. You guys, so that she's like covering it on breaks there or on sidebars and stuff like that, same as we do here?
Yes, that's exactly how she's doing it. She really likes to get all of the testimony in because, quite honestly, that's what people want to see. They want to see and decide for themselves what's being said. And so just in regard to sidebars or particular things we say, we discuss just like you and I are doing.
Tib 333 says temps below 95 is hypothermic. So thank you.
Yeah, absolutely. I mean, it's a high temperature that's hypothermic. I mean, for the body to be able to function.
Right. Right. What do you think so far of the performance of, well, I don't think I talked to you after the trial yesterday. So there's a lot to go over. What did you think yesterday of the opening statements? What did you think of Hank Brennan's performance and Jackson's performance? And then we also have the voir dire coming up in the ARCA stuff.
Right. So right out of the gate, I think Hank Brennan did an A job, particularly compared to last year's opening statement that put everybody to sleep. That was more like an encyclopedia recitation of what happened. Hank Brennan was engaging. He didn't use his notes. He walked around and used the courtroom. Great eye contact, great memory, even precise details of dates or not dates, but of times and incidents. I loved how he infused what I call the most important information, and that is the information that's digital and from the vehicle, because that can't lie. You know, anybody on the stand, you know, the jury's going to be able to decide how important their testimony is, but when it's evidence from, you know, that's on paper, it doesn't speak, it tells the truth on its own. So I like how.
And let me just respond to that real quickly too, as just as an addition to that. So people from the Free Care and Read say, well, how come some data you believe and some data you don't? Well, data does come in a lot of different varieties. And so, for instance, your phone bill that tells you who you called yesterday, that's data, and that's very lock solid data. But other data, other types of data is interpretive. So your health app trying to figure out whether you're water skiing or going down a fire pole or roofing or walking up and down stairs, it doesn't know what you're doing. It's interpretive. So there's different types of data. But I'm sorry, go ahead.
No, I totally agree with you. So I was impressed. Look, when it comes to Alan Jackson's opening, he is so engaging because he's charismatic. I mean, he would be a maestro in an orchestra, you know, the leader in a circus. I mean, he's just a maestro. He's engaging. But when you broke down, and I'm sure you did, I broke down, there were so many untruths he told. Even talking about the 227 timestamp, really inferring multiple individuals, including Jen McCabe was a third-party culprit, which they were supposed to stay away from. Talking about the dog, you know, purportedly they were told to stay away from that, but they sure didn't. They brought up what they thought on the opening, and it just, when you break down what he says it so well, but when you look at it, you're just boggled by the fact he can misrepresent.
Yeah, and he also doesn't miss a legal trick. So he used that yesterday, what was in the opening statement, despite the fact that they weren't supposed to talk about third-party culprit, as a way of getting in a new exhibit today, which wasn't, it doesn't have any new information on it, but he's going to exploit every opportunity. So that's probably the difference between a seasoned defense lawyer who's used to looking for every angle as to a prosecutor, which especially these prosecutors, they're handling a bunch of cases. They're not generally going to be that kind of level of thoroughness.
Yeah, so that was the opening. I want to digress if we can and go back to the deal with ARCA. I mean, the bottom line is ARCA has been found, the whole situation with ARCA, they've been found to have lied. The word she's used was lack of candor. That is a government use word. We use it in the FBI. When somebody is found lack of candor, that means you lie. There's no difference. It's no parsing of words. It's just a more eloquent way to say it. So now look at this, all these text messages. First I saw 99, then Julie reported 105.
It was, I think, like it is 99, but it's combined. It was like 99 to Dr. Wolf, and then another maybe 6 to Dr. Rentschler. So combined, it was 105 or something like that. So.
Okay. Nevertheless, I mean, this is going to be the big problem for them. And I I'm enjoying how Judge Canoni, who is such a defense judge, right? She was a defense attorney, that's her career, and she's such a defense judge, is sort of working them and letting them paint themselves in a corner. You know, we're going to have this voir dire, and it's going to be big because, in my opinion, both ARCA experts lied on the stand because multiple times they were asked, this is the first time we're talking, right? This is the first time we've discussed this. You're not working for us, right? And or words to that effect. And each time they said yes. They said yes. They agreed with Jackson. That is a huge problem. I would be shaking in my boots as an expert if all of this happened. I literally, personally, I wouldn't testify. I would tell the defense, I would say, listen, I don't care how much you're going to pay me. I don't care if you're going to pay me $20,000 for 2 days like you did last time. I am not coming in. I am not going on that stand because they've already perjured themselves. So my mouth is open because this is my profession.
Yeah, and like I've used your example many times, how when defense teams go shopping, they're not telling you to report. They're not telling you what to find. They're sending you the packet of evidence, and you're looking at it, and but you know what's going to help them, or what you're going to testify to is going to help them or not going to help them. And so you're upfront and you're honest, and you say, yes, I'm willing to testify, but I don't think I'm going to help your case completely. So they're like, thank you, and then they move on to someone else. So that's how the shopping works. It's not like, and this is, I think it's also subtle with the U.S. Attorney's Office. It's not like the U.S. Attorney's Office reached out at any point to ARCA and said, we really want to find that this Karen person didn't do this crime, so you need to help us. No, it doesn't work that way. But there are subtle ways that it's understood what the party that's hiring you wants. And then you have to consider, are you willing to destroy your reputation? So what you're saying here is Dr. Wolf and Dr. Rentschler, are they willing to destroy their reputation if the evidence is so overwhelming against what they're going to say? And I don't know, Dr. Wolf struck me as one of the most arrogant human beings I've ever seen. And I believe he's one of those guys that he does not want to admit that he was wrong last year. And he's kind of snaky, and so I believe he believes he can do everything he can to try to, that's why they're coming up with tests this is what Hank is trying to get out actually with it. He's not trying to get the judge to eliminate ARCA from testifying. He wants them to not be allowed to use any new testing. And that new testing is still underway right now. And that new testing from ARCA is to refute the Aperture, the company hired by the prosecution, their testing.
Yeah, I mean, this is such an interesting situation, right? Because ARCA never looked at the DNA on the taillight, the hair on the back of the car, the fragments of the taillight, the small, teeny microscopic that were in John's clothing. How can you make a scientific conclusion without having all of the facts? And that put them at a huge deficit. So they can get on and say, hypothetically, if this vehicle goes at this angle and does this, hypothetically, from an engineering standpoint, but you cannot refute the science of the DNA and the fibers. And for them not to consider it is, to me, always just made me have no respect for them.
And they've obviously not only looked at it now, they must have, because they've looked at the entire Aperture conclusions, which apparently includes some new testing and stuff like that. We got a hint at it from Alessi a couple of weeks ago. It sounds like, there was something involving paint that the Aperture did. So I'm going to guess that they took off the exterior of a taillight, took the corner off like it was on Karen's Lexus, and put paint on it and used to see if they could push that up against a bag or a dummy and see if it could recreate those parallel tracks that we see on John's arm. I'm just guessing on that. I don't know, but they've done, so whatever they've done, they've obviously would have looked at the Aperture guys would have looked at the tech stream data and the DNA and all that stuff. So ARCA has no excuse now for saying they didn't look at that. But in a way, the prosecution might give them that excuse, because I think what he's angling at here is that they're only going to be allowed to talk about their original findings. And those original findings were just based on what they were given, so they won't have that stuff.
Yeah, I agree. The problem is they are totally out of the discovery window. And so it's different to put up a PowerPoint based on the information that the defense already has. Anybody can do that.
Right.
The defense can put together a PowerPoint. That isn't taking the initial information and giving you new information. It's just,
right.
fine tuning it. And that's why that's all going to be allowed. But you can't, as an expert, come with a supplemental report, they call them, and have new findings based on new experiments and things. All of that is not going to be allowed. It was due long ago, and it wasn't submitted. But Kevin, aside from that, which I don't think she'll let it in, she just can't let it in. Aside from that is their credibility, their reputations as experts. I mean, this is their job. This is their business. And so I'm not talking about lying about what they said in the first experiment, right? That's been refuted by evidence. I'm talking about not telling the truth of their relationship with the defense team. And that's what they're going to look at, I think, during voir dire, is not their backgrounds as engineers, but it's regarding all these lies that were told.
Yes. Oh, Joey, I did catch that. So the judge said no more testing after Monday's voir dire. The voir dire is now scheduled for Monday. So whatever testing ARCA, whatever new testing they have has to wrap up this weekend. Yes, I absolutely caught that. But what I'm saying is that the judge is, what Brennan is trying to get the judge to say is no new testing that was done since over the last couple months. And what Alessi and the defense are going to argue is, and they already did argue yesterday at the motions hearing at the end of the day, is that they just received a lot of this. Most the reports from Aperture they didn't get until February, and then there was some back and forth over the last couple of months. So they're still getting updates on it, is what they're trying to say. And so they're within a timeline, because he's trying to say that they didn't get their last update until this month. So they have to be given enough time to perform these tests. And I think what Hank Brennan brilliantly did, though, was now conflate these issues a little bit. The deletion of the text messages that the defense team did, and Alessi falsely says took place 2 years ago. It didn't. It took place no more than 13 months ago. But I think that the judge, she may see that conflation, though, and say, you know what, that's it. I'm just not. But I think the judge is going to allow the testing, anything that was done by this weekend, because she just doesn't want to take that away, that tool away from the defense.
Court is back in session. You may be seated.
Thanks, Shannon. We'll see you soon.
Yes.
Ms. Roberts, we have about a minute and a half left. I want to watch the video until it reaches 6:35, please, Ms. Gilman. Do you know where you are at this point, Ms. Roberts?
No.
Could you fast forward just a little bit more, please? Were you in the car?
I just got out of the car.
And do you remember if your car was warm?
Yes.
Stop, please. 6:34:36. Do you see yourself?
Yes, I just got in the driver's side of my car.
And at that point, do you remember whether you still had John's cell phone or you had given it to a first responder?
I don't remember.
Between you having it in your pocket and giving it to a first responder, did you put it or place it anywhere else?
No.
Did you take it out of your pocket and place it in the elements at all?
No.
So it was either in your pocket or in the hands of a first responder?
Yes.
Thank you for your time.
Your Honor, may I? Thank you. Good morning, Ms. Roberts. How are you?
Good morning.
Under questioning by Mr. Brennan, you talked about the number of times or a number of times that you have spoken to the DA's office or some member of the DA's office. I'd like to ask you a couple of questions about that.
Sure.
How many times in total do you think you've spoken to a representative of the district attorney's office?
I don't have a number.
Would you say it's more than a dozen?
Yes.
Would you say it's more than 50?
Maybe around there.
Okay.
Maybe less.
And who are the folks, Ms. Roberts, that you have spoken to at the DA's office?
Steve Nelson,
Okay.
the victim advocate, Yuri Buchanan, who's a state police officer, and the DA, Michael Morrissey.
And what was the, I want to take those in order, and two of those are at the DA's office. One of those is not. Yuri Buchanan is not at the DA's office. He's actually a Massachusetts state police officer. Is that right?
Yes.
Okay. Let's take those in order. How many times would you say you've spoken to Mr. Nelson? Just if you can give me a thumbnail.
I don't know, maybe 30, 40.
Okay. Have you received what you would consider to be updates on the progress of the case?
I would ask questions and he would give me very broad answers.
Okay. Were your questions ever prompted by conversations that you had with your friend, Miss McCabe, Jen McCabe?
Sometimes Jen would say, could you ask Steve this? Because I had a rapport with Steve.
Okay. Were those conversations by text message or phone calls or both?
I would usually text him.
Okay. What about the conversation with, or conversations with Mr. Morrissey, the elected district attorney? What were the circumstances under which you contacted Mr. Morrissey?
Well, during the course of this trial, the witnesses have been harassed.
That's not my question.
Objection.
But I'm answering your question.
Hold on. I'm going to sustain the objection. Next question.
Thank you. Were you phoning him? Were you meeting him? Were you texting him? That's my question. The circumstances of the communication itself.
I phoned the office asking for a meeting, had a meeting, and then he left a voicemail at some point and texted me and said, I just left you a voicemail.
Okay. Was that the extent of your conversations with Mr. Morrissey, the elected DA?
I had one other meeting with other witnesses.
Okay.
And the DA.
And turning to Yuri Buchanan, what were the logistics, I'll use that word instead of circumstances. What were the logistics of you contacting Yuri Butnick? Was it by phone? Was it in-person meetings, text messages, or all of the above?
All of the above.
How many times would you say that you've spoken with Yuri Butnick?
Spoken or communicated?
Sorry, good point. Communicated with.
Probably 20.
Okay. When was the last time? Actually, let me ask you a different question. Have you ever met with Mr. Brennan before your testimony today?
Yes.
What was the circumstance of that meeting?
Going over my testimony from the last trial.
Okay.
And sort of just asking questions on what might come this time. Would I be cross-examined? I wasn't last time. Just sort of, all the things went through my testimony.
Okay. When was that meeting?
I don't know. In the last couple of weeks. I don't know.
Okay. Where was the meeting?
At the DA's office.
Who else was there?
Different times that I would meet with him. Steve Nelson would be there. One time, Brian Tully was there. Mr. Brennan's assistant.
I'm sorry?
Mr. Brennan's assistant.
Okay.
I don't know. Adam Lally and Laura McLaughlin.
Were those meetings, you said there was 2 meetings? Or did I misunderstand you?
Yeah, I think there were 2.
Okay. Were those close in time to one another? You mentioned 2 weeks ago. Were those both 2
I
weeks
said a
ago?
few weeks ago, but the other meeting was just before I was going to testify.
Meaning, what, yesterday, the day before?
Last week.
Was that also at the DA's office?
Yes, it was.
Were you shown anything at that meeting?
Was I shown anything?
Videos, testimony, transcripts,
No.
reports?
No,
Nothing?
I don't think so.
Okay.
We went over my testimony on the screen. And then I just talked about my testimony from the last time.
Okay. When you say you went over your testimony on screen, what do you mean?
We watched my testimony from the first trial on a TV screen.
Okay, so you were shown something. You were shown a video of your prior testimony.
Yes.
So I'd like to see counsel at sidebar for just a minute, please.
You are
This is like a TV sidebar. You have to have a commercial every 15 minutes during a football game, right? This is a sidebar because we haven't had a sidebar in 20 minutes. So it's time to have a sidebar. I'm just kidding. Don't get mad. Thank you, Kim, very much for the donation. I think she had a comment too. Let me see. Oh, and Lou Morocco, thank you. Thank you very much, Lou. Haven't seen you in a while, Lou. Good to see you, man. Andy Dufresne. And remember, Karen stated, I was the only one who tried to save John's life. Of course, she said that on the courthouse stairs. She is legally entitled to lie as long as it's not in court. And obviously that was not true. And it's, in fact, we saw this when we watched the video last year of the dash cam. It became apparent that not only was it not true, but it seemed like Carrie and Jen were spending more time trying to save John's life than Karen. Now, I don't mean that in some kind of disparaging way of Karen, because she was hysterical at the scene. But when she says she was the only one, she clearly was not telling the truth, as she is prone to not do. I'll take this off the screen. Thank you again, Andy. Chick, we're at a sidebar because we haven't had a sidebar for 20 minutes. So they have a legal contract with Court TV where the judge has to have a sidebar every 20 minutes. Right, Jen?
Yes, very true. What do you think the sidebar is about, though?
I don't know, because there wasn't an objection, so I don't know.
I think this sidebar is about this. I think it's about the door. Sorry, there's
Oh, looks like they're going to come back. Grandma Munson says, get the flagpole out there. No, I don't want to get that idea out there unless there's a third trial.
May I, Your Honor?
Yes.
Thank you. Other than watching your testimony, were you shown anything else? Transcripts, videos that you may have seen today, dash cam videos, anything like that?
I don't think so.
Okay.
I don't think I was shown anything.
Okay. Did you discuss other parts of your prior testimony?
Yes.
Okay. What was discussed concerning your prior testimony and how it would impact how you testify today on direct examination?
Mr. Brennan had just asked me, can you just tell me what happened? So I told him the story verbally.
Okay. Anything come up about specific instances of how you were going to testify today?
No.
Or yesterday?
No.
Okay. I want to talk to you a little bit, Ms. Roberts, about the video that you were shown by Mr. Brennan. It's the dash cam video of Officer Seraph. I'm not sure if you know which officer that is.
No, I don't.
It's the one that you've been watching.
Okay.
That dash cam that shows your car in the foreground.
Yep.
I'd like to ask you a couple of quick questions about your memory of that incident, and then perhaps show you the video depending upon what the answer is.
Sure.
Do you remember when the officer first arrived, you and Miss Reed specifically were at Mr. O'Keefe's body?
Yes.
Where was Miss McCabe at that moment?
She was there too, but she was waving down the first responders because it was dark out and he couldn't see us. He had a spotlight.
You and Miss Reed were both providing some level of CPR, some level of life-saving efforts.
Yes, as was Miss McCabe.
What was Miss McCabe doing?
When I was doing chest compressions and Karen was doing mouth to mouth, Jen was either on the phone with 911 or handing me baby blankets.
Okay.
At some point, she did take over doing chest compressions because I asked her to.
Okay. So Miss Reed was focused on Mr. O'Keefe's head, face area.
Correct.
You were focused on the chest.
Correct.
Miss McCabe was, at some point at least, she had called 911 or dialed 911.
Yes.
When Miss McCabe dialed 911 and was on the phone with 911, isn't it true that she was actually in a vehicle at the time?
That is not true.
She was outside?
She was outside.
That's your memory?
Yes.
Okay. Have you heard the 911 tape of that call?
Yes.
Okay. You're aware that that tape was also captured by an open line on Miss Reed's phone?
Yes.
That open line that phone was dropped inside the cab of an SUV?
It was in the back seat, I believe.
Right. So in order for that for that open line to capture sort of the background of Miss McCabe's side of the 911 call, Miss
Yep.
McCabe would have had to have been either at or in the cab of the truck.
The back of the SUV was open. She was standing there.
Got it. Okay. So she was right next to or adjacent to the cab of the SUV.
She was in back of it with the back was up.
I see that back hatch.
Yes.
Okay. Do you remember Miss Reed's statement, her initial statement to Officer Seraph when he got out of his patrol
I do
car?
not.
Do you remember her saying something to the effect of, my boyfriend, I left him, he never came home?
I do not.
Okay. Have you listened with audio to that dash cam at the moment that Officer Seraph arrives at the scene and y'all flag him down?
We just watched it.
Right. Have you listened to it for the audio side? I mean, in other words, instead of focusing on the
no.
video.
No.
Okay. I'd like to ask you to do that with the court's permission. This is it's been previously marked as Exhibit 4. And with the court's permission, I'd like to play that from runtime about 3:50 and ask the witness to concentrate most readily at about 4:07, maybe 10 seconds into it. I'm going to give a little run up and then ask you to listen very closely to the audio.
Yep.
With the court's permission?
Yes.
Okay, Evan. Stop. Do you recognize the video as being the same video that you saw and you looked at on direct examination?
Yes.
Okay. In just a quick second, the door to the car, you're going to hear it open. I'd like to ask you to pay special attention to the audio portion and Miss Reed's voice,
Okay.
if you can hear it. Go ahead. Stop. Did you hear that last statement?
No.
Did you hear a woman's voice kind of faint in the background?
I heard a voice, but I didn't make out what she was saying.
Okay. Did it sound like she said, my boyfriend, I dropped him off and he never came home?
Objection.
Could you hear that, Ms. Roberts?
No.
Okay.
Next question.
That's all I have for the video. We can take that down. You talked about, on direct examination, some of the injuries that you saw Mr. O'Keefe having suffered, both what you observed at the scene and then what you observed later at the hospital.
Yep.
And you noted those injuries, correct?
Say it again?
You noted those injuries. Those were,
Yes.
you made note of those,
Yes.
or at least some of them. You said that you saw a hematoma of some sort over his right eye. Is that right?
Correct.
And there was some significant swelling to his right eye
Correct.
at the scene.
Correct.
Did you also notice a laceration just above his right eye, just under the eyebrow?
I saw it at the hospital, but I don't know if at the scene I saw it.
Fair enough. At some point, you saw that laceration to his right eye?
Yes, I did.
Did you also see a laceration to the left side of his nose, a smaller laceration to the left side of his nose?
I don't recall. I know there was blood coming from here, but I don't know if it was coming from inside his nose or from a laceration. I don't know.
When you said here, you're pointing to the left side of your nostril.
Yes.
And basically just above the nostril, correct?
Yes, right around the nostril, there was blood coming this way.
Okay, draining to the left side of his cheek?
Yes.
Okay. You also saw, once you got to the hospital, that his left eye had swollen as well.
Now, both eyes were swollen and filled with what looked like blood.
And his left eye was black as well as his right eye?
Correct.
Okay. You also indicated that you saw, well, actually, I don't know if you did or not, so I don't want to put words in your mouth. I apologize. Did you see his right arm?
I did.
Did it appear to you that he had some abrasions or lacerations, parallel abrasions and lacerations and punctures on his right arm?
They were scratches.
Scratches. Ms. Roberts, you've previously testified that when you arrived, let me take you back instead of jumping right into it. After you met up with Ms. Reed at Jen McCabe's house that morning, so this is just after 5 o'clock or so, the three of you arrived back at One Meadows, correct? Is that right? I'm sorry.
Correct.
Okay. You're trailing the Lexus SUV, correct?
Correct.
The Lexus pulls in to the driveway and you pull in directly behind Miss Reed and Jennifer McCabe is driving.
Correct.
You're driving your SUV, correct?
Correct.
You've previously testified that when you arrived at One Meadows at that moment, that once that SUV, the Lexus SUV, had pulled in and you pulled in behind the Lexus, you got out of the Lexus, sorry, you got out of your SUV, they got out of the Lexus, and that's a point at which Karen showed you the back of her taillight and said something to the effect of, do you think I hit him? Do you think I hit him? Oh my God, do you think I hit him? Do you recall that?
I recall saying I didn't know if it was when we were coming or going, but she did point out the taillight.
Okay. When you previously testified under oath, your quote was, quote, Karen pulls in and I pull in behind her.
Mr. Jackson. Give page and line numbers when
Yes.
offering statements.
Sure. It's the SGJ, the grand jury, page 58, lines 14 through 19 for court and counsel.
Thank you.
Did you testify, quote, Karen pulls in and I pull in behind her, period. When we get out, and Karen is now showing us the back of the car saying, my taillight, do you think I hit him? Do you think I hit him? Oh my God, do you guys think I hit him? Question mark. End quote. Is that how you testified?
May I see it?
Sure. I apologize. I've already got it up here.
Does it have a date on it, Mr. Jackson?
It does. (4/26/22). May I approach?
Yes.
Thank you, sir.
Thank you. Do you have the pages after this?
I'm sure I do.
Because in the pages after
My
this, I
question,
say,
Ms. Roberts, is that a quote that I just said? Is that accurate? Do you see it in the?
yes, it is.
Okay. May I approach?
Yes.
Your Honor, may I approach
Yes.
one more time? Thank you. Just for reference, I'm going to show you both pages. That's the page I asked you to look at, and then the following page as well. Please take your time.
Okay.
May
What
I?
I'm looking for is still not here because I did say I wasn't sure if it was
Yes.
before or after.
Ms. Roberts, you do have to wait for a question.
When you gave this testimony, you were in front of a grand jury, correct?
I'm not sure which one that is.
Do you remember testifying in front of a grand jury on April 26th, 2022?
Yes,
Okay, about 2 years ago.
yes,
Sorry, 3 years ago. You were under oath at the time. Is that right?
yes,
Things were fresher in your mind at that time than they are now, 3.5 years later, I'm guessing, correct?
yes,
Okay. You were asked the question to describe the circumstance when you arrived at One Meadows. Is that right?
yes,
And the answer that you gave was, quote, we pulled into it's a driveway. There's 2 cars and then 2 cars, then a single. So John's car is there. Karen pulls in and I pull in behind her. When we get out, and Karen is now showing us the back of the back of the car saying, my taillight, do you think I hit him? Do you think I hit him? Oh my God, do you guys think I hit him? That was your testimony at the time, correct?
yes.
Just to be clear, I'd like to take a look at a quick video that you may or may not have seen before. We'll find out. Your Honor, I'd like to have this. Actually, this has already been previously marked as Exhibit 12C as in Charlie.
Okay.
And it's a short clip. So I'll play the entire clip with the court's permission.
Okay.
Let's go ahead and take a look at that video. Can you pause? Do you recognize what's depicted in the video?
Yeah, that's when we arrived at John's house.
Okay. And who's the person with the plaid red pants?
That is Jen.
And who's the person that's just rounding the back of the car in front?
That is Karen.
What is the car in front?
That's Karen's SUV.
That's the Lexus SUV.
Yes, it is.
Behind that Lexus SUV, Ms. Roberts, is there another car?
That's my car.
And who's getting out of that car?
I am.
Okay. And this is the point that you were describing in your, at least in the grand jury testimony at that time.
Yes.
This is the time that you're describing.
That I thought it was when we walked in.
This is the time that you were describing, right? When you arrive at the scene.
Yes.
Or sorry, arrive at One Meadows.
Yes.
Okay. Let's go ahead and play this through. Okay, you can stop it. And you can bring the lights up. You saw the interaction between all three of you and the vehicles, correct?
Yep.
At any point, did anybody stop and take a look at the tail light or the rear end of the car?
Not when we were entering the house like I thought, but when we came out.
Okay. And there's no video of that.
I'm sorry?
There's no video of that.
No, I don't believe so.
Right. So the video that does exist describes nearly exactly the time that you testified that y'all stopped at the back of the taillight and Karen said, look, my taillight's broken. Oh my God, do you think I hit him?
Correct.
Right? Okay. And that obviously was incorrect.
It was incorrect.
So your memory was faulty about that incident, that part of that incident at least.
It happened on the way out of the house.
So your memory was faulty about that part of the incident that you testified to at the grand jury.
Yes.
Okay. You were interviewed on January 29th. You've already testified to that, correct? By
Yes.
Troopers Dunn and my memory's failing me now.
There were two. I don't know who they were.
Okay. I'm sure it's in my notes somewhere. Two individuals that interviewed you on January 29th, correct?
Yes.
Obviously, things were very, very fresh in your mind at that point.
Yes, but I believe I was in shock. So
The incident had just happened.
yes.
Okay. And you were asked to recount certain of the specifics about the incident that you had just experienced, not days or weeks, but just hours before, correct?
Yes.
Okay. And you did your best, I'm sure, Ms. Roberts, to be as full-throated as possible, to provide them with as much detailed information as you could and to be as honest as you could.
Yes.
I mean, you weren't going to lie to these police officers, right?
No.
In your very first conversation with those two troopers on January 29th, you didn't mention anything about a taillight or a cracked taillight, or
No,
even
I did
having
not.
seen a cracked taillight, did you?
No, I did not.
Okay.
I
You
didn't
then-
want to accuse anybody of anything.
You were then interviewed on February 1st, 2022, a few days later, correct?
I don't know.
Does that
I don't
sound
know the
right?
exact date. I was interviewed again, but I don't know the exact date.
Okay. During your interview, let me withdraw that and ask a different question. On February 1st, or whatever day it was, the subsequent time that you were interviewed just a few days later, you did then for the first time describe the taillight that you saw, correct?
I don't know.
Would it refresh your recollection if you looked at a report?
Yes, please.
I may have just a moment, Your Honor.
Sure.
May I approach?
Yes.
I'm handing you a 2-page report, Ms. Roberts. I've put a little dot on the second page just to direct your attention to the discussion related to the taillight, if you want to take a look at that.
Okay.
Okay. May I?
Yes.
Does that refresh your recollection that you were interviewed on February 1st, 2022 by a trooper by the name of Connor Keefe and a trooper by the name of Kathleen Prince?
Yes. Did Connor Keefe write that report?
I'm sorry?
Did Connor Keefe write that report?
Trooper Kathleen Prince wrote the report.
Okay.
Does that matter? No?
Nope.
Okay. Does that refresh your recollection that you did discuss the taillight at that time?
Yes.
And did you tell Trooper Prince and Trooper Keefe that you noticed the back right taillight in the middle, quote, in the middle, your words, was broken and a piece of the metal encasement was pushed forward?
Yes.
Okay. You didn't say the taillight was completely shattered, correct?
Correct.
You didn't say that the entire lens was missing, correct?
Correct.
You said it was broken in the middle. Is that
Yes.
right? And then you described today that a square piece was missing.
Yes. That's the piece I was referring to in the middle.
Just in the middle of the taillight, though. That was how you described it.
Yes.
Okay. I'd like to shift gears for a quick second and talk about a March 7th, 2023 text message with victim witness advocate Steve Nelson. Do you remember communicating? You don't have to know the exact date, but if you do, fine. Do you remember communicating in March of 2023 with victim witness advocate Steve Nelson about the Ring camera at One Meadows?
I don't know the exact date, but yes.
Okay. Is it true that you contacted him to inform him that the O'Keefes needed to replace or wanted to replace the driveway Ring camera, that same Ring camera that we just literally saw through that perspective
Yes.
of you arriving?
Yes.
Did Mr. Nelson indicate that he believed that would be fine to replace that Ring camera if the O'Keefes wished to do that?
I don't remember if he said it would be fine, but at some point they were told they could replace it. It had broken. It wasn't working.
Did he indicate that he would check with DDA Adam Lally and then get back to you?
I don't know.
At some point, you were informed that the O'Keefes had the green light or the go ahead to replace that Ring camera at One Meadows. Is that right?
Yes.
Okay. And then ultimately you then relayed that to the O'Keefes that they have the green light. You've talked to somebody at the DA's office and they said, yeah, go ahead and replace the camera, correct?
Yes.
Okay. Did you ever receive any kind of response from the DA's office either before or after you relayed this information to the O'Keefes to say, wait, hold on, we need to do a reconstruction. We need to make sure that the camera is in the exact same spot that it was at the time of the incident?
No.
Any communication like that?
No.
So the communication that you got was, yep, go ahead and replace it. It's no big deal.
Correct.
Okay. And ultimately, you learned that the O'Keefes did, in fact, replace that Ring camera.
Correct.
You have already described your relationship, at least in part, with Canton Police Officer Sergeant Michael Lang, correct?
Yes.
He is friends with you?
His daughter is friends with my daughter.
You're friendly with the family?
Yes.
Okay. And you're aware that he's also friends with the Albert family?
No. Well, no.
Were you aware that Michael Lank grew up with Chris Albert?
I was not.
Have you ever been in a social setting with both the Lanks and the Alberts?
No.
You're aware, obviously, you were at the scene. He was the first officer to respond to the crime scene at 34 Fairview on January 29th after Officer Seraph and after Mulaney arrived. Right? Then it was Sergeant Lank.
I don't know which order. I did see Sergeant Lank there, yes.
Was he the, excuse me. I was just reminded, you indicated that you don't remember the date of that text communication between yourself and Mr. Nelson.
No, I don't remember the date.
Would it refresh your recollection if you looked at a text message between the two of you about the subject of the Ring camera?
Sure.
Okay.
Do I need to know the date?
May I approach? I need to know the date.
Oh, okay. Sorry.
Thanks.
Is it March 7th, 2023?
Does that refresh your recollection?
Yeah.
Okay. Thank you. You indicated that you did recognize Sergeant Lank at the scene.
Yes, I did.
You had a conversation with him.
No, I said, Mike, is that you? He said yes, and that was it.
All right. Following that, the next day, you did go to his house. You've already described that.
I did.
You indicated that you went to his house to drop off your daughter for a play date. Is that right?
Yes.
But
And
you
she
also
was
indicated that you took Jennifer McCabe with you.
Yes, because I drove Jen McCabe to the O'Keefe's house, so she was leaving to go home with me. So I was going to drop her off.
Okay, so your memory is you took Miss McCabe from where over to the Lanks house?
I think she was at home.
So you picked her up
Yes.
at her house
Yes.
with anybody else?
With my daughter, my son. I picked up her and either one or two of her daughters. I don't remember.
And then you drove over to the Lanks house. Is that right?
No, I drove to the O'Keefe's house.
First.
Yes.
And what did you do with the O'Keefe's
Then
house?
left a couple of kids, and my daughter wanted to go to the Lanks house. So I drove my daughter to the Lanks house before driving home.
And Jen's child was with you on the way from Jen's house over to the O'Keefe's house.
Yes, one or two daughters. I don't know.
Dropped the one or two kids off at the O'Keefe's. Is that right?
As well as my son.
As well as your son. Then you went to drop off your daughter for the play date.
Well, she was 13, so it wasn't a play date.
Whatever. I don't know what you call it.
I know.
I don't have a 13-year-old. What a date, whatever
Yeah.
it is.
So she went over to her friend's house. Yes.
Okay. But you took Jennifer McCabe with you
Yes, because I was driving her home.
back to her house without her kids?
Yes, she was going home.
Were you going to go back to the O'Keefe's and pick up her kids and then take all of them home?
I didn't have a plan. I mean, Patrick,
Okay.
nephew, is my son's best friend.
Got it.
So he wanted to be with him.
Okay. Did you, I think you just answered this, but I want to make sure I'm clear about it. You didn't take separate cars. You all went in the same car. Is that right?
Correct.
Okay. Did anybody stop by or go by 34 Fairview during that roundabout?
No,
Nobody stopped off at 34 Fairview either on the way or on the way back?
no. I don't believe so. That wouldn't be the route in which to get to my house.
Right, exactly. You indicated that you stayed, even though you were dropping off your daughter, y'all stayed, you and Miss McCabe stayed at Sergeant Lank's house for some 45 minutes. Does that sound about right?
Yeah.
And Sergeant Lank's wife, you indicated was in the backseat of your car?
Yes.
Did y'all ever go inside the house?
Jen went in to go to the bathroom.
Was Sergeant Lank there?
I don't know. I didn't go in.
You didn't have any communications with Sergeant Lank?
I'm sorry?
You didn't have any communications with Sergeant Lank himself, Mike Lank, on that trip?
No, I did not.
But you don't know whether or not Jen did?
I don't know whether or not Jen did. She went in the house to go to the bathroom.
Okay. You've indicated that there have been occurrences in which Jennifer McCabe has asked you to contact the DA's office on her behalf to ask a question here or there, get some information, correct?
To Steve Nelson, yes.
Okay. How many times, just a number of times, the volume, would you say that Ms. McCabe has asked you to reach out to the DA's office in one particular or another on her behalf?
I don't think very many.
What does that mean? Of the 50 times that you've had
No,
communications?
maybe like 4, not many, to my knowledge.
When you would, on these 4 occasions or 4 or so occasions, when you would reach out to the DA's office, gather information, whatever that information may be, would you then report that information back to Ms. McCabe?
Yes.
You obviously understand the importance of providing statements to law enforcement that are free of influence of other people, other witnesses. Is that right?
Say it again?
You understand the importance of providing information to law enforcement as a witness to law enforcement free of influence from other people.
Yeah.
In other words, you want to be as accurate and as independent as possible.
Yes.
And that's because if your statement is somehow, or if your communications with law enforcement are somehow influenced by others, it might call into question the credibility of the person providing the statement.
Objection.
Can you answer that question, Ms. Roberts?
No.
Okay, next question.
Sure. A statement that's been colored by influence from someone else would lack credibility, right?
Objection.
Sustained.
I want to talk about the statements in the prior testimony that you have provided in this case, Ms. Roberts. There's been several of them. The first time you told your story to law enforcement was on January 29th. We've already established that, correct?
Say that again?
It was on January 29th, the first time you relayed your story to law enforcement.
Yes.
And that was to Trooper Dunn and Trooper DeChico. That's the name I couldn't remember.
I don't remember.
But you do remember Trooper Dunn?
I remember 2 troopers. I don't know their name.
Okay. Where did that interview take place?
In my dining room.
And who was with you when you gave that interview, if anybody?
My husband was home. I think my daughter was home at that point. My husband was home. I don't know if the kids were home.
Nobody else from outside the family?
No.
Okay. Who contacted you about doing that interview? How did they know to come to you at your home?
I don't remember. They may have just shown up. I don't remember.
Okay. Do you remember what time the interview was?
Maybe around dinner time, maybe around 5, 6.
Was it recorded?
I'm sorry?
Was it recorded in any way? Tape recorder running?
I don't think so.
The troopers were taking notes, obviously?
I believe so.
During your conversation with, and I'm jumping around a bit, so I apologize. During your conversation or conversations with Mr. Brennan and the members of the DA's office in preparation for your testimony, were any of those interviews recorded?
No.
Was anybody taking notes?
No.
No, none of the DAs were actually taking notes, the ADAs?
I didn't look around the table to see if anyone was taking notes, but I didn't see them taking notes.
No pads and pens on the table?
There was a lot of stuff on the table, but I didn't see anybody taking notes.
Okay. You received a phone call just before that interview started at 5:25 p.m., correct?
Around 5 o'clock, 6 o'clock. Is this the night of the 29th, you mean?
This is the night of, I'm jumping back to the night of the 29th.
Yeah, I'm not following you very well.
That's okay. On the 29th,
Yeah.
you were interviewed around 5:25 p.m., maybe just a little bit before that.
Yeah.
You received a phone call just before that, correct?
I do not know.
Isn't it true that Jen McCabe called you and spoke to you just before that?
I spoke to Jen McCabe the entire day.
Okay. Including just before that interview?
I don't know.
Did you tell Jen McCabe that you were about to be interviewed?
No.
Did you tell her at some point did you text her and tell her that the officers had arrived?
I don't think so.
Did she text you back and say, call me right after?
I don't know.
Okay. During the course of that interview, when the incident was still pretty fresh in your mind, You indicated that at about 5 a.m. you got a call from Karen Reed indicating that John never came home and that she was worried, correct?
Correct.
You also indicated that she was worried that John may be walking and may have gotten hit by a plow. You relayed that to the officers.
Yes.
You indicated that you met up with Karen Reed and Jennifer McCabe at Jennifer McCabe's house, and Karen was hysterical and worried that something had happened to John.
Yes.
You also indicated that once you were at 34 Fairview, once y'all had made your way over to 34 Fairview, Karen saw John and ran to him, although you and Jennifer didn't see him initially, correct?
That's correct.
You said that Karen was repeating the phrase, "Is he dead? Is he dead?" over and over. Is that right?
That is correct.
You also indicated that she said that if anything happened to John, she'd kill herself, correct?
That's what she said to me.
Object.
So the objection sustained.
Did you indicate at any time, I'm sorry, let me ask it a different way. Did either of the troopers indicate to you after your initial interview that if there was anything further that you could recall that would be useful, please provide it? Please give it to at that time.
I don't know.
Okay. Would it refresh your recollection to look at that January 29th report?
Sure.
Thank you very much.
Thank you.
Show the second page of that report, January 29th. And there, I put a little mark by paragraph 5. You could take a look at that.
Okay.
May I?
Yes.
During this interview with Trooper Dunn and Trooper DeChico, they indicated after you gave your statement that if you wish to provide anything additional, now is the time to do it.
Objection.
Sustained.
Were you informed that you were limited on time in that interview? Meaning, we got to get this done, we're leaving, we're out of time.
No.
They didn't cut you off, correct?
No.
They didn't tell you that they had a limited amount of information that they wanted and then they were just going to leave, correct?
I don't remember. I don't recall.
As a matter of fact, they told you that anything you wanted to provide to them, provide it. Give them as much detail as you could, correct?
I don't recall.
You just read the last statement that these troopers indicated, correct? If there's anything further she could recall that would be useful, please provide that information.
Object.
Sustained.
John, may we approach?
Yes.
I'm sorry, guys, but no, it's not irrelevant. This is all relevant. You have to now. I'm not suggesting that obviously was not a conspiracy, and all of this goes on in the real human world. That people like we saw Trooper Proctor. He knows that he's not supposed to talk, text anything about the investigation to his buddies, but he did. And in reality, probably every cop does that, and it goes on a lot of times. Apparently in the Norfolk County DA's office, possibly. So it is appropriate for Alan Jackson to try to point out these problems because Jackson's doing fine so far.
May I?
Yes.
Thank you. Having looked at the report.
No, bring it to her and show it to her again.
She's just, it's the same thing that I just showed her. Having looked at the report, does that refresh your recollection about what Trooper Dunn and DeChico told you at the end of the interview?
I don't recall. It's not refreshing. I'm not remembering it. Even reading it, I'm not remembering it.
I see. Okay, fair enough. So as you sit here, the details about what we told or what those two officers told you are not fresh in your mind, and nothing's refreshing your recollection about that.
Right.
Okay, but you do remember the basics of what I just described in that conversation with those two troopers?
I mean, they asked me what happened. I told them, but I was also in shock.
You never said during the course of that interview that my client called you at 5 o'clock in the morning, just hours earlier, and said he's dead and then hung up, correct?
No, I don't believe I said it at that point. I did not remember that until a couple of days later.
I see. And in fact, when you were asked about that particular statement, when you asked about that particular series of events, that never came to your mind.
No.
That literally the first words out of Karen Reed's mouth, according to you now, is he's dead and then hung up.
Correct.
When you heard that, you didn't take that to mean that she killed him.
No.
Of course not. She was panicked, correct?
Yes.
You did add that, one other thing that you didn't add in your initial statement to Trooper Dunn and Trooper DeChico is anything about the taillight either, correct?
Not.
Okay. And you also didn't say anything about any sort of a Google search or the praying that you talked about in the back of the patrol car, anything like that?
No. Okay. I don't know. I don't remember.
The second time you were interviewed, that was the February 1st interview. That was with Kathleen Prince and Connor Keith, correct? And you just looked at that report, at least part of that report. Is that right?
Say it again.
Connor Keith and Kathleen Prince, that was on February 1st, 3 days after your initial statement, correct?
I don't remember the date, but I remember meeting with them.
Okay. I want to make sure I get the dates down, so I'm sorry to belabor this, but. May I approach?
Yes.
Would it refresh your recollection if you were looking at the report of that interview?
It might.
Okay. First paragraph.
Thanks. Am I reading the whole thing or just the part where you dotted?
Just if it refreshes your recollection.
Oh. Oh, for the date, yes.
May I approach?
Yes.
What date was it that you met with me?
February 1st.
That second interview was conducted at 12 Country Lane, correct?
Yes.
And who again lives at 12 Country Lane?
Jennifer McCabe.
So the second time you told your memory, your story to law enforcement, you were literally sitting in Jennifer McCabe's house.
Yes.
And you had met with Jennifer McCabe before your interview, correct?
Yes. We were putting a timeline together.
So you two were actually prepping, if that's a valid term, prepping for your interview, putting a timeline together, correct?
We were putting a timeline together at the request of Mrs. O'Keefe.
And Jennifer McCabe, was helping you with the timeline, and you were helping her with the timeline.
Yes, we were putting together the events of what had happened.
So she was helping you, and you were helping her, yes or no?
Yes.
Okay. So both of you were assisting in each other's memories, correct?
Yes.
I remember this, and you remember this, and okay, now I remember this, correct?
Yep.
Obviously, that would help influence your memory going over the event with someone else, correct?
Yeah.
So what's on that timeline, you would agree, is not completely independent, your memory. It's a combination of your memory and Jennifer McCabe's memory. Isn't that right?
Yes.
May I have just a moment, Your Honor?
Yes.
Thank you, Your Honor. So the two of you drew out some sort of a timeline for you to follow during the course of that interview. Is that right?
For me to follow what?
During the course of that February 1st interview, as you were interviewed in Ms. McCabe's house. I mean, that was the purpose of the timeline, to help you with that interview.
No, that wasn't the purpose of the timeline.
You used it for that purpose, though, obviously.
We did not. I was at Jen's house making a timeline, and the two officers showed up to interview her. I just happened to be there.
Right. And when they interviewed you, did you have that timeline in front of you? That's my question.
No, I did not.
Okay. But you had just created it along with Jennifer McCabe.
Some of it.
Okay. And then it was after that that this timeline was coordinated between the two of you, that you actually told your second story to Trooper Prince. And when I say second story, I mean as the second time you were interviewed on February 1st as opposed to January 29th. Is that right?
Yes.
Did you ever become aware of text messages that Jennifer McCabe was sending to others in a group chat talking about you in that interview?
No.
You were never told or became aware that she sent text messages to a group as she listened in on your interview?
No, I don't think she could listen in. She wasn't anywhere near me.
You weren't aware that or are you aware as you sit here that she sent a text message that said she's telling them everything, all the stuff?
Sustained.
Have you ever been provided a text message or told about a text message that perhaps Jennifer McCabe was sending to a group?
No.
Listening to your suggesting that she was listening to your interview?
No.
The third time you told your story was later that night in a telephonic interview. Is that right? With Trooper Proctor?
I requested to speak to Trooper Proctor because I had remembered the very first time I spoke with Karen that morning, and I wanted to make sure it was recorded.
Okay, that wasn't my question. My question was, did you have another telephonic conversation with Trooper Proctor, yes or no?
You said that night, but it wasn't that night.
When was it?
I think it was earlier that day.
Okay. Meaning, but it was after the interview with Trooper Prince.
I don't think so.
Think it was beforehand?
I think it was beforehand.
You were still with Jennifer McCabe when that call took place, correct?
I was in her house. I was not with her. I stepped away to speak to him by myself.
In her home at 12 Country Lane?
Correct.
Who else was with you other than Jennifer McCabe in the house?
Her sister was there writing down the timeline for
Who's
us.
that?
Her sister, Denise.
Denise? So she was scribing the timeline as you and Jennifer McCabe were creating
She
it?
was writing it down as we were remembering things.
Right. And the three of you were doing this together, sort of communally.
Yes.
She would say something, then you would say something, then it would spark something that she would say, and back and forth, correct?
Yes.
How is it that Trooper Proctor got a hold of you? Did you call him or did he call you?
I think he was on the phone with Jen, and I asked to speak to him.
So Trooper Proctor got a hold of you through talking to Jen McCabe.
Well, I asked to speak to him, but yes.
Right. Was that interview recorded, to your knowledge?
I don't know.
The fourth time you met with police was February 2nd, the very next day, at about 12:08 p.m. Is that right?
I don't remember.
Do you remember signing a consent form for your phone?
Yes.
Was that the next day after this interview with Trooper Prince and Trooper
I don't know
Keith?
what day it was. It was right after Karen was arraigned for the first time. Jen and I met with them and both handed our phones over willingly.
So you just answered my question. So when you met with police, whatever the date was, it was a few days later, you met with police. You had a fourth time, you were still in the presence of Jennifer McCabe when you met with police.
Yes.
And handed your phone over, is that right?
Yes.
She handed her phone over, is that right?
Yes.
And the two of you were together when you signed your consent forms, is that right?
Yes.
The fifth time you told your story was in front of a grand jury, is that right?
I don't know.
Do you remember testifying in front of a grand jury?
Yes, I do.
Okay, let's talk about that for a second. Before you testified at that grand jury, just physically, you were brought into an anteroom where you waited to be called by ADA Adam Lowry, correct?
Yes.
Who was in that anteroom with you just before you gave your testimony?
My husband and Jen and Matt McCabe.
So Jennifer McCabe was with you yet again just before you gave official testimony under oath concerning this case and concerning the incident.
Correct.
Ms. Roberts, when was the last time you've spoken to Jennifer McCabe before you testified in this trial?
In this morning.
Did you discuss your testimony?
No.
So you and Ms. McCabe, who became friends because of this incident,
Correct.
talked as recently as this morning before your testimony.
Correct.
And your testimony now is that you did not discuss anything about what you're doing here
No,
or what you're going
I
to
did
testify
not. She
to.
called to wish me good luck today.
When did you talk to her the last time before this morning?
I don't know, maybe a couple days ago. I don't remember.
Within days of you taking the stand yesterday, correct?
Yes.
Did you ever?
Yes.
Ms. Roberts, I'm going to ask you. To take a look at, actually, let me ask it a different way. Did you say that you did or did not recall texting with Jen McCabe during the course of that January 29th interview with state police? Do you recall that or no?
No.
Okay.
During the interview, I didn't text anybody.
Okay. Are you saying you didn't text anybody or you don't recall?
I don't recall. I don't think I had I wouldn't be texting somebody if I was being interviewed by the state police.
Right. Okay. Would it refresh your recollection to take a look at a report of text messages?
Sure.
May I approach you?
Yes.
Thank you. So, may I, Your Honor?
Yes.
Take a look. There's two tabs. Take a look at the tabs and the data across the two tabs, if you don't mind.
Okay.
Absolutely. Absolutely. I'm in a rush. May I?
Yes.
Take this back? Well, with court permission, Mr. Brennan,
Okay. Jurors, feel free to stand up and stretch if you'd like. And I forgot to tell you, anytime we're at sidebar, please feel free to stand up and stretch, okay?
That was quicker than we thought, Judge. May I
Okay.
proceed?
Yes.
Okay. Did you take a look at this document?
Yes.
Does that refresh your recollection that there were two text messages at around the time of your interview with those two troopers?
No.
Do you recall, as you sit here, texting Ms. McCabe that the state troopers were arriving or they're just getting there?
No.
Do you recall Ms. McCabe texting you anything back about calling me after?
No.
Okay. Did you, in fact, different question, did you, in fact, call Ms. McCabe right after the interview and talk to her?
I don't know.
have you ever testified that at the scene, Miss Reed was seated in the back of a patrol car along with Jennifer McCabe, and you were standing just outside the car, and there was an interaction among the three?
Yes.
Have you ever testified, or have you ever stated in any particular, that during that interaction, Karen asked the three of you to pray?
Yes.
Have you ever said or testified that during that interaction where you're seated, where they are seated in the back of the patrol car, and Miss Reed asked you to pray, that Miss Reed said to Jennifer McCabe, Google hypothermia?
No,
You've never said that.
I've never said that.
You testified at the grand jury on April 26th. Is that right? April 26th, 2022?
I do not know.
Right? Does that sound right? April 26th, 2022?
I have no idea.
Late April 2022, does that sound right?
I don't know. It was 2022.
You testified under oath, correct?
Yes.
Swore the same oath that you swore here.
Yes.
Tell the truth, the whole truth, and nothing but the truth, but guilty of perjury. Is that right?
Yeah.
That's what I needed. Is it your testimony that you have never said that Karen told Jen to Google hypothermia, or that you don't recall saying that?
I don't recall saying that.
Would it refresh your recollection to look at portion of your grand jury testimony from that day?
It might.
May I approach?
Yes.
Thank you.
Sure. And if you could read on to page 83 as well.
Yep. I testified. I didn't hear it, but I was told that she was asked to Google it.
You testified under oath at the grand jury that at some point Karen was in back of the police cruiser, correct?
Yep.
Objection.
No, I'll allow that question.
Does that refresh your recollection as to what you told grand jury?
Yes.
And isn't it true that at some point during the course of your testimony under oath, you said that Karen was in the back of the police cruiser?
Yes.
And then you went on to describe that Karen and Jen and I were standing outside, and she made us all start holding hands and starting to pray.
Yes.
I mean, what, the she being Karen Reed, correct?
Yes.
And at this point, they had lifted John up and taken him onto the gurney, correct?
I
That's
don't
what you
know.
described.
I don't recall.
Okay. I'm going to do this again, just so we're clear. May I approach?
Yes.
Sure. Thank you. Just a portion of the bottom of the page.
At the bottom?
At the bottom, last couple of paragraphs.
Okay. Yep, I say I think, so I'm not
I have
positive.
a question for you.
Okay.
Does that refresh your recollection?
Yes.
Okay. Thanks. Thank you. And you testified basically that you think, at least that's what you were telling the grand jurors, that you
Yep.
think that was the point at which they lifted John up
Yes.
and moved him into the ambulance, correct? Is that right?
Yes.
And then you were asked a question, what, if anything, did she, Miss Reed, ask Miss McCabe while they were sitting in the back of the cruiser that you heard, correct?
Objection.
Do you recall that?
I did not hear the question about Google being asked.
That's not my question. May I ask? May I inquire?
Just repeat that question.
Sure. Isn't it true that you were next asked by Mr. Lally in front of the grand jury, quote, what, if anything, did she, Miss Reed, ask Miss McCabe while they were sitting in the back of the cruiser that you heard, end quote. Remember being asked that question?
No.
May I approach? Yes. Thank you. Thank you. So we're going to look at lines 16 through 18.
Okay.
May I?
Yes.
Does that refresh your recollection? That was the question you were asked?
Yes.
Okay. And in response to that question, you stated, quote, at one point she asked her to Google hypothermia and how long Google hypothermia, correct?
Mhm.
I'm sorry?
Yes.
That was very detailed. You'll agree that that's a very detailed and specific recount of an event. You recounted where you were, back of a cruiser, or they were in the back of a cruiser, correct?
Yep.
You recorded or reported the time. It was right around the time that you thought they were lifting John up and scooped him up onto the gurney, correct?
Yep. I thought it was about that time. I wasn't sure.
Location,
I'm sorry, I didn't get that answer. You were talking over each other.
that's my mistake.
What was your answer, Ms.
I
Roberts?
thought it was about the time they lifted him up, but I wasn't sure.
You were very detailed about who was there. It was you. It was Jen. It was my client, Karen
Yes.
Reed, correct? Is that right?
Yes.
You were so detailed that you talked about where you were standing next to the cruiser open door, correct?
Yes.
What the others were doing, holding hands and praying. Is that right?
Yes.
And the actual words used. You were as detailed about all of that as the actual words used. She asked her to Google hypothermia and how long, and then you stopped, Google hypothermia, end quote, correct?
Correct.
You will agree, at least for that purpose, you painted a very, very detailed picture in front of the grand jury, didn't you?
Yeah.
Except it's not true, is it?
I did not hear her ask that. I was told she was asked that. In
The
the
answer to my question, Ms. Roberts, and I'm a trick question. What you told the grand jurors was not true. You never heard her, my client, ask anyone to Google anything, did you?
I did not.
And yet that's what you testified to under oath, under penalty of perjury in front of the grand jury, didn't you?
I did.
And the reason you did that, the reason that you said that false statement was because someone told you to say it, correct?
Object.
Is that, I'm going to let her answer.
Nobody told me to say it. I knew it happened at that time,
How did you
which
know
is
it
why I
happened?
said it.
How did you know it happened, Ms. Roberts, if no one told you it happened?
Because we wrote a timeline. We already spoke about
So
that.
the timeline that Jennifer McCabe helped you with, that influenced your testimony in front of the grand jury, correct? Obviously.
I was telling what happened in the back of the cruiser.
The timeline
You can answer.
you wrote,
So when you ask a question, let her answer, okay?
the timeline you wrote, with Jennifer McCabe's help, influenced your testimony to testify in front of the grand jurors to a statement that you never heard, correct?
Yes.
You were later asked about that statement in another investigation, by another investigator or set of investigators, correct?
I don't know.
Were you interviewed by a different law enforcement agency, a separate law enforcement agency from the Massachusetts State Police at any time?
Yes.
And you were told that to lie to those agents would be a crime, correct?
Yes.
Punishable by prison, correct?
I was not told that.
They asked you whether or not you heard Karen Reed ever say anything to Jennifer McCabe about Googling anything, correct?
I don't know.
Isn't it true that you told them what you've just now told us, which is, I did not hear Karen Reed ask Jennifer McCabe to conduct any Google searches?
I don't recall.
Would it refresh your recollection to look at a copy of that interview and that report?
Sure.
Can I approach?
Yes.
I'm going to ask you to take a look at the entire document, just to familiarize yourself with it, if you don't mind. Go to the front page. And don't answer anything about the document until I ask you a question, if you don't mind, please.
Sure.
Thank you. Ms. Roberts, do you recognize that as being a report of an interview that you conducted?
I've never seen this before, but
Understood. You may never have seen it, but does it remind you that that's
Yes.
a report of a conversation you had with another law
Yes.
enforcement agency? I'm going to ask you to turn to page 7 of that report. And if you look, there's a small paragraph, about 2 paragraphs up from the bottom. I think I may have put a little blue dot by it, but I'm not sure. Please read that to yourself.
correct.
Done?
Yep.
Thank you. May I approach?
Yes.
Thank you. Ms. Roberts. Ms. Roberts, does that refresh your recollection about what you told these investigators?
Yes.
And what you told them was you, quote, did not hear Karen Reed ask Jennifer McCabe to conduct any Google
That is
searches.
correct.
And you went on to say you saw McCabe on her phone.
I'll allow it.
You saw McCabe on her phone, but you did not hear Karen ask Jennifer to Google anything.
Correct.
So what you told the grand jurors was in fact false.
I misunderstood Mr. Lally's question.
Got it. Thank you.
Okay. Mr. Brennan, any questions?
Thank you. Thank you. When you spoke to the grand jury about your memory, were you trying to fool them in any way?
No.
Were you trying to,
Watch the form of your questions.
were you trying to mislead them in any way?
Sustain, watch the form of your questions.
When you spoke to the grand jury, were you honest?
Yes.
When you were asked the question, what, if anything, did the defendant ask Ms. McCabe? Did you begin your response by saying at one point?
You can show her her response.
May I approach?
Yes.
Page 83, line 19. Can I ask you to look at page 83, line 19? Just read it to yourself and the lines that follow. You done? When you were asked that question by Mr. Lally at the grand jury, did you ever say you specifically, personally heard that statement?
I'll allow that.
Did you
No,
ever
I
tell
did
the
not.
grand jury you actually heard that statement being made?
I did not.
And when you spoke to the people in that report that you looked at on page 7, did you ever tell them you specifically heard that statement being made?
No.
Were you consistent in both of those statements?
Sustained.
Did you say anything different as
No.
far as what you personally observed between those statements?
I'll allow that.
No.
And when you were asked about what the defendant may have said to Ms. McCabe or Mrs. McCabe, did you generalize your answer?
Sustained.
Did you begin your answer with at one point?
Yes.
When you chose the words at one point, what were you trying to convey to the grand jury?
I'll allow that.
I didn't know at what time it was done.
Was that a topic of conversation around the time you were brought to the grand jury?
Around the time what?
That you were brought to the grand jury to testify? This Google search.
Was it? I don't know.
Okay. Were you asked here in front of this jury whether or not you personally heard that statement?
Yes.
By me. Did I ask you that question?
No.
Did you personally hear that statement?
No.
After this happened, you discussed what had happened with people, didn't you?
I'm sorry, say it again.
After you found John lying in the snow, did you discuss what had happened, what you saw with other people?
Yes, of
Did
course.
anybody tell you that you couldn't discuss this trauma that you had been through?
I'm going to allow that.
Say it again.
Did anybody tell you that you couldn't discuss what you had just seen?
No. Did I say it again? I'm
Yeah.
sorry.
After you found John that morning, did anybody, civilian or law enforcement, ever tell you you weren't allowed to discuss what you had just went through?
No.
Did anybody ever tell you that you couldn't have support of other people?
No.
I'll allow that.
No.
Was this a traumatic event?
Yes.
Have you spoken to it to a number of people about it?
Yes.
Tell us why you would want to speak to somebody about what happened that morning.
I'm going to allow that.
I've spoken to many people, obviously, that we all grew up with. But Jen in particular, I do speak to her. I am friends with her. We went through a really traumatic experience together.
Did you ever confide in other people other than Jen McCabe about what you endured that morning?
Yes, many people,
Why?
because it helps me get through. And it's whether John's family, friends, whoever, I've talked to a number of people about it.
You're friends with John's parents?
Parents?
John's parents, the O'Keefes.
Yes.
You still friends with them?
Yes.
Do you ever discuss what happened?
Yes.
You were asked by law enforcement if they could have your telephone?
Yes.
Was there a warrant?
Objection.
Sustained, ask it differently.
Did you feel like you had any obligation, legal obligation, to give your phone to law enforcement?
Objection.
I'll allow it.
No, they asked for my phone. I handed it over willingly.
Did you think you had to?
No, but there was no reason not to.
When they went through your phone, do you know whether they saw all of your phone calls that were on that phone?
Objection.
Do you know that?
I don't know. They cloned my phone, so I assume they saw everything.
Objection.
I'm going to strike that answer. So the answer is I don't know.
What type of information did you have on your phone when you voluntarily gave it?
Objection.
I'll allow that.
Text messages, phone calls, call logs, pictures.
You said that you stayed friendly and still are friendly with Peggy O'Keefe and John Sr.?
Yes.
At some point, at times, do you try to help them with things?
Daily.
Do you try to help them with the children?
Objection.
Sustained.
Well, you were asked about contacting the district attorney's office about replacing a Ring camera.
Yes.
Whose Ring camera was that?
It was at One Meadows where Mr. and Mrs. O'Keefe, John's parents, are now living.
What motivated you to call the district attorney's office about the Ring camera?
Because we knew the Ring might be some sort of evidence that they didn't want to take the camera that was not working down without permission.
Do you have a Ring camera?
I do.
Do you know if there's a difference between the actual physical camera and the iCloud storage that keeps the actual video on it?
I don't know the difference.
Okay. Did you ever ask to replace any hard drives or storage, or were you asking to replace the camera itself?
Just the camera.
And that was in March 7, 2023?
I don't know when.
You were asked questions about what the defendant said that morning when you were trying to help Mr. O'Keefe.
Yes.
You were asked whether you heard any comments about her, from her, about dropping John off.
Say that one more time.
You were asked whether you heard any comments about her saying she dropped him off.
In the car on the way to the hospital. Okay. She said it to Mrs. O'Keefe.
When you were outside trying to help John, were you ever told where the defendant dropped John off?
No.
Were you ever told where he was left?
No.
Was it ever suggested that he went into 34 Fairview?
No.
Was it ever suggested that he went into any house whatsoever that morning?
No.
Were you ever asked to go into the house to look for him?
No.
When you were being interviewed by law enforcement, did you ever refuse to be interviewed?
No.
Were the interviews all the same or different?
They were all different. They were all different.
Were you ever asked to give a complete review and detail of everything that you knew?
I was just asked to tell me the story of what happened that morning.
And at some point when you were interviewed, you were asked about the phone calls that the defendant made to you that morning at 5 o'clock.
Yes.
When you received those phone calls, Jennifer McCabe was not on the line, was she?
No.
Was she a party to the calls?
No.
Did she influence your memory in any way about the words that the defendant spoke to you that morning?
Objection.
I'll allow that.
No.
Do you have a clear memory of what the defendant said to you on the morning of January 29th, 2022 at around 5 in the morning when she first called you?
Yes.
Is it your independent memory?
I'm saying.
Is it
sorry.
your independent memory?
Yes.
How well do you remember it?
Objection.
Sustained.
Tell us what you remember her saying to you.
Objection.
I'll allow it.
When she first called, she said, John's dead, Carrie, and hung up.
And she called you back.
She called back.
When she called back, was there any other party on the line other than you and her?
No.
What do you remember the second time that she called you?
Yes. She said, John, I think he got hit by a plow. He did not come home last night. He would never not have come home. I wasn't supposed to stay in Canton, and Kaylee was here. He would never leave Kaylee by herself.
Did anybody ever ask you to lie
No.
or exaggerate?
No.
Would you?
Say that?
Would you?
No.
Sustained.
You were asked whether or not you told people on January 29th about the missing pieces to the defendant's taillight. And you began to say you didn't tell anybody that morning.
I didn't think it had anything to do with John. I didn't want to point fingers at anybody
Why not?
because I had no idea what had happened to him. I wasn't going to point fingers at his girlfriend.
Was it, in fact, broken with missing pieces that morning?
Yes.
You saw the ring video of you and Miss McCabe and the defendant going into John's house?
Yes.
Had you seen that video before today?
Yes.
Had you been shown it before in
Yes.
other proceedings?
Yes.
When you went into the house with Miss McCabe and the defendant, did you do anything before you went into the house, actually in the house?
When
You take
we took off our shoes
You took off your shoes?
Jen and I both took off our boots
Why did you take off your boots?
because you had to take off your shoes to go into John's house.
Well, you say you had to. Explain to us a little bit of the background on that.
John was a neat freak. You were not allowed to wear shoes in the house.
Had you ever worn shoes in his house?
Oh,
Had you ever seen anybody wear shoes in his house?
no.
You and
They
Miss
do
McCabe?
now. They do now.
You and Miss McCabe took your shoes off?
Yes.
Did the defendant take her shoes off?
She did not
How do you remember that?
because Jen and I were standing there for about a good 2 minutes trying to get our boots off, and she had already gone in the house.
Do you know why you were called that morning?
No.
Did you volunteer to be part of this
Yes.
after the call?
Yes.
You had said you thought that you looked at the taillight before you went into John's house.
Yes.
Do you remember actually seeing the tail light that morning?
I do.
Was it simply cracked?
No.
Do you know that the portion of the ring video from when you came out of the house with the defendant, Miss McCabe, do you know that that portion is missing?
Objection.
Sustained.
Have you ever seen any ring video depicting when the defendant was showing you her missing pieces of taillight that morning?
No.
Despite no video, are you certain that you saw it?
Say it again.
Are you certain that you looked at it with the defendant that morning in that driveway?
Objection.
Sustained.
I'd like to play clip 3, please.
Okay.
Objection.
Okay.
Quiet, folks, still on the record.
I was going to skip this one, but Jen came in, so I popped in. Hey, Jen.
I was going to skip this one, but Jen came in, so I popped.
And it looks like it's over. Almost time for lunch, though.
All right, go ahead, Mr. Brennan.
When you first got to John and you were trying to save him that morning, do you have a distinct memory of it?
Yes.
Counsel had asked you if it was your story. Was this a story?
Say it again.
Was it a story that you told?
A story?
Yes.
It's what happened.
Do you wish it was just a story?
Objection.
Sustained.
There's no further question.
Okay, so recross.
Just asked. Just a few minutes ago. Did you ever say that you actually heard that statement about that Google search? And you said no.
Correct.
The question that was posed to you by Mr. Lally was, what, if anything, did she, Miss Reed, ask Miss McCabe while they were sitting in the back of the cruiser that you heard?
Right.
Correct?
I misunderstood the question.
And you misunderstood that question?
Yes.
What
I
did you
did.
misunderstand about that question?
I didn't know it was that you heard, so I was explaining what happened in the back of the car.
I see. So you just ignored the part, literally, the part of the question where he said, what did you hear her say? That's what your
The word
testimony
was
is now?
heard, and I didn't hear it. I obviously got the question wrong because I did not hear anybody ask about a Google search.
Well, I know that's what you're saying now. I get that. But when you were asked, what, if anything, did she ask Miss McCabe while they were sitting in the back of the cruiser that you heard, your immediate answer was, at one point, she asked her to Google hypothermia and how long dash Google hypothermia, end quote. Correct?
Correct.
That was your answer.
Yes.
Correct?
To a question I misunderstood.
And that was a false statement, wasn't it?
Technically.
Technically?
Yes,
It's like being a
technically.
little bit pregnant, Ms. Roberts.
Okay, so remember, jurors, I said earlier, comments of counsel are not evidence and you're to disregard them. Ask a question.
Thank you, Your Honor. What do you mean technically?
Technically, I was under oath and I did not hear Karen asked Jen to Google it,
And yet under oath.
but I
you-
knew it happened at that
And yet
time.
under oath, you said you did.
Correct.
And that was a lie, correct?
Objection.
Was that a lie? Did you lie?
I did not intentionally,
But you did.
And,
not intentionally.
okay, that's the end of
Understood
this.
the question, Mr. Jackson.
All right, is there any other question or is that it?
I didn't hear what you just said.
I said I misunderstood the question, Mr. Jackson.
That's what you're saying now, correct?
That's what happened.
All right,
Can I ask one more question?
okay.
In that quote, you said, at one point, she asked her to Google hypothermia and how long. Then you corrected yourself and finished with Google hypothermia. What did you mean by how long? What were you about to say?
I don't recall.
Had someone told you something about a phrase that started with how long?
I don't recall.
Hypothermia?
I don't recall.
Like, for instance, how long to die in cold?
I don't recall.
Okay. All right, Ms. McKay, I'm sorry, Ms. Roberts, you are all set.
Thank you.
May I?
Yes.
I'd like to play clip 3, please.
Your Honor, before this is played, is it possible to take a quick break so we can review this? There's a lot of clips. I'm not sure what this is. I'd like to see it before it's played.
All right. How long a clip is this?
Probably about 10 seconds, 15 seconds.
All right. Jurors, we're going to ask you to take a break, and we'll bring you back in, and we'll see you at 10 seconds. All right, we'll give you a 5-minute break.
That's fine. Thank you, Your Honor.
Court, all rise, please. Jurors, close your books. Follow me.
So we're going to bring the jury out so the defense can view the clip. Then we're going to bring them back so they can view the 10, 15-second clip. And then they're going to go to lunch. Right, Jen?
That's what's going to happen. Oh, I'm just so disappointed that Carrie admitted to a lie, but she didn't lie. She answered a question that she misunderstood. A lie is when you intentionally make something up or distort fact. And this is what bothers me is just the fact she said, well, yes, technically I lied. He literally gets to put that now in his closing. And Carrie Roberts, you already heard her. She lied. She said she lied.
Yeah,
and
that's the problem with unclear
terrible.
language. I mean, she says, well, I guess I lied, but I didn't intentionally, which is a lie is intentional. So if it was unintentional, it's not a lie, which is what you're saying. But yeah, it's at this point, it's just gamesmanship, right? It's not an actual effort to get to the truth. That's the most disturbing part of it.
Well, and that's what he's charged with doing, is making these witnesses look like they're not being honest. And he is as honest as the day is long. You know, when you are interviewed 4 or 5 times, I think they went over 5 different times. It's so hard because if an investigator asks a different question, you're going to answer that one. So it's not that you're changing your story, you're adding to what you said before based on questions. And that's what happened here. You know, we're hearing questions that have never been asked, and so she's discussing them.
And so if Jackson, to your point about Jackson using that in closing statements, what would the impact of that be on a jury? So the jury watches Carrie, and presumably was impressed by her as the last jury was. And then Jackson gets up and says, she's admitted she lied. Doesn't that make the defense look a little shysterish to the jury?
Well, not if anybody from the jury believes she was lying. Of course, he's also trying to paint her in the corner as being some nefarious co-conspirator with the rest of the individuals, you know, that covered up this murder plot, supposedly, right? Now he's finally been able to wrangle her in. Remember, in the first trial, she was clean. She didn't even know Jen McCabe. And so, but to another point, anybody watching this would say, listen, she could downplay, she could lie, she could say she really isn't good friends with Jen McCabe. Nobody would ever know. They're not going to get her record subpoenaed in time. She is being honest, whether it's good, bad, or indifferent. And I do appreciate, hopefully, the jury seeing all of that.
Yeah, I thought Carrie was incredibly good witness, very intelligent, could see where things were going. What did you think about going after the communications with the witness advocate and the district attorney?
You know, I think that they're just trying to paint that what she says has been influenced by Jim McCabe, by the DA, by the witness advocate. But at the end of the day, obviously, if you're doing your job as a witness advocate, you're going to be talking to them constantly. This is, that's their job. And secondarily, it's the job of a prosecutor to pre-try, we call it pre-try their witnesses. You're going to want to know, How do they come off? Are they, remembering everything? Are they a good witness? Are they not? He's made specific choices this time. Remember, Lally put up, I think, 4 EMS people. He put up a police officer. We may see more. I don't know. But he's trying to figure out who are the best witnesses to tell I'm going to say the word story
Right.
too. It's not a fable.
But this was not
It's a
Lally
story.
talking to her. This was the witness advocate, who's not a
Oh, I
lawyer, I
know.
don't think. And this was the district attorney, who's not
Right.
trying the case.
No, I agree. I think he was trying to paint that. The witness advocate has to talk to her. And the fact that she talked, I think, did she say one time with the DA himself?
She didn't really give a number, so I think it was maybe more than one. And as she tried to suggest and got objected to, most of those conversations were probably about witness intimidation and not
And
about had nothing to do with the sharing of evidence. But so let me just ask you, as a former FBI agent, you obviously understood the idea that no ongoing investigations should be discussed with anybody outside the investigators. But how realistic is that in the real world?
Well, first of all, discussing it with the DA and the victim's advocate, just to be clear, that is not outside of the investigation. That's who you're supposed to speak with. Investigators.
But not about evidence, right? Or certainly not about things that she could be feeding to Jen McCabe or so for instance, she did say that she took questions from Jen McCabe to the district attorney, or I forget if that was to the district attorney or to the witness advocate,
But that's why they needed to specify. I believe those were questions concerning being intimidated.
it could be.
The harassment and intimidation. And remember the last trial when Alan Jackson opened the door, which he opened the door wide open for that question because he said, "What did you talk to him about?" And she said about all the intimidation, and the judge closed the door. And I think that was so very wrong. She should have been able to answer so that it was clear. And I wish Brennan would have brought it up again with her. To be clear, you weren't talking about this case. You were talking about another case involving witness intimidation. That's the question that should have been asked.
I mean, I agree, except I wonder, so I'm getting a sense of just how thorough Brennan is and how anticipatory he is. He may have wanted to end that discussion because he may, look, in the real world, it's not unusual for someone, if let's say you're the witness advocate and you're developing your connection to all these witnesses, you live in the same community as them. And the fact is that there are law enforcement people involved in the case. So is it really that unusual that he might pass on some information? I'm not accusing them. I'm just saying, would it be that unusual?
Well, a victim witness, those individuals don't even have the information. As a case agent, what you have to do, at least in the FBI, you have to put in what we call an EC and ask for a victim witness advocate to be appointed to the case. And then they open up a case and keep their own line of communication and, documentation. So in this case, when one is appointed, their role is so different. They're serious. They're actually counselors. That's their role. In other words,
their ideal role. Yeah.
If it's a free counseling service, those individuals, I could tell you, at least in the Bureau, I don't tell them what's going on in the case.
Mm-hmm.
They don't know the investigative steps. They're completely separate from that. Because that's not their role. Their role is to listen and to help the person through it, kind of a free psychiatrist or psychologist. That's their role. And then also, to a degree, at least let the individual know, yes, the case is being pursued, or yes, it's under investigation, so the people aren't in the dark. But they don't disseminate facts, and they don't know the facts. These individuals are so busy with multiple victims and witnesses, they don't get into the weeds of the case at all, typically. That's the way it works.
And I do think it's obviously going to be everything is done at a higher level with the federal, especially the FBI, where you have more rules in place. It's less local oriented as a local crime normally is. You have better lawyers. And so it's not surprising that that would be your experience there, which also highlights the fact that what we seem to be a very irregular relationship between the feds in this case and Karen Reed's team, where they actually were giving them more information.
Yes.
Question for you real quick, if we can get it in. This is from an retired FBI agent. Why didn't Josh Levy's witnesses, why didn't they have a witness advocate? So you can think on that and get back to us.
Okay.
All right, Mr. Brennan, whenever you're ready.
I'd like to play clip 3, please.
When my car was seized, there was a few small pieces of taillight missing that I had picked out at John's at 5:45 before we drove over to Fairview. I'm showing Terry, look what I just did to my light, and I'm worried that there's gonna be some kind of electric short circuit. There's like the bulb is showing, and some of the red plastic's missing. So I picked pieces out of the light housing that had kind of collapsed within the light and dropped them in John's driveway.
I'd like to have that marked as an exhibit, please.
Okay.
No objection.
Right. All right. Rather than calling your next witness, who it'll take 10 minutes to bring a witness in and do all of that.
Yes, Your
Why don't
Honor.
we take the lunch and recess? I'm sorry, is the food here? Okay. Folks, we'll take a 40-minute lunch and recess, okay?
All rise for the court, please. Jurors, close your books, put them on your chairs, and follow me.
So, Jen, if we could go to that question, which, just to remind the audience, was why didn't U.S. Attorney Josh Levy have a witness advocate for their witnesses? If he didn't, and I don't know that he did or didn't, but doesn't seem like he did. Oh, I got the wrong Jen in. There's a couple of Jens in here. Let me, Jen, did you hear that?
Yes. Was the question as to why did Josh Levy's victim witness advocates not help the witnesses? Is that what the question was?
It doesn't seem like they were even assigned a witness advocate for the federal grand jury.
I'm going to answer that because in my view, first of all, when you have victim witness advocates isn't when you're in a grand jury investigation trying to figure out if you're going to charge. It's after, after
that makes sense. Yeah.
the crime occurs, after you have everybody outlined who needs one. And again, it takes some paperwork, right? You specifically are going to point out. And then you really have little to do with the victim witness advocate again, and they have little to do with you. In other words, you're not asking them, how's it going over there with that witness? None of that happens. It's so confidential.
Right. And there was obviously a lot more communication in this case here between the witnesses and the DA's witness advocate and even apparently the DA himself. And that's because of the mob that was stirred up to go after them.
Oh,
and as we,
yes.
And we're seeing that now today, this mob last night and today going hard after Carrie Roberts, who was not connected, didn't know the Alberts, only met Jen McCabe once before this. She is in no conceivable way part of a conspiracy theory involving her best friend, John O'Keefe's murder. And yet they're going after her like it's the most important thing in the world to destroy this person's life and their credibility. This is the other side. This is why I get annoyed by false equivalization. The other side, at least I'm not saying everybody on the other side, but the content creators, the main people covering this case, and the main people speaking up on this case in social media truly are cruel.
Yeah, they are cruel, especially when you really consider that the court of public opinion should be irrelevant right now. It should only be about these 18 jurors that are listening to this. So why on the outside try to discredit and stir up dirt on Carrie Roberts? You know why? Because they wanted to infiltrate the 18.
Yeah, they absolutely, and she is the most unimpeachable of the witnesses because even if you want to buy into the possibility of this grand conspiracy theory involving investigators and McCabe's and Alberts and stuff like that, she's not connected to any of that.
Yeah.
She's not from Canton. She didn't grow up in Canton, so.
Well, she said she was from Canton, but the
She
other
lives there
side of
now, yeah.
Canton. Oh,
Yeah,
okay.
she lives there now, but she grew up in Braintree, I believe, with John.
Oh, I see. And to your point with that, her only connection came afterwards. So in other words, whatever was said and took place was before their relationship existed.
Yeah. Yeah. All right. So what did you think? From what you saw today, if you're scoring this, not that we should be looking at it that way, this is a more, obviously a very serious case, but how are you scoring this? Good for the prosecution or good for the defense so far today?
Well, I will say that round one with her testimony, it was an A+, hit it out of the park home run because the defense they weren't even prepared to cross. Now you can see they have done hours and hours of review of every word she said and everything she's done. And, obviously they were very well prepared. So I can't give her a hitting it out of the park because he got her to say that she lied, for heaven's sakes. Although I think they pretty much cleaned that up to anybody with any common sense. But I still think it was a triple. She does a good job of getting out these keywords. John's dead at 5 a.m.
Yeah.
And that is just, you just can't erase that. And hopefully the jury won't forget that.
Did the prosecution miss, or could they have found a better way to highlight the fact that Karen showed Carrie and Jen her taillight pieces? I mean, they did do it, but the objections kind of halted it. And then the video clip that they played did it a little bit too. But I felt like it wasn't as clean and as clear. Like if this was a movie or a documentary, you'd want it to flow a little more clearly so that because normally Hank is very good at creating that emphasis. And Alan Jackson is supremely good at it.
Well, Alan Jackson objected and wanted to see it. So you're right. He absolutely put a chasm between the point being made and the point maker, which is, to your point, the flow was stopped. But remember, these exhibits get to go back to the jury room with them, and they're going to get to watch that over and over and over again if they want. And I think that's the most important thing, that it gets to go back. But I wanted to comment, did you see Karen Reed's face? Oh my gosh, it's quite
during the playing of the clip of the audio?
Yes. Yeah. And I was trying to read Alan Jackson's words. I couldn't hear he said something to her twice. I didn't read his words, but I read his mind. You idiot.
Well, he should be saying it to himself because he was sitting in the room with her.
Oh, they loved the showmanship.
Yeah, all three of those lawyers were with Karen when she made that comment to Gretchen Voss. And so they all should be looking at themselves. David Unetti was looking down guiltily and playing with his yellow cottage tails tie.
Well, I've always said that if she's convicted and this goes to appeal, she has so many appealable fronts when it comes to Sixth Amendment because of, in my opinion, her waiving the right, just bad counsel by them to let her speak to the media over and over and over again. And how about the statements that they made sitting right next to each other? Who do you think did this on the courthouse steps with her attorneys? You know who did this. We all know who did this. Yet on tape, she said, none of us know who did it. It's none of us to answer. Remember that?
Could she, if she's convicted, could she win a new trial based on ineffective counsel? Is that something on the table?
I personally think she could, because now you already have on record them lying to the court. Lack of candor, lying to the court, and Rule 14 violations twice. Once in the first trial, they were found of Rule 14 violations and verbally sanctioned about the dog bite doctor. Remember how they produced that late, and you remember him lying then and saying, well, she contacted me. Well, actually, And then the Canoni said, wait a minute, I thought you said it was the other way around. And he said, oh, you know, potato, potato. Does it really matter who contacted who? And then now we have the much more serious situation with ARCA. And even though she took them at sidebarred only and said, hey, are you still okay with these guys? Because in federal court, my opinion is they would have been kicked out. They would have been held in contempt of court. They would have been seriously fined. He would have lost his ability to practice in Massachusetts, which isn't his jurisdiction.
Yeah.
I'm stunned, but I always have to remember I'm looking at this through a federal lens, which is much different in a sense than most state and local courts. It's just not to that degree.
Yeah, absolutely. So you got a question up here that is Gretchen Voss pro Karen. Now, you and I met Gretchen Voss. That was the first time I met. We all met together. And I think Gretchen Voss has made pretty clear that she began investigating this story because a friend of hers suggested there was something really interesting going on in this Canton story. So she was one of the early reporters on it, probably the first mainstream reporter on it, and still has done kind of the best reporting on it yet. In that one article was really in depth. And I think she started out just neutral and objective. And she met with Turtle Boy, spent time with him. She met with Karen Reed and spent a lot of time with her. And it was, I think, just over time trying to check out versions of Karen's story that she realized Karen wasn't telling her the truth. And also seeing some of the interaction. I don't want to put words in Gretchen Voss, but, you know, seeing some of how Karen behaved at her parents' house. I think it was at her parents' house when she was showing Gretchen a shrine that Karen of pictures of John and this and that, but it's all stuff that she puts up and takes down when the reporter leaves. And Gretchen got that sense. So I don't think Gretchen Voss went into this pro or anti-Karen, but I think now she's, although trying to be journalistic, she is probably anti-Karen.
Yeah, I mean, what happened with Gretchen, you, Matt, myself, I'm not going to put Kate in that category, but all of us started out looking and saying, geez, is there public corruption here? What's going on? What's everybody clamoring about? And going into it completely objectively, I mean, I'm a victim's advocate, as you know, that's one of my most important things that I do now is advocate for victims in many arenas. And I thought, oh my gosh, if somebody's being railroaded or you know, if there's corruption, I'm going to be all over advocating for this woman. Well, the problem was when I looked at all the facts and all the court documents on both sides, the story was blatantly clear from a factual standpoint. And you did the same thing too. You started out and you still are very, you know, you're not sure about, you know, public corruption issues, federal issues. You know, you come into it with a very keen eye for that, let's just say. And
I'm neutral. I come in it from like, I know nothing.
Yes.
I'm Sergeant Schultz. I'm Sergeant Schultz on Hogan's Heroes knew nothing, but didn't want to know anything. I'm only half a Schultz. I know nothing, but want to know. So nobody gets the benefit of the doubt for me, whether you're a cop or a robber, you know? So I don't know. So I try to just ask the questions.
And Matt was the same way. I was the same way. And Gretchen Voss was the same way. And then Gretchen, the more she dug, she's an investigative journalist. By the way, I think she is so sharp. I really, really like Gretchen. And the problem was the more she dug and the more she looked at facts, the truth came clear to her. So her story that I think a lot of people thought might go in one direction ended up going into the direction of truth.
And that really pissed them off. Yeah.
Yeah. And that's exactly right.
Yeah. This is Gretchen Voss's article from Boston Magazine in September of 2023. It was, as a writer, I can tell you it was brilliantly written because it's really hard to know the chronology of how you want to tell a story because it's not the same as the chronology of in the order of events happen because you want to put some stuff in the early part of the story that hooked the reader. And so you're going to insert some stuff that would intrigue people thinking there might be something unusual here. But in the second half of the story, she ends up debunking most of the conspiracy theory. And I don't think she expected to do that when she was writing it. It's just the integrity of her journalism, you know?
Well said.
So just quick thank yous. Thank you to Andy. Thank you, Allie, for your donation. Claire Marie, thank you for your very generous donation. And thank you, Maria. Love to watch the channel. Thank you. Appreciate it. So I'm here with Jen Coffindaffer. Her channel is Breaking the Case with Jen Coffindaffer. I apologize for Kate not being here, and probably Matt is the same issue because did the same thing with, well, they got the same email that I sent you, Jen. So apparently I did put in the wrong link. So that's why Kate's not here. She called me during the break. So hopefully we'll have Kate after, but it's my fault that Kate's not here. Sorry, guys. I'm a Luddite sometimes.
And of course, I'm like, ooh, I better get a hold of Kevin.
I'm glad you did. Yeah.
Came after you, came searching you down, because it really is important, I think, for all the viewers from all of our different channels. And I don't know if you saw this, but apparently 120,000 people on all the channels, right? Court TV, Long Crime, ABC, whoever's linking this, 120,000 people are apparently watching it. That's what one of my viewers wrote. And I only have, I don't know, at the most 60, 70 people on watching. But my point was, great. I want to see all those people hopefully seeking truth like Gretchen Voss did and like you did, and advocating for John O'Keefe, hopefully. So I was glad to see those numbers. And like I always say, I'll take quality over quantity.
Oh yeah, absolutely. It's same. Yeah, we have so because I've been covering it for a while now on the streaming. There's a few more people here because they get to comment in YouTube where more people are. But it's still way under the numbers that the Karen Reed channel people get. So like I said, quality over quantity any day of the week, and you just pursue the truth and don't worry about the numbers. That's what a real journalist does. That's what Turtle Boy does. That's why Turtle Boy is not a real journalist. Just pursue the truth. Even if you get something's wrong, at least you're trying to get to the truth.
Yeah, I think so. And the other thing, I know you're the same way on your channel. I don't discourage people who think differently. We encourage everybody, our mods, all questions. There's no dumb question. Some of us have been following this and know virtually every detail, and some people don't know anything. And I love to hear questions, and nobody's going to be made fun of, or, and if somebody comes on and say, you disagree, we say, we appreciate your POV, tell us why. And so hopefully, I think we offer that, Kevin, a very neutral and inviting and friendly channel.
Yeah. And all right. So let's take our lunch break. Are you going to try to be back with us at all after lunch?
Yeah, I am. I have News Nation a little bit later, but yes, I'll be here after lunch.
All right. And just so I'll remind us again then, but I won't be here tomorrow, but I will double check the links to make sure that Jen and Matt have the correct links for tomorrow. And Kate will be running the show, all these, or at least my show and her channel she'll be running it. So she will make sure Jen gets in and Matt get in and stuff. I won't be able to really do anything during the day tomorrow. And then Friday, it sounds like, I don't know, it was a little confusing. Like they had a crime scene visit planned for the jurors in a half day. I think that's it. There was some back and forth. They might do the voir dire on Friday, but now I think the voir dire is going to be Monday. So I think Friday still will be a half day for the jurors. That was my understanding, but it was a little confusing.
It is. Okay. I thought voir dire was Friday. I need to relook at that, because for me, I do not want to miss 1 second of that real time.
Yeah, I don't either. I think it's going to be Monday now, but again, it was a back and forth before the jury was brought in today. That seemed how it played out to me. So we'll get some clarity on that by the end of the day.
Well, and really quick, to leave the cliffhanger, the afternoon session is going to be Peggy O'Keefe. I would expect almost zero questions from the defense if they're smart. They will not want to beat up Mama. I think it's a brilliant move to have Peggy on in lieu of Paul, only because And I think Peggy, I don't know if Peggy was up to it in the first trial, but the fact that she's coming forward for her son and knows just as much as Paul knows, and now we know was on scene earlier and things like this, it makes a lot of sense to have Peggy on.
Yeah, it's unfortunate that she has to go through it, but I think she wants to go through it for her son. And you can tell that this is a very strong woman. This is a very, very strong woman. When I was in Dedham for the first time for a hearing, this was in August, so after the first trial, and there were hundreds of people there. There was probably 500 pink shirts and 100 blue shirts there. And the O'Keefe family arrived and went up the side ramp. If you remember the way the courthouse is, Jen, they didn't go up the front stairs. They went up the series of side ramps to get in. So they had to go through the blue crowd. The pink crowd saw them coming and booed vociferously. But the O'Keefes were buoyed to see the supporters that Kate put together. Kate was primarily responsible for that. And they were cheering the O'Keefes, and they were really heartened by it. And Peg gave everybody a fist pump. She was pumped up. So she's a very energetic woman, very, very strong woman.
Really quick, I wanted to say that one of our devout listeners, Carrie Roberts, has said, sure enough, Monday is the voir dire, and it's a half a day on Friday, as you mentioned. So I just wanted to restate that for everybody. And there was one other thing I was going to touch on that I thought was important before we go to lunch. And that, I wanted everybody, if you want to see what the blogger has done to Carrie Roberts so far, I posted one of his clips on my Twitter while I was listening. So take a look at what the blogger, how he's treating Carrie Roberts, and yet, she's standing strong.
Yep. She's another strong woman. Yep, absolutely. Strong, intelligent woman. That's the best thing I take away from this case. They're everywhere.
Thank you, and we'll see you after lunch.
Okay. Thanks, John. Thanks, Jen. I'll see you then.
All right. Bye-bye.
Okay, guys. So, thanks. I am going to take my own lunch now. Thank you for being here with us. So I don't know. I'm not sure. I'll be back by say 1:45 because the lunch started at 2:50. So I'm not sure if they'll go all the way to 2. Yeah, Brian. She won't say his name. All right, guys. So we will see you shortly. Enjoy your lunch and don't drink anything yet because we got to wait until somebody gives us a chance to drink. Either Alan Jackson knocking over something or a fire truck going by.
Counsel sidebar.
All right, thank you, jurors. Thank you. All right, your next witness, please, Mr.
Thank you, Your
Brennan.
Honor. The Commonwealth calls Peggy O'Keefe.
You solemnly swear the evidence you before the jury in the case now against you the truth, the whole truth, and nothing but the truth, so help you God.
So, good afternoon, Mrs. O'Keefe. Yeah. All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good afternoon, Mrs. O'Keefe.
Good afternoon, Mr. Brennan.
Could you kindly introduce yourself to the jury?
My name is Margaret O'Keefe. I am John O'Keefe's mother.
Are you married?
Yes,
Who are you married to?
John O'Keefe Jr.
How long have you been married for?
Too long. 53 years.
I'm sorry, ma'am, I didn't hear you.
53. Long enough?
How long have you lived in the area?
We moved to Canton 3 years ago.
Before you moved to Canton 3 years ago, where did you live?
Braintree.
How long had you lived in Braintree for?
50 years?
Did you begin your family in Braintree?
No, we lived in Mattapan first, and that's where my daughter was born. And then we moved to Braintree.
Your daughter was born when you were in Mattapan?
Mm-hmm.
Your daughter's name?
Kristen.
How many children did you have?
3.
You, Kristen and John?
And Paul.
Is Paul the youngest, the baby?
The baby.
Did you raise your children? How long were you in Mattapan before you moved closer to here?
I'm sorry, repeat that?
How long did you live in Mattapan before you moved closer?
2 years.
And then the rest of the time you were in the area?
In Braintree.
Tell me a little bit about your immediate family.
My daughter. My daughter Kristen had a tumor, a cancerous tumor that she had for 5 months. And she died in November 13. She had 2 children. And then 2 months after she passed, her husband passed from a heart attack. And then you all know about John. And then my son Paul is over there.
That was 2013, ma'am. Could I ask you about her children?
She had 2 children, Kaylee, who's now 17, and Patrick is 14. And he's a run for my money.
Do you remember how old the children were when your daughter passed?
3 and 6.
When that happened, was there any plan for the children?
As far as
Or what was going to happen with the children?
when she passed
Yes, ma'am.
and when he passed,
Yes, ma'am.
we decided, my son decided to be the head guardian. And then we had, I was the other guardian, and there was Steve's brother and sister were the other 2 guardians. There's 4 of us.
May I approach you, adjust the microphone?
Yes, please.
Oh,
Thank you.
talking too soft? Okay.
Did I understand that there was a decision that John would be the primary guardian? Can you share with us how that decision came about?
Well, he was single. The other 2 guardians were married, and they didn't have children, but he decided to do it himself. And then I was the second one in case he needed me. So I was over there most of the time, like when the kids get home from school or, take them places, and then have them on weekends so he could have a break. So that's what I did.
Did other people help out in addition to you and John?
Yes, my husband was there, and Paul and Erin were there, and the other members of Steve's family.
I understand at some point John worked in law enforcement.
Yes.
Besides that, could you just share just a little bit about him with us?
He was a police officer at headquarters. And when he first started, he was in Hyde Park, and then he moved to Dorchester, and then into Boston itself, and that's what he did.
I was hoping if you could tell us a little bit about John besides his work.
He was enthusiastic with sports. He was wonderful with the kids. He took care of them and did everything for them. Take them places on vacations and everything. He was their number one, and they called him JJ.
Would you mind if I showed you a photograph?
No.
May I approach?
Yes.
I'm showing you a photograph.
Okay.
And could you tell us what you see?
That's my son.
Thank you. May I introduce this as an exhibit?
Yes.
Exhibit 16.
Thank you. With the court's permission, I'd like to publish.
Yes.
Ms. O'Keefe, do you know when this picture was taken?
Oh, I really don't know. It was in the summer of I don't know what year. I really don't know the year. But is that one he probably took him to a fair or an amusement park, and he had his picture taken there with it, and then the kids were with him too. So,
Do you know how old he was in that picture?
43, maybe.
What year was John born?
75.
Ms. Gilman, could you take the photo down, please? How old was John when he passed?
45. My mind's not working right now.
I understand. It's okay. Can I ask you a few more questions? Okay. You let me know. I want to go back to the morning of January 29th, 2022. Is that okay?
Yeah.
Were you home
I was home in Braintree.
in Braintree?
Mhm.
Who were you with?
My husband.
Did you receive a phone call?
Yes, from Carrie Roberts. It was about 6:15, between 6:15 and 6:30 in the morning.
Did you know Carrie Roberts?
Yes.
How did you know her?
She lived in Braintree for a while. John and her were friends. They went to the junior prom together. And then we found out that she moved. She lived in Canton, and she was around the corner from us, and she helped us out with the kids.
And when you were helping take care of the kids, would you often see Miss Roberts?
Yeah, because she'd take Patrick and her son Ryan places. And yeah, so I saw her all the time.
Often?
Yeah.
When she called you that morning, do you remember the conversation?
Yeah, she said John was found in a snowbank. And I didn't understand, which I said, what do you mean found in a snowbank? She said, they found him in the snow. They don't know what happened. She says he's brought up to the Good Samaritan Hospital.
So she says, I'm going to come get you and Papa because I don't want you driving. I says,
we can drive there. We both have 4-wheel drives. She says, no, I'm coming. So she came to get us. And it took a while to get there because the snow was bad. And in the meantime, I had called one of my nieces to find out because one of my other nieces worked at Good Samaritan. I just wanted to know if she could find out anything about it. And I just couldn't get a hold of her. So when we get up there, they told us to sit in this room and they would bring us down shortly. So finally they said, okay, you can go down. So we started walking down the corridor. And as I'm walking down, I hear Karen Reed yell, Peg, is he dead? Is he dead, Peg? Peg, is he dead?
and I just kept walking. And then I asked, I don't know who it was, a nurse or a worker at the hospital. And I said, what is she doing here? And she says, oh, she's being psych evaluated. So then they brought us down to the room where my son was. He's bruised up. His eyes were closed. It's just not a good scene.
Okay. I'd like to go back, if I may.
Okay.
May I?
Yep.
When Carrie Roberts picked you up in the car, did anybody go with you and Miss Roberts on the drive from your home in Braintree to Good Samaritan Hospital?
No, we were the only 3 in the car.
Who was the third person?
My husband.
During the drive to Good Samaritan Hospital that morning,
Yep.
did you ever have a chance while you were in the car to speak to the defendant?
Yes.
Please tell the jury about that conversation.
She, I asked her what happened, and she said, we went to a party. I left him there. I said, you just left him there? She said, yes, I just left him there.
Did she say whether she left him inside or outside?
No, she just said, I left him there.
Did she tell you whether or not she left him in the driveway or the street?
She just said, no, I just left him there.
You told us that when you got into Good Samaritan Hospital, you were walking down the hallway and you had another interaction with the defendant.
Yes.
And you told us that she was asking if he was dead.
Mm-hmm.
Can you describe a little bit where in the hospital you had this interaction with her?
When they took us down to the emergency room, the doors open, and there was a corridor to go down to the other rooms, and she was on the left-hand side, and that's when she saw me come in, and that's when she started yelling, is he dead, Peg? Is he dead, Peg?
So when she was yelling, could you describe her mood or demeanor? Was she animated?
She's loud, and I don't know. She was just loud, and as she was saying it.
And when she was asking you, is he dead? Is he dead? Did you again ask her a question?
I just asked the nurse, what is she doing here?
And did you speak to Miss Reed herself?
No. No.
At some point, and you and your husband got to see John?
Yes.
And
Paul
were you
was-
with Carrie at some point?
Carrie was there, and then my son Paul was there.
How did you get home?
I think I went home with Paul, and I think my husband went home with Carrie. We went back to Canton at the time.
Do you remember generally the time frame? Was it morning, afternoon, evening?
No, it was morning.
Do you remember getting home that day?
Yeah. It was snowy, icy.
Was
And-
anybody home when you
No.
got back?
No, it was just us. And then the kids started coming home. And that's when I was trying to, take care of them. And then there was a knock at the door. And it was Karen, her father, and her brother asked if they could come in. And I was just trying to calm the kids because Patrick was just out of control, yelling. And then they came in. And then he said, do you mind if we go upstairs and get a couple of her things? Which I never should have let them go up there. But at the time, I just couldn't think straight. And I really didn't have anybody else to help me keep them down in the kitchen. So I don't know what they got up there, what they did up there.
How long were they, when you say upstairs, do you know what room they went to?
I assumed the bedroom.
So I'm going to strike that, Mrs. O'Keefe. If you could just, what you actually know, okay? And Mr. Brennan can ask a better question.
Thank you. Could I lead a bit?
Yes.
Ma'am, how many rooms are upstairs in John's home?
1, 2, 3, 4 bedrooms and an office. And off the master bedroom, there's a bathroom, and then there's a closet. It's a big house.
Did you see the defendant and her father go upstairs?
I didn't really see them go up, but I knew they were up there because I could hear them.
You didn't follow them up or go to look?
No.
You didn't know which room or rooms they were in?
No, I'm assuming the bathroom and the master bed.
My question was poor. You didn't see which rooms they actually went in?
No.
How long was the defendant upstairs in John's home with her father?
I don't know, maybe 10, 15 minutes.
Did you see them come back down?
No, I did not.
When they were upstairs, what were you doing?
I was trying to calm the kids.
Both of them?
But yeah, well, mainly Patrick.
How was Patrick reacting?
He was very upset once we told him because he slept over a friend's house the night before, and he just said, I'll never see him again. Sorry.
Would you like a moment?
Mrs. O'Keefe, would you like to take a short break?
No, that's fine. Thank you.
You can just let me know when you're ready. Take your time.
Okay, go ahead.
You ready?
Go ahead.
Okay. That morning, when the defendant and her father came into your home, did you personally interact with the defendant?
No.
Was there any hugs, condolences?
No.
Did you ever confront the defendant with any accusations when she was in your home that morning?
I don't even remember her being in the house. When she went upstairs, that's the last I saw of her.
Did you ever lean over a kitchen island? Do you have a kitchen island in your house?
No.
Did you ever lean over the kitchen island and say, I think he looks like he got hit by a car?
No. I don't remember talking to her that morning.
Did you see when she left?
Nope.
Did you ever see her Lexus in the driveway?
No.
The children, who's their guardian and custodian now?
Well, there's still 4 of us. 4 of us.
Where do they live?
One in Boston, one in Stoughton, and Paul's in Bridgewater, and me.
Where do the children live?
With me. In Canton.
They live with you full time?
Yes.
You're their primary caretaker?
Yes.
Thank you.
Yeah, just a moment.
Okay.
Mrs. O'Keefe, I'm very, very sorry for your loss. I have no questions for you.
All right, Mrs. O'Keefe, you're all set.
Thank you.
Ready to court officer.
I would like to introduce 2 clips, labeled 4 and 5. Yeah, both on.
Can you explain?
Both clips 4 and 5 are on that zip drive.
Okay.
17.
There's no objection to these? I don't know what they are.
Is there a second, please?
So I guess we're going to get this interruption after each witness whenever the prosecution decides to play a clip. Even though the defense has seen all of the clips, but I guess in their defense, they would have to know the context of which the clip is being played. Although the jury's not being dismissed here, so I don't think that they're looking over the clip. But maybe they're just explaining to the judge what's in the clip. So for people that ever try to think that the Reeds have distanced themselves from Turtle Boy and his behavior, including calling this woman the C word multiple times, that's Turtle Boy's paramour, Meredith, sitting with the Reed family as their special guest right behind the parents. And they know that. She's only there because she is Turtle Boy's girlfriend. It's the only reason she's there. Now, I'm not trying to take a shot at her, but I'm taking a little bit of a shot at Karen Reed, at the Reed family. They have to own what they are and what they've done. In order to get their daughter off, which I understand parents wanting to get their daughter off, they've got people like the Glare in court and people like Turtle Boy's paramour. And, you've made that decision. That's who you're in with. So this woman, Peg, the victim's mother, who was not even called that, but who was confronted by Turtle Boy outside the courthouse. Just keep that in mind.
Short recess. Hopefully you'll get to walk right through the first section courtroom this time. Thank
All right,
you.
so there's
Court, all
going
right,
to-
please. Jurors, close your notebooks and follow me.
All right, so I'm not sure if you wanted to be here, Jen. So we're seeing the problem here now. If Hank's plan is to show a clip at the end of every witness, that's seemed like a good idea, but they're going to have a better way to handle this because you can't dismiss the jury after each witness, or this trial is going to go until August. So this needs to be sorted out. They need to get those clips that he intends to show to the defense at some point prior to this point, so they don't have to dismiss the jury each time.
Well, I would say that the judge needs to just let the clip go. Maybe they could do it as a PowerPoint for the judge
So I'll
and the defense.
watch the first one,
So
then
they
I'll
know.
hear your argument, Mr. Brennan and Mr. Jackson.
So the jury is gone, and they're going to
So
argue
Ms.
about the
Gilman,
clip,
if
I
you
guess.
play that first one, please.
They had pulled into the driveway before me, so I was presuming she saw my cracked taillight and was thinking, did you hit my son? I could sense from her that she was looking at me very warily. And then when John's nephew came home, I just wanted to see him and squeeze him. It was quite uncomfortable. I said, Dad, come upstairs to the master bedroom. I said, I think I need to leave. Because I think John's mother thinks I did something to John.
Note that she doesn't call John's nephew Patrick.
All right, so tell me why I should admit that clip.
You should admit this clip because it demonstrates consciousness of guilt. On the morning of John's death, Miss O'Keefe sees her son at the hospital and goes back to Mr. O'Keefe's home. In the driveway is the alleged murder weapon, the Lexus with the broken taillight. It's the middle of a snowstorm, and a prelude to that is there is a phone call from the defendant's father to the Dighton police looking for a ride to go in and see his daughter at the Good Samaritan Hospital. He's looking for a police ride because the weather conditions are so terrible. When the Dighton Police Department declines that ride, he gets the assistance of his son, and his son's wife pick him up and bring him to the hospital. At the hospital, there are a number of comments made. I think I hit something. There is evidence we have where the defendant, her mother, and her father admittedly discuss in different ways the broken taillight. It is an issue that is primary on their mind. In this tumultuous, grieving moment, the taillight is central between these parties. Uninvited, the defendant and her father go to the O'Keefe house without invitation. They knock on the door and they ask to come in. They go into the house. There does not seem to be any interaction, at least with Peggy O'Keefe. And curiously, they go upstairs for 15 minutes. They stay at the house for less than an hour. This is a family that's grieving the loss of their son. Less than an hour, they go back outside. Instead of leaving in the one car, they take the alleged murder weapon, they get into two cars, and they drive away and remove the Lexus with the broken taillight from the scene. That is clear consciousness of guilt evidence, removing the murder weapon from an area where witnesses can see, photograph, identify the damage. In fact, despite the other evidence about the cracked taillight in the testimony, it is a centrally contested issue in this case. The defense is already questioned and confronted, as they have a right to do, about the shape, manner, and extent of that broken taillight. The removal of it is helpful for the defendant. And so the fact that they stay for less than an hour, remove the Lexus from the scene is important. This statement by the defendant is clearly an attempt to create an excuse, a ruse, for why they removed the murder weapon from the scene. It is an attempt to suggest that she somehow is targeted. She somehow on that morning is victimized. She somehow on that morning is the intent or the object of something that is abusive from Peggy O'Keefe. And so this evidence will demonstrate a key part of our consciousness of guilt evidence on this issue, that there was no viable reason to take that evidence from the scene other than to obscure it. It was not because Peggy O'Keefe yelled at her or intimidated her or threatened her. This was, again, a central conversation between her, her father, and her mother in those early morning hours. This is what was foremost in their mind. And so that's why it's not only relevant, it is an extraordinarily strong piece of the conscience of guilt evidence. And inevitably, the defense may or may not try to provide some type of explanation or excuse, but we have a right to the full force of our proof, and this is part of it.
Thank you, Mr. Jackson.
Thank you, Honor. With regard to the first clip, which is clip 4,
That's the only one we're discussing right now.
then in that case, now that I look at it and I see the transcript, I'll withdraw an objection. I don't care. It's not, I don't agree with anything Mr. Brennan just said. It doesn't go to consciousness of guilt. As a matter of fact, I think it very clearly shows the opposite. But
Okay, so there's no objection. So there wasn't an objection until I said, is there any objection to this? And then you all came to sidebar. I mean, they were just going to play. So there's no objection to the first clip, right?
yes, correct.
Okay, so let's hear.
I made an objection to sidebar. I'm withdrawing it.
Okay, so Mr. Brennan, play the second one, please.
Yes.
And his mother leans over the kitchen island and says to me, I think it looks like he got hit by a car. It looks like he got hit by a car.
Okay, so tell me how this comes in.
Similarly, conscience of guilt evidence, the defendant making what we allege is a false statement to try to excuse her conduct of removing evidence of a crime from the scene. This has additional import. It has two facets to it. One, equally as important for conscience of guilt in the first part, as I supported for clip number 4 or 5. Secondly, it is important because we've heard testimony from Peggy O'Keefe that this claim never happened. So we now have direct testimony that she did not have a conversation with the defendant, did not make these claims to the defendant. And so while also conscience of guilt evidence, it has additional support from the previous clip.
Right, Mr. Jackson?
Thank you. With this video clip, Your Honor, it's very different. It has absolutely nothing to do with consciousness of guilt. the argument is baffling. How could that possibly be consciousness of guilt if my client is simply reiterating something that she believes somebody else said? This clip is obviously, very obviously, and strategically being used to try to vilify my client with something that's completely irrelevant. In Massachusetts, you can't call a witness just for the purposes of impeaching them. What this clip would be doing is purporting to impeach Mrs. O'Keefe, who just testified, I never said that. I never said it. I never leaned over the island counter. Never happened. So bringing this in would be used to impeach their own witness. And that's what can't be done in Massachusetts. With regard to consciousness of guilt, how does my client reiterating or stating that something that the victim's mother may or may not have said, how does that relate to consciousness of guilt? It doesn't. This is simply a wolf in sheep's clothing. They're trying to get it in because it makes my client look bad. They've just put on a very, very sympathetic and empathetic witness, John O'Keefe's mother, and they're trying to make my client, Ms. Reed, look bad by saying something what they perceive to be pejorative in a tone that's pejorative about that very same witness. He's trying to, at this point, there is no issue about whether or not Peggy O'Keefe leaned over and said something about the car, being hit by the car. He's trying to create the issue so that he can put this video clip in. It has nothing to do with consciousness of guilt.
It's not for impeachment of Peggy O'Keefe. We don't take the position that Peggy O'Keefe is lying. This is a statement of the defendant. It's in the form of an admission or a statement, which qualifies for admission substantively, not for impeachment purposes. The defendant should not be able to pick and choose which of her statements do not look good for her and do not look bad for her. She made the statements, they're relevant to this case. It's not unfairly prejudicial. It's a statement that they embraced and they chose and they publicized, and it goes directly to the issue of consciousness of guilt. Just because it hurts, just because it's incriminating, just because it's difficult for the defense is not a basis to preclude it. It is an admission, a statement of the defendant. It's admitted substantively.
If that were true, Your Honor, then they would simply put in the transcript. They wouldn't need to play the video. Transcript is one line. And his mother leans over the kitchen island and says to me, I think he looks like he got hit by a car. He looks like he got hit by a car. Sorry. I think he looks like he got hit by a car. It looks like he got hit by a car. They just put that statement in. They want to play this because of its prejudice, because of the tone that it sets. It's not in evidence at this point. The witness who supposedly said the statement has denied having said it and said it never occurred. This is far, far more prejudicial than it is probative. If they want to simply use the transcript, that's one thing. But playing this video is simply being used to vilify my client because of the tone of voice she used in the clip. That's it. That's what's not allowed. That's overly prejudicial, and it's not relevant.
All right. So what I'm going to do is I'm going to think about this. And if I decided to let it in, you can let it in first thing tomorrow morning. I'm not going to let it in now.
May I ask for a ruling in the morning?
Yes.
May I introduce the one that was not objected to?
Yes. Do you want a consciousness of guilt instruction, Mr. Jackson?
No, we don't believe that
So you're in agreement that that statement just comes in?
we're not objecting. I'm not trying to introduce it. Don't put words in my mouth. I'm not trying to.
No, I said you're, okay.
But I'm not objecting that it at this point, that it should come in.
Okay. We'll bring the jurors back and we'll do that. Tony, can they come right in or is it going to be 5 minutes? Can they come right in? Thank you.
Clip that's under consideration and just admit the other one?
Yes, and give it to me so I can look at it, please.
So
So I'm sorry, Your Honor, do you want me to leave that on there so you can look at it tonight? And if we decide to take it off in the morning?
Yes.
Okay.
Thank you. Because you can just single it out and play one, right?
It'll be over in a moment.
Okay, thank you. Chrissy.
All rise to the court, please. Jury centering. Court is back in session. You may be seated.
Hey,
Yes, please.
Your Honor, I'd like to introduce clip number 4.
They had pulled into the driveway before me, so I was presuming she saw my cracked taillight and was thinking, did you hit my son? I could sense from her that she was looking at me very warily. And then when John's nephew came home, I just wanted to see him and squeeze him. It was quite uncomfortable. I said, Dad, come upstairs to the master bedroom. I said, I think I need to leave. I said, I think John's mother thinks I did something to John.
May I call my next witness, Your Honor?
Please.
The Commonwealth calls Nicholas Garino.
Do you solemnly swear the evidence you give to the court and jury in the case now and here and to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thanks, you can take it.
Hi, stand or sit, however you're most comfortable, okay?
Thank you, Your Honor.
May I proceed?
Yes.
Good afternoon.
Good afternoon, sir.
Could you please introduce yourself to the jury?
Yes. My name is Nicholas Garino.
Mr. Greeno, where do you work?
I work at the Massachusetts State Police at the Norfolk District Attorney's Office.
How long have you worked for the Massachusetts State Police for?
This is year 10 now.
How long have you been assigned to the District Attorney's Office for?
Since November of 2019, so 5-ish years, 6 years.
I want to go backwards a little bit. Can you tell me a little bit about what you did before you began working for the Massachusetts State Police?
Yes, sir. I was a Norwood police officer for almost 11 years.
So how long have you been in law enforcement between being a Norwood police officer and a Massachusetts State Police officer?
February of this year started my 20th year in law enforcement.
Did you go to school before you became a law enforcement officer?
Yes, I went to Westfield State College, Westfield State University now.
Did you graduate?
Yes, I did.
Can you remember what year you graduated in?
Yes, it was 2003.
Did you have a particular degree from Westfield State?
Yes, I double majored. I got a major in criminal justice and mass communications.
When you began as a police officer with the Norwood Police Department, did you have to go into any type of specific training?
Yes, I went to the police academy.
And how long is the police academy?
6 months.
Generally and briefly, what was taught at the academy?
How to conduct investigations, respond to calls. They did a standard field sobriety testing week, physical training, Massachusetts law and criminal procedure.
When you began as a Norwood police officer, were you a patrol officer?
Yes, I was.
And did you remain a patrol officer for the 10 or 11 years you were there?
Yes, I was also part-time in the detail office. But
What does that mean?
handling jobs when we're off. So filling details like road construction, I'm sorry.
When you left Norwood and began working with the Massachusetts State Police, based on your prior training, did you have to go through further training or were you ready to just begin?
No, I had to go to the State Police Academy for 6 months.
After you got out of the State Police Academy, were you assigned to a barracks?
Yes, I was assigned to the South Boston Barracks for my training. And then once my break-in training was done, I was assigned to the Holden Barracks near Worcester.
At some point during your time in your career with the Massachusetts State Police, did you start to receive any type of training in the specific field?
I'm sorry.
Did you receive any specialized training at the Massachusetts State Police after the academy?
Once I got into the district attorney's office, yes.
And can you tell us a little bit about what type of specialized training you received when you were assigned to the Norfolk County District Attorney's Office?
Yes. So I was hired by the district attorney's office. I do cell phone and computer forensics, as well as I'm a sexual assault investigator. I had prior sexual assault investigator school done, and I went for digital forensics classes as part of my now daily duties.
In order to work with cell phone forensics, did you have any particular background in it at that point?
I had taken some classes when I was at Norwood PD, but I didn't have any of the Cellbrite or Axiom classes that I do now.
We'll talk about those in a minute so you can give a little more explanation. Did you ever receive a specific advanced degree in data forensics?
No, I didn't.
Did you ever receive any specialized further degree, a master's in data forensics?
No.
So your training came while you were a Massachusetts State Police officer through the Massachusetts State Police?
Yes, that's correct.
What type of courses did you take to learn about forensics?
The first one I took was Cellbrite certified CCO CCPA is their intro course that teaches you how to use the program and how to extract cell phones using Cellbrite program.
There's a couple words I want you to help us understand.
Yes.
The first is an extraction. What is, as simple as you can, a cell phone extraction?
Yes. Quite literally is plugging the phone into specialized hardware or software, and it pulls the data from that device to make a digital copy of it so that way we can load it up later to look at it.
So when you extract the phone through a download, it basically mimics the content of the phone, but it's in a different shell. It's in a different form than inside the actual phone itself.
Yes, exactly. That way we're not manipulating or changing any data while looking, because if we were to open the device, it would change data by going through the phone itself or computer.
When you plug it in, can you explain a little bit about what you're plugging it into?
Yes. So the main program and hardware that we use is Gray Key. It is, again, specialized software and hardware that once the phone's plugged into it, the software is able to extract the information if we have the passcode. If we don't have the passcode and the phone is supported, it's able to guess that passcode depending on how long, like for an iPhone, if you have a 4-digit, it could take months. If you have a 6-digit, it could take up to 35 years.
So does the phone have to be accessible to actually do that download through Gray Key? Do you have to be able to open the phone with the passcode?
No. So if we don't have the passcode and it's supported, it can guess the passcode without making the phone useless after, say, for an iPhone, I believe it's 10 passcodes.
Is it a quicker process if you do have the passcode?
Much. It would take hours to download the device, depending on how much information's on it.
How do you ensure that the information that you extract from the actual device is accurate and the same when you're making a copy? How do you ensure the integrity of it?
So with Gray Key, it produces a progress report as it goes through its process. The only two fields that we can sort of amend in that PDF that it spits out is the ID number and then the investigator name. So after the data is pulled out, it creates a hash value, which is like a digital fingerprint for that specific information. So if you had gone in and to edit or change it, that digital fingerprint would change. It would change the big long string of numbers that it attaches to that file.
The digital fingerprint, is that the same thing you're referring to as the hash value?
Yes, exactly.
And how do you ensure that the hash value of the product, the copy, is the same as what's on the phone?
You can run the zip file that it creates with the information into a hash calculator, and it will give the same hash as what is produced from the Gray Key PDF report. So if something had changed or there was an error with it, the hash would not be the same as what was given from the PDF. And that's how we know that the data is not the same.
So if you download a phone and it has a hash value, this digital fingerprint, and then someone was to manipulate the phone and remove anything, even a period, from that data, if it's run again, will the hash value change?
Yes, it would not be the same because
Even
it will
if it's
show.
just, I'm sorry, even if it's just a period?
Yes, any alteration to that initial extraction with that number, it immediately would change.
So if you have an item, a computer or a phone, and you put it through the Gray Key program, and you do an extraction, a copy, where do you store that copy of information if it's not on the phone that you originally have? What do you do with it?
So once the program pulls that information, we have to place it onto our secure server at the office, and we'll take any of the files that were given via the extraction process, and it's saved there for us.
And so you copy it on another link or another digital file?
Yes, we'll save it to the server at the district attorney's office.
Can it be put on a physical item, like a zip drive or a hard drive?
Yes.
If you put that download onto a zip drive or hard drive, how will you know if that information on the hard drive matches the same information you originally downloaded from the phone to the server through Gray Key?
Again, like I said, you could run the hash value of that file again to correlate it with the PDF that we were given once Gray Key has given us the information. So that's how you would know all the information is the same, nothing has changed.
So for example, if you download an iPhone and it has that digital fingerprint hash value attached to it, and you make a copy or multiple copies, is the way to test whether or not those copies are exactly accurate is to look at the hash value of each copy?
Yes, and copying the zip file would not change the hash value. The only way it would change is if you physically went into it and deleted information somehow.
So now that you have the item, say for example, an iPhone, and you've downloaded it through GrayKey, which is hardware and software, and it's on a digital file, can you just open it up and start reading it like a report or a book, or do you have to do something else to it?
No, once it's pulled into that zip file, it has to be opened into another program, which there are many forensic tools, but the ones at the office we use are Cellbrite or Axiom. They're two brands, and then those programs make that information readable so we can actually look at it.
So if you were to download a forensic copy and you were to open it up without using that subsequent software, would you be able to read or see anything that's on that data?
To be honest, I don't know because I've never opened one of those zip files to know what's actually in them.
After the extraction happens, after that copy made, did you mention this further software you would use to be able to actually read the data?
Yes, so that's Cellbrite and Axiom. They're two different programs, but those programs will make the information readable.
Are those the programs that you typically use?
Yes, they are. And there's other programs out there, but those are the two that we normally use at the office.
Are they commonly used in the Massachusetts State Police?
Yes, they are.
Are there other programs beyond Axiom and Cellbrite that can be used to decipher the information so you can read it?
Yes, there's many.
In your entire time with the Massachusetts State Police, have you used any other programs other than Axiom or Cellbrite?
To look at cell phones?
Yes.
We have Sanderson forensic software that can look at databases that are in the phone to look at information. I don't normally use those because I don't want to say, I'm probably not proficient enough that I would know this exactly means this, or I wouldn't want to confuse anything that I'm looking at.
When you look at the information after it's been through the extraction and then the analysis through the software, is the data still available if you want to look into the data?
From the zip file itself, sir?
Yes.
Yes, it's always available. It's, like I said, the data in the zip file that GrayKey gives us is never changed. It's just being loaded into another program so we can see it. That's all.
The software that you use, whether it's Cellbrite or Axiom, does that do the work for you as a forensic examiner?
Yes, so it runs, as the program runs, I should say, it will bring up different tabs. So it'll say phone calls, chats, photos, the databases, all different things that Cellbrite, their software, has run to pull this information out to make it easier for investigators to find what they're looking for.
Beyond the initial report that you can look at and look for the information, if you wanted to as a data forensic examiner, could you look deeper beyond the production of those software programs?
Yes, you could.
Forensic data analysis, when you look at these tools that provide these initial reports, is that the beginning, or does it dig deeper when you're a digital forensic analyst?
No, these reports are finding the low-hanging fruit in the proverbial tree. So it's showing you the stuff that the program is set that most people are looking for. As I said, the phone calls, the chats. If you need to go deeper into it, as I said, there's other software out there where you can pull these databases and try to go through the code to find what you're looking for. Once you find something, you would have to corroborate it with other evidence or data to make sure what you're looking at is exactly what you're looking for.
Have you been involved in the download, extraction, and analyzing data on phones as your role with the Massachusetts State Police?
Yes, that's my primary role in the DA's office currently.
And how many years have you been in that role?
Since November of 2019, so 5 years now.
Have you worked on a number of different cases that involve forensic data?
Yes, I have.
Is there a routine or a practice in your present role when you make a copy about what process you use and how you produce it in a case?
I wouldn't say there's a normal process. It's all case dependent. A lot of cases we get, people want PDFs of the information, portable cases that we can create. So it's basically the portable program that I'm using. That way someone could find the information they're looking for, or I give the raw information if requested.
What's the difference between PDF form and raw information?
So Cellbrite can create a PDF form of every bit of information in the phone. It could be like a 10,000 page PDF. It literally just lists everything that's in there. If I create a portable case, as I said, that is basically like me giving you the thumb drive and it's showing you exactly what I'm seeing, and you can click on the tabs yourself from your own computer. And then if I give the raw file, that means someone has to go in and load it themselves to look for it.
Typically, when you are producing evidence of discovery in a case, do you produce PDF or the raw file?
As I said, it's all case dependent. Not all cases have forensic experts to come in to look at the information. So I'll supply whatever is requested. Normally the PDF or the portable case is what I give, but if more is requested, that's readily available.
And so the raw data, if requested, do you provide that as well?
Yes, if requested.
In this case, were you involved in any type of forensic data extraction?
Yes, I did the extractions of multiple phones and analyzed multiple phones in this case.
You mentioned that there's a software and hardware, the Gray Key unit. Where's that located?
That's located in the digital forensics laboratory, which is key card access and alarmed. Excuse me, at the Norfolk DA's office.
Are there other cases or the multiple cases that are occurring at the same time?
Yes, we constantly have phones coming in and out and being worked on.
What if you have a phone and the Gray Key unit's being used? What do you need to do?
We need to wait for that phone to finish, because if we say we unplugged it, it would interrupt that data transfer and we could lose it. So we wait until the phone's done and then the next phone goes up.
Did you become involved in some way in this case?
Downloading devices, sir?
Well, I'm asking generally for.
Oh, yes, sorry, yes.
Were you involved in investigating this case as far as speaking to witnesses or going to the scene?
No.
Can you describe the best you can what your role was relative to this case?
Yes, so I was brought, as I said, phones from this case to have the data extracted and then have it ready in our Cellbrite program for the investigators to look at.
At some point, were you provided a phone that you later identified as a phone belonging to Mr. John O'Keefe?
Yes, I was.
Do you remember when you were provided that phone?
Yes, it was January 29th, 2022, about 7:30 p.m. that night.
Do you remember where you received that phone from?
Yes, I was at the DA's office. I got it from Sergeant Buchanan and Michael Proctor.
Do you remember about what time of night that was?
As I said, about 7 to 7:30 p.m.
Thank you. When you received that phone, did you have the passcode?
No, we didn't.
Without the passcode, what were your next steps?
So the phone was placed in our digital forensics lab until we could get the passcode. I was told that a family member was going to be bringing it in so we could download the device.
Did you ultimately get that passcode?
Yes, we did.
And do you remember when you received it?
January 31st, 2022.
After you received the passcode for Mr. O'Keefe's phone, can you walk us through the process of what you did?
Yep. So once the passcode's obtained, we'll unlock the phone and then plug it into Gray Key, and then it's able to pull the full information from it without having to guess the passcode.
How long does that take?
Again, depending on the size of the phone, a few hours.
After the information was downloaded, then what happened?
We place on our digital evidence server at the DA's office, and then if the phone is evidence, it would go into evidence. If it was a consent, we'd give it back to the person who gave it to us immediately.
Did this phone go into evidence?
Yes, it did.
When you downloaded the information through Gray Key, which you said was the hardware and software, does it produce a report with that digital imprint?
Yes, it does. It produces a report from the time you plug it in to the process it it completes, and then the amount of data, and then, like I said, that digital fingerprint hash value at the end.
And did you do that with this phone, Mr. O'Keefe's
Yes,
phone? May
I
I
did.
approach, Your Honor?
Yes.
Highlight. I'm going to show you a document, sir.
Okay, sorry. Yes, thank you.
I'm sorry.
Did you show it to Mr. Leslie?
I'm sorry. My apologies. May I?
Yes.
I'm showing you a document. Can you look at both pages, please?
Okay.
Do you recognize that document?
Yes, this is the,
I'll just
I'm
ask you a couple more
Oh, sorry.
questions if you don't mind. What is it?
it's the Gray Key progress report that they give once the phone extractions are completed.
Do you recognize that as the report that is attributed to John O'Keefe's phone?
Yes,
And does that document have that digital imprint, the digital fingerprint that you were talking about?
yes. So it's in, yeah, so it's here on the back. I just want to see if it was in two places. But it would be here for the, sorry, it's got cut off,
Why
but,
don't I put it up for an exhibit so that we can show you later?
Okay.
I'll ask you some questions.
okay.
I'd like to introduce this as an exhibit, please. No objection, Your Honor.
Okay, thank you.
Is it 18th of March?
May I show that exhibit to the jury? May I approach the witness to show him the pointer?
Yes.
On this top button will be the pointer, the middle button will change the screen, so
Oh,
it's the top button, please. Can you walk us through what this report means?
yep. So here at the top, there it is. Again, it says Gray Key progress report, and then it gives the report generation date and time, and it is in UTC, which is, get the exact definition, universal time coordinates, I believe. So you'd have to minus 4 or 5 hours depending on daylight savings time. So this one would have been January's -5, 16:10, so it'll be 1 noon, 12 o'clock for the actual time on the 31st. As we go down, device name is Johnny. The software version is the Apple iOS that was running at the time. Model number, iPhone 11. And then if you were to look up the N104AP is also a model number. The unique device ID. This one is what Gray Key assigns to the zip file that it creates. Serial number of the phone, the unique chip ID, the Wi-Fi address, the Bluetooth address, and then the phone number. And then there's more information underneath.
Could we scroll that, please? Thank you.
This here is the IMEI, which is the International Mobile Equipment Identifier. It's not uncommon now to have multiple of those identifying numbers. The data partition size of the device, which is 83 gigabytes. The lock state, if the phone was locked, it would say locked. This one is unlocked, so we had the passcode. This was the Gray Key agent version for the software. And then this is the last time that the phone was backed up via iTunes or iCloud. This is the owner's name. You can have anything in this, but his phone had John O'Keefe set as the iPhone owner name, and then the different accounts attributed to the phone.
Okay. Can you show us where the digital fingerprint is?
Yep, it's down. So that, the top part here is literally every time when it's plugged in to every process that it completes until the progress report is generated. Here is the full file system was created on this date and time. And then even though the partition size was 82 gigabytes, it actually pulled 125 gigabytes of data. Underneath this, if you're on the next page, is that unique fingerprints right here. So it has a SHA-256 and an MD5. They're just two versions of hashing to show that the file, they're unique fingerprints, and that's what these numbers are here. So there's one for the image of the extraction, and then one for the keychain for the other documents that Gray Key creates.
And you mentioned that if anything has changed, even a period, that number and letter sequence will change as well?
Yes, that's exactly right.
Did you have an opportunity to download and extract any other phones?
Yes.
At some point, did you have an opportunity to download and extract a phone from the defendant?
Yes, I did.
Do you remember when you received that phone?
I got the phone the same time as I got Mr. O'Keefe's phone on the 29th at around 7:30 at night.
And so you received both phones at the same time
Yes,
from the same people?
correct.
Trooper Buchanan?
Yes,
Trooper Proctor?
yes.
What did you do with that phone?
Again, that was brought down to the digital forensics lab for holding until we could get into it, or a warrant was written, or whatever legal process was going to be done, so we could get that information.
Do you secure it?
Yes, that room is locked with keycard access that only myself and two others have, and it's also alarmed.
Do the case officers or investigators that aren't part of your unit have access to those items?
No, the only ones that had access were myself, Trooper Connor Keefe, and then the director, Samantha Vogt. She's a civilian that runs our lab.
And at that point, were you able, after there was process, were you able to get into the phone at first?
No, it wasn't supported by Gray Key, the phone model and number.
What do you mean it wasn't supported?
So the software, even if we had a search warrant, we plugged it in, Gray Key wouldn't be able to recognize it because it just wasn't supported at that time.
When you say it wasn't supported, does this have anything to do with a passcode?
For both. So we didn't have the passcode. So because we didn't have it, it wasn't supported for us to download that information from the device.
If you had a passcode, would it have been supported?
Yes, it would have been.
So is there a process when you have a phone that you don't have a passcode for to be able to access the content of the phone?
Yes, that's correct. We have to wait until we either have the passcode or the software and hardware is supported for the device where it can try to guess the passcode.
So let me ask you some questions about software. In forensic data analysis, does software change frequently?
Constantly.
When the software changes, does it advance?
Does the software get better?
Yes.
Yes, it does.
At the time you first had the defendant's phone, the software you had was unable to access the contents?
That is correct.
What do? Do you look for other software or do you wait for updates? What's the process?
If there is another software out there, we will use it to try to get the information. If not, we are at the mercy of waiting for the developers to come up with the information for us.
Did you wait in this case?
Yes, we did. We had to wait.
Ultimately, did software advance so that without a passcode, you were able to access?
Yes.
How long did you have to wait before you were able to access?
I believe it was July of 2022 that the software had been upgraded enough that it was able to brute force or guess her passcode for the device.
And where does the device remain until you're ready to try again?
In that locked digital forensics lab.
So when the software updates and advances, do you know that it will be successful or you plug it in and you try?
No. So on Gray Key, they have like a link where you can click and it brings up a whole matrix. So it shows every make model of phone and then the software associated with it. And it says it can do a partial download, a full download, a password guess. It tells us, so when there's a new update, we'll check that to make sure that the devices we have can be accessed.
Did you make an attempt to have the software access the phone without a passcode?
Objection, Your Honor. Move the approach, please.
One by one, all, or certainly most, of the claims of the original conspiracy put out by Turtle Boy and put out by Karen Reed through Turtle Boy is debunked. And one of the claims was always that the state waited until the last second to give Karen Reed their analysis of the extraction, and that was somehow suspicious. Nope, they're waiting for software updates, same as the chip off.
Thank you. Did you use software inevitably to open the defendant's phone?
Yes.
And how many times did you download?
So there was 2 downloads. One, thank you. One of the partial part of the phone, and then in the same time that we had it plugged in, we had the password brute force guess software installed onto the phone, so we would try to guess the passcode. So there were 2 downloads, one with very limited data, and then one with the full file system extraction, which is everything on the phone that it can get.
May I approach?
Yes.
I'm going to show you 2 documents, sir. Need a copy? Give an extra copy of both. I'm going to show you 2 documents that actually, the first one, do you recognize that document?
Yes, I do.
Is that a result summary from Gray Key for a search of the defendant's phone?
This is the initial extraction that we created before the password guess process went through.
I'd like to introduce this as the next exhibit, please.
No objection, Your Honor.
That's the original.
Yes, this is the first one.
Thank you.
Yep.
Exhibit 19.
I showed you a second document. Do you recognize that?
Yes, this is essentially the same information, except it goes further of all the password guess attempts longer until we actually get all of the information from the phone.
I'd like to introduce this as the next exhibit, please.
No objection, Mr. Leslie?
No objection, Your Honor.
Exhibit 20, somewhere.
Could I have the previous exhibit as well, please? Sir, I'm handing you back Exhibit 19, which was the partial download.
Okay.
Exhibit 20, which was the subsequent download. You mentioned hash value changes with the content of each download.
Yes.
Is there hash values specifically assigned to each download?
Yes, there is.
Are they the same number and digits in digital fingerprint?
No, they're not.
And explain again why they would be different.
Again, the first one was the partial. It was only 45 gigabytes of data. So it has one number. The second download was 109 gigabytes of data once it got the passcode. And again, that number is completely different again. And again, like I said, the information is not the same, so the hash values won't be the same.
Were the two other phones that you inevitably analyzed?
Yes, there were.
Let's start with the first one. Did you have an opportunity to create a file on a phone that came from Carrie Roberts?
Yes, I did.
Now, you said it's a two-step process. First is the extraction, the copying, and then it's creating the file.
That's exactly right.
With Carrie Roberts' phone, did you make the extraction? Did you plug it into the gray key?
No, I didn't.
Who did?
Trooper Connor Keefe.
How do you know Trooper Connor Keefe?
He went to meet with Carrie Roberts, received the device from her. He brought it back to the office and did the extraction. His name is also on the extraction gray key progress reports as well. And he wrote 2 state police reports regarding it.
Do you work with Connor Keefe?
Yes.
He works with, I'm sorry.
Yeah, I would say we do the same, essentially the same job working together.
So he's in your unit?
Yes, he is.
In the digital forensic unit?
That's correct.
That phone, did it come with any paperwork, any forms?
Yes, he had 2 signed waivers of consent from both parties for each device, one for each device.
And so as far as the copying, the extraction, you did not do the extraction on Carrie Roberts' phone?
No, I did not.
After it was plugged in and a copy was made, did you then access it?
Months down the road.
Were you assigned at that point to analyze or look at any of the data on that phone?
Initially, no.
At some point, did you create a file so that you could provide it to the parties?
Yes, I did.
Was that upon request?
Yes, it was.
And separately, did you know, or did you, let me ask it a different way. Was a phone from Jennifer McCabe extracted?
Yes, it was.
Did you do the extraction?
No, I did not.
Was the information after extracted again provided to a digital file?
It would have been, yes.
Did you, at some point later, did you make a copy to provide to the parties?
Yes, I did.
Can you tell us what a USEF reader is?
So the UFED reader is a portable case that I can create through Cellbrite. Again, like I said, it's the exact same program that I would be viewing if I was sitting at my desktop, and said it can be made into a thumb drive to give to defense, prosecution, investigators, whoever. And there's no chance for the data to be manipulated because it's just a reader.
When you have the digital file that's been extracted and then created into a PDF or a form that can be read, can you print the entire file on paper if you'd like?
Yes, you could.
Would that include, could you print it so it includes the entire content of the phone?
Yes, it would be thousands of pages, but yes, you could.
Is there any way to isolate particular things of interest that you might want? For example, if you wanted just the chats between 2 people, is there a way that you could have a program isolate just those chats and then give you all of them in a form that you could read?
Yes, so you can go in to cherry pick whatever information you're looking for to create into PDFs or other, it gives 5, I think, different mediums. You can have it output: HTML, portable cases, XML files.
If you wanted to create a document that had a number of people in communications, could you do that as well?
Yes, you could.
So you can pretty much set the parameters how you want if you want to search for particular items.
Yes, it's very generous that way of being able to search for keywords, phone numbers, whatever it is, and then you can export that out into a PDF so you can print it.
May I have a moment, Your Honor?
Yes.
Okay. Did you go through the program and create a number of documents that isolated specific information that you wanted?
Yes.
For example, did you go through and create a report for all of John O'Keefe's calls for a period of time?
Yes, I did.
Did you go through the program and create a report for all of the calls between John O'Keefe and the defendant for a period of time?
Yes, I did.
Did you go through the program and create a specific document that would show just the text messages between John O'Keefe and the defendant?
Yes, I did.
Did you go through the phone and create specific separate documents for communications, phone calls and text messages between Mr. O'Keefe and other people, not the defendant?
Yes.
For example, Ms. Roberts,
Yes, that's correct.
Ms. McCabe.
Yep.
Did you go through any of the phones and create documents to show any text or conversation between parties not involving John O'Keefe?
If directed, I could, but I don't believe I did.
When you took on the task of creating these documents, was it something you did on your own or something that you would wait for a request from a prosecutor or another officer?
I would wait for a request. Again, my knowledge of most of the cases is very, very limited. So if they're looking for something specific, I can assist them. If they need some type of help, I can assist them. But normally I will open it up for them and they have a better knowledge of the case, so they know what they're going to be looking for. Everyone in our office is Cellbrite trained. Or if someone new comes in, that's the first thing they'll go to is to a Cellbrite training, so they know how to use this program. And it doesn't put the burden on myself and Trooper Keefe to try to find everything for every case.
Thank you. Your Honor, at this time, I'd like to conclude this witness.
You're in agreement with that, Mr. Lessie?
We are, Your Honor,
Okay.
subject to the recall.
Okay. All right, Trooper, you're all set.
Thank you, Your Honor.
We'll see you again.
Should I?
You could just leave them right.
Thank you.
Do you have another witness, Mr. Brennan?
May I?
Yes, please.
Commonwealth calls Mr. Whitley.
You solemnly swear the evidence given to the court and jury in the case now hearing to be the truth, the whole truth, and nothing but the truth, so help you God. I do. Thanks.
May I?
Yes, please.
Thank you, Your Honor. Sir, could you please introduce yourself to the jury?
Hello, my name is Daniel Whitley, Whitley. I'm a paramedic with the Canton Fire Department. I've been a paramedic and firefighter there since March of 2006.
Before you became a paramedic firefighter with the Canton Fire Department, did you work anywhere else related to that field?
Yes, I had 4 years full-time as a EMT intermediate, and also a paramedic at American Medical Response in Brockton.
I'd like to take us right to January 29, 2022.
Yes.
Do you remember that day?
Yes.
Were you working?
Yes.
What was your role that day?
I was a field training officer working on the ambulance with my partner, Jason Becker.
Mr. Becker?
Correct.
That morning, did you know whether there was a call where a group of your colleagues went to and addressed 34 Fairview?
Yes.
Were you accompanying your colleagues on that initial call?
No.
Where were you at the time your colleagues left to go to that location?
I was at the Station 2, Ponkapog Station, on the north side of town.
Different station?
Correct.
At some point after that call came in and was responded to you, did you receive a call?
Sometime after, I'm not quite sure exactly how soon or later it was, but we received another call to respond to that scene.
And as a result of receiving that call, did you make your way towards that location?
Yes.
Who did you go there with?
Just me and my partner at that time was Jason Becker.
What type of vehicle did you use to get there?
It was an ambulance.
What was the weather like?
It was snowing pretty heavily at that point.
Do you know about how long it took you to get to 34 Fairview?
Not exactly, but definitely longer than usual. It should have been an 8-minute drive. I'm guessing 10 to 12 minutes. You could refer to my partner's report for exacts.
When you got there, what did you see?
We arrived on scene. Our engine was there before. We run on a response with an engine and an ambulance to medical calls. And then at least 2 police cruisers and another car parked on the street, a gray SUV.
When you got there, did you meet with anybody?
Yeah, usually we get out, we say hi to my lieutenant and the other gentleman, Sam Parker, was on the engine before we got there. They were up front of where we parked, and then we walked down further, or at least I did, to the gray SUV.
When you reached the gray SUV, did you see anybody inside it?
I believe at that point we were kind of, getting out. We were walking down, they were coming out to greet us. There were 3 women there.
Okay. Did you speak to any of them in particular?
Not at that point, no, not really.
At some point, did you have any interaction with any of the women?
Yes.
In fact, did you know any of the women who were there that morning?
I knew Carrie Roberts.
How did you know Carrie Roberts?
First we're neighbors. She lives about 100, 200 yards away from me around the corner. And she helped organize a neighborhood block party, and I would volunteer every year to bring the fire truck to the block party and show the kids the fire truck for a little bit.
So you knew her well?
No.
Were you friends with her?
No.
Friendly?
I just would describe us as acquaintances.
Did you ever socialize with her personally, other than the block party?
No.
But you know who she was?
I knew who she was. I don't recognize her, yes.
Did you talk to her that morning?
Not beyond probably a hey or hi or something like that.
Do you know whether she ever gave you any items?
I know at one point I had to exchange whether it was a purse or a cell phone or some object from Miss Reed.
At some point that morning, did you have an opportunity to meet with the defendant?
Yes.
Where did you first see her?
We were in the process of getting her to go to the hospital.
When you say we, who was helping you?
That would be, my partner, obviously, Jason Becker, and then my lieutenant, Greg Woodbury.
Where was she when you first saw her?
Somewhere outside in the street.
Do you recognize her in the courtroom today?
I do.
And could you identify her, please?
Yes.
Please. You're pointing to a person. Can you give just a very limited?
The woman standing, sitting in between these 2 gentlemen here.
Did you interact with her that morning? Have a conversation?
Yes.
When you first started speaking to her, what was her demeanor?
Pretty upset, crying. we had a Section 12 in hand, which is a medical order or a police order to be taken to the hospital for psychological evaluation.
Did you discuss that with her?
Yes. Yeah.
Did you ask her to follow you or to come with you?
Yeah, she did.
And did that happen?
To the ambulance, correct.
So you went to the ambulance with the defendant?
Yeah.
And was Mr. Becker with you?
Yes.
What happens when you get to the ambulance?
I mean, so it was snowing, and it was more to kind of just get everybody into a nice, warmer location where it wasn't snowing or windy or anything like that. And we would discussing that, we have a Section 12 that states we have, regardless of if you want to go, we have to take you to the hospital. She was arguing that she really didn't need to go to the hospital, and we were trying to convince her to go to the hospital because once the Section 12 is written, it doesn't matter what the patient says. We have to get them there one way or the other, whether it's cooperatively restrained or chemically restrained with sedatives or anything.
It's not a voluntary order?
It is not a voluntary order.
Inevitably, did the defendant agree to go with you to the hospital?
Yes.
When you were going to return to the hospital, was the defendant placed in the back of the ambulance where a patient would be?
Correct. So how we operate for anybody that's a Section 12 or anybody that is under the influence of anything, we always operate with 2 people in the back of the ambulance. So myself and my partner, Jason Becker, were back there. And then we had to take somebody from the engine company and have them drive to the hospital, and that was Sam Bach.
Sam Bach?
Bach, B-O-C-H.
Thank you. Before you left, before you started to drive away from Fairview, were you having any conversations with the defendant?
Yes.
Can you share with the jury what those conversations were about?
So we were talking. She was upset. She kept asking if there was any chance her husband could be alive, and even sitting outside in the snow with no coat on for many hours.
Did she indicate what many hours meant? How many?
No.
How often did she raise the issue of whether or not or how long he could be out for?
I'd say at least 3 to 4, maybe more.
Part of your job is to care for patients?
Correct, yes.
Was part of your job to try to get them to the location safely?
Yes.
And sometimes you treat patients with physical injuries, don't you?
Oftentimes it is physical injuries, yes.
Are you trained when you're trying to transport somebody on how to interact with them?
Yes. Well, sometimes if they're upset, in this instance, she kept asking if there was any chance that he could be alive, and that we really didn't know what was the patient that ambulance 1 took. We really didn't know what his condition was, and but figuring that it was a hypothermia type case, being the conditions outside, we were trying to give her hope that there is a saying in the medical field, you're not dead until you're warm and dead. And I was basically, there's stories of children falling through ice and falling into rivers and being underwater for multiple hours and coming out, being resuscitated and having no neurological deficits. So I was telling her those stories just kind of to say, look, let's be sure we'll get to the hospital. We'll find out more there. Just trying to give her any sort of hope that her husband would be alive.
Can you describe her demeanor when she was in the back of the ambulance with you during your interactions with her?
She would go from pretty upset, crying. One instance where she kept saying, I can't take care of these kids. I can't take care of these kids. They're not my kids, and they're not his kids. And at that point, I understood who ambulance 1 had taken. because John was pretty well known in the town for taking on the care of his niece and nephew. So I said, listen, it's okay. It looks like you have a very strong support system. And then Miss Reed said, do you know Carrie Roberts? And she had been crying. And she picked her head up and said, do you know Carrie Roberts? And I said, a matter of fact, I do. And she said, anybody who knows Carrie Roberts wouldn't say that about her. And I said, well, she did come to out at early in the morning to look for your husband in a blizzard. And she just rolled her eyes and put her head back down. And I thought it was just bizarre.
Objection, move to strike.
I'll strike that last sentence.
Would you describe her demeanor as even through that ride?
No.
How long did it take to get to the hospital?
I mean, you can refer to my partner's ambulance trip report. I'm sure it has the.
Do you have it right with you, sir?
I do not know.
Well, let me ask you.
I would guess about 15 to 20 minutes, somewhere in there.
You don't have an exact memory?
No.
When you get to the hospital with a patient under these circumstances, do you leave them at the door?
No.
What do you do?
We have to hand off care. So we go in and we have to give a report to a nurse to let them know what their condition is, why they're coming to the hospital, and what we found taking them to the hospital.
When you got to the hospital with Miss Reed, did you interact with the hospital personnel?
Yes.
Do you typically, after you hand off a patient to staff, do you leave?
Typically, yes. This time, Miss Reed was, I'm going to say, not really cooperative with the nurse there. The nurse was asking her to get into a Johnny, give a urine sample. She was not cooperative. The nurse tried to work with her, had an ER tech go and ask the doctor if she had to get into a Johnny. She came back. She said, yes, she's a patient. She has to do all the normal stuff. We really didn't feel comfortable actually leaving the general area. I don't know if it was just shift change or what, but security wasn't there. And with her demeanor, we just didn't feel comfortable leaving the nurse by herself with Miss Reed.
You said that there was some difficult times. Was there some difficulty about the defendant accepting wearing a Johnny?
Yes, she was refusing to get into the Johnny, and the nurse kept saying, well, you got to get into this Johnny. The nurse did try to work with her and you know, asked the doc if.
Objection.
I'll allow that.
And so the ER doc, the ER tech had to come back and say, yes, she has to get into the Johnny. And at that point she did. She you know, seemed to have calmed down and was getting into the Johnny. Security personnel had shown up, and we felt comfortable being able to kind of leave the nurse and the tech on their own.
Before security came, was there difficulty in her providing a urine sample?
Objection.
Do you know the answer to that?
Can you ask the question again? I'm sorry.
Why don't you ask it a little differently?
Sure. Do you remember whether she was giving the nurses a hard time about a urine sample?
Yes.
Objection.
So break that down, Mr. Brennan. The objection is sustained.
You said that she was giving nurses a hard time.
She didn't want to give a urine sample. And then the nurses kept asking her to, you know, this is the cup, you pee in the cup.
Objection. Not funded.
No, I'm going to allow it.
You were there and saw this, right?
I saw it, yes.
Thank you. I have no further questions.
May I proceed, Your Honor?
Yes.
Good afternoon, sir.
Good afternoon.
Sir, you knew before you got into Ambulance 2 that you were heading to Fairview Road for what is called a Section 12, correct?
We were dispatched for a Section 12, correct?
Right. And that was not your first call for a Section 12, right?
No.
You had been in that job since 2006?
Yes.
You've handled a number of them over the years, correct?
Correct.
the fact that the call came in as a Section 12 gave you some idea of the nature of the issue that you might be dealing with, correct?
We had an idea that it was for a psychological issue. Correct.
Right. It told you that somebody at that location was suspected of being in some type of either psychiatric or emotional distress, correct?
Yes.
And on your crew, or of your crew, I should say, you were the one to drive the ambulance to the residence, correct?
I drove to the address at Fairview.
Now, you've said that when you got to Fairview Road, you don't recall the time, but you do recall that there were still emergency vehicles on scene, correct?
I do.
There was nobody lying in the front lawn of 34 Fairview at that time, correct?
Correct.
And do you know how much later after 6 a.m. you would have gone there?
You'd have to refer to my partner's report.
You don't know if it was minutes or hours?
It
later?
was minutes. It was within the hour. I don't know.
Within the hour.
Yep.
Okay. And you said that there were, or you testified that there were 2 police vehicles on scene, correct?
At least 2.
At least 2. There could have been more than 2.
It certainly could have been.
And those police vehicles in such a situation, particularly with the snow falling down, would have had their blue lights flashing?
I'm not exactly sure if they did or they didn't. Sometimes the police shut off their lights when they arrive on scene. Sometimes they don't.
Okay, so you don't have a memory one way or the other?
No, nothing sticks out.
But those police vehicles certainly were not hidden. They were in plain view, correct?
I would say so.
Minimum of 2, maybe more. Correct?
Yes.
And there was also a gray SUV parked near that residence?
Correct.
And there was a fire engine there as well, correct?
Correct.
You called it our engine, right? That was from your,
Well, it would be engine 3.
Engine 3 from
Or
your
at least
station.
the Station 1 engine.
I'm sorry?
The Station 1 engine. So Canton Fire has 2 fire stations. We were coming from the second station. The Station 1 engine is the one that responded to Fairview.
Okay, and that was a typical large fire engine, correct?
Yeah.
And did the fire engine have its lights on?
I assume it did, only because we rarely shut our lights off on a scene.
Sure. And there were police officers walking about, milling about?
Yes.
Do you know how many?
I know I spoke with Officer Sarif and Officer Mulaney.
Okay. And
So at least 2.
And you know them by name?
Yeah, Canton's a fairly small town, so you run into the police on a regular basis.
Sure, and you work cooperatively with them, correct?
Yes.
Were there other police officers besides Sarif and Mulaney?
I'm sure there could have been, but I don't recall ever speaking with them or interacting with them.
Okay. Were there other EMTs or firefighters there when you got there?
Just my Lieutenant Woodbury, and then firefighter Sam Pock.
Okay, and they were in charge of engine 1?
Well, the Station 1 engine.
The Station 1 engine? Okay. And there were also civilians on scene, correct?
Correct.
So you would agree that there was a lot of activity outside 34 Fairview, correct?
There was a fair amount of activity.
I mean, there were people and vehicles and lights surrounding that residence, correct?
I assume so, yes.
Well, you were there, so
Yep.
you don't really have to assume, you know, right?
There was at least 2 police cruisers and a fire engine.
Right, and civilians,
And
and police officers, and firefighters, correct, and civilians.
Correct.
All right. With all of that activity outside 34 Fairview, did you ever see the homeowner come out of his house?
I wouldn't have known the homeowner.
Do you ever see anybody exit the house?
I was not focused on the house at all.
All right. You were there to do a job, correct?
I was there to take somebody to the hospital.
Right. And you were there also to do a medical or psychiatric assessment while you were on scene, correct?
Well, yes, my partner was. Correct.
All right. When you got there, you learned, well, I have to strike that. You knew going there that your patient would have been Karen Reed, correct?
No.
Okay. When you got there, you learned your patient was to be Karen Reed, correct?
Yes.
All right. And given the nature of the call, you knew when you arrived that you would be transporting her to the hospital, correct?
Correct.
One of the first things that you tried to do was to get a medical history from her, correct?
Or my partner.
All right. And you were present for that, correct?
I may or may not have been.
Getting a medical history is important so that you can pass along information to the hospital when you eventually arrive there with the patient, correct?
Yes.
And you know that when assessing and treating somebody, getting more information is always better than getting less information, correct?
Not necessarily.
Okay, so there are times when you'd like to get less information from a patient before you transport them?
So it would be pertinent information. For instance, if somebody was complaining of chest pain and they had, stents placed in their heart, we wouldn't talk about how they had their tonsils removed when they were 12.
Okay, fair enough. But getting more information is not going to negate the crucial information that you do get, correct?
I mean, it certainly could in a critical stage. If there was a critical patient, we wouldn't typically overburden passing off a report to a nurse or a doctor with non-pertinent information.
Okay, it's not your testimony that getting less information is always better than getting more information, is it?
I would say getting pertinent information is better than having.
That wasn't my question. My question was, is it your testimony that getting less information is always better than getting more information, sir?
I would not agree with that, no.
Okay, thank you. Now, the medical history that was taken from Ms. Reed listed her as having multiple sclerosis, right?
I want to see it, second, please.
I hate when the defense is allowed. I shouldn't say allowed as though there's a rule against it, but to make these statements like, is it true that more information is always better than less information, however you worded it? Because it's ridiculous. Garino just pointed out an example where less information is sometimes better than more information. So Hank Brennan asked if you wanted to get the entire extraction report from a phone put into a PDF form, could you do that? And he said, if you wanted to print it, I think is the way he asked it. And he said, well, yes, but it would be thousands and thousands of pages. If you wanted to narrow that down to just getting the conversation between two individuals on that phone. And he said, yes, you can easily do that. So if someone was to ask for the conversation on John's phone, any text conversations from January 28th and 29th, or January 28th, between Karen and John, they could put in, download all conversations between Karen and John. They could set those parameters. That is preferable to getting thousands and thousands of pages. So it's a stupid presumption that he tries to sneak through there. And they do this all the time. And yes, now I am in the mood for Jimmy's. If you're following our conversation in chat, I haven't had Jimmy's in years because usually when I know it's actually been a long time since I've been to an actual ice cream shop to get an ice cream, probably about 3 years. I think I did get Jimmy's that time. Or for people outside of Massachusetts, Sprinkles. Something to remember. People are commenting that there's no Erin today, but this is having these lengthy trials are a major inconvenience for these people, and they have kids and grandkids. Peg is, I believe, living. She said they're testified living with her grandkids now. So, I mean, it's hard for these people to make every single day of testimony. Bucks and Six, I love you, man. You've been here with us for a long time, all the way back to when I was kind of on the other side. And the Bucks and Six was big back maybe a few years ago, but there looks like it's going to be a seller's market in the Bucks this offseason. They're down 0-2. If someone wants to ask for the conversation. Hi, Jen.
Hey, Kevin, you brought up a good point. I like this guy. He is holding his own. We did not get to see him in the first trial that I recall at all. And I like him.
We did, but he's unless it was a different paramedic, because I know that Karen, maybe there was two, there must have been two on the ambulance, because I remember that there was a paramedic that Karen had asked, or he testified that Karen had asked him, how long could someone survive in the cold? Was there another paramedic maybe that was going to testify to that too?
Well, he talks about a partner. I just physically don't recognize this guy, or he has a very unique style, right? He says a lot, I think.
Yeah.
But he has
maybe there was a second one. Yeah.
He's just nervous, but he has such great information. You know, I remember, as you do, the testimony about what she had said, but this is times 10, right? We're hearing a lot more detail.
Yeah. Yeah, it's these witnesses, as I said earlier, I said I would Trooper Garino, but we're seeing it here too. And I'm not trying to knock Lally, because Lally was, well, we're going to go on this, but Lally was doing a lot of work for one guy. But these witnesses are much more carefully prepped. And now that's what you're seeing, a much better trial.
Thank you. Sir, the medical testimony, history that your partner and you took from Ms. Reed listed that she suffered from multiple sclerosis, correct?
Correct.
And you know that that's a chronic disease of the central nervous system?
It's my understanding.
And what does chronic mean?
I believe any disease lasting more than a certain amount of time. It could be 2 years, 3 years, 4 years.
Persists for a long time or constantly recurs?
Correct.
And it's a disease that affects neurological muscle control, correct?
That's my understanding.
And last question, it's also a progressive disease, which means it tends to get worse over time?
My understanding.
All right. Now, when you first interacted with Karen Reed after you got to 34 Fairview and encountered that whole scene, it was clear to you that a major focus for her was whether John O'Keefe was alive or dead, correct?
Correct.
Bless you. She asked if somebody could survive after having been found in the snow without a jacket, correct?
For many hours, correct.
All right. And you mentioned something about hypothermia, that you assumed that you may have been dealing with a hypothermia situation from earlier, correct?
Well, she said that he had been out in the snow with no jacket on for many hours.
And you assumed hypothermia was your testimony, correct?
Yes.
You are not qualified to diagnose hypothermia, are you?
I'm not a doctor.
Okay. And you don't know if your assumption about hypothermia was correct or incorrect, correct?
Is my assumption correct?
My question is that as you testify here today, after having dropped off Karen Reed at the hospital for that Section 12, you don't know if the assumption that you made that you were dealing with a hypothermia situation was correct or not. Is that right?
Well, they were certainly working on him at the hospital as a hypothermia patient.
You don't know if your assumption was correct or not, sir.
I guess I don't.
And you told her, in fact, that you could not speak to that, correct?
I'm sorry, to what?
In terms of how long somebody could survive outside, correct?
I couldn't speak to his condition is basically what I was trying to say to her.
All right. But she still persisted in asking you over and over if he was alive or dead, correct?
Correct.
She wouldn't let that go. Is that fair to say?
Correct.
And that was despite your not being able to give her an answer, correct?
Again, we were just trying to sort of give her any hope.
Right. Okay. So she kept asking it, and you were trying to give her hope that he could still be alive, correct?
Correct.
All right. Now, today you claimed that her demeanor had changed when you mentioned Carrie Roberts, correct?
Correct.
And the term that you used to describe her demeanor when You mentioned Carrie Roberts as being part of a support system. What term did you use?
I'm sorry.
When you just testified on direct examination, did you characterize the way that she reacted when you mentioned Carrie?
She had been crying in her hands, and I said, you know, it looks like you have a very strong support system. And she picked up her head. She had her face in her hands. She picked up her head out of her hands, looked at me, and said, "Do you know Carrie Roberts?" And I said, "Matter of fact, I do." And she said, "Anybody who knows Carrie Roberts wouldn't say that about her."
Okay, and you've previously described that in testimony last year as her being snarky was the term you used, correct?
Correct.
But you were first interviewed by the police on February 8th of 2022, correct?
If that's what the report says, yes.
About 10 days after this?
About that.
And the events of January 29th were fresh in your mind on February 8th of 2022, correct?
As fresh as they are today.
Okay, so you do not allow that your memory was better on February 8th of 2022 regarding January 29th of 2022. It wasn't better on February 8th than it is today, is your testimony?
I would feel it's just as good.
Okay. Your memory does not get better over time, correct?
For this case, it seemed to stick out to me.
Okay, so are you testifying that your memory gets better over time?
No, but
that would be crazy, wouldn't it?
Correct.
In that February 8th, 2022 interview, you were asked about Carrie Roberts, right?
I'm sorry, what day?
February 8th of 2022.
Okay.
You were asked about Carrie Roberts, right?
I do not recall if I was or was not.
You told the police that you knew Carrie Roberts from your neighborhood, correct?
Okay, yes.
And you've testified today that she just lived 200 yards away from you, right around the corner, right?
About that.
And you told police that you had seen Carrie Roberts on scene at 34 Fairview when you got there, correct?
Correct.
You also told police that Karen Reed had told you about making statements about her wanting to die, correct?
Correct.
But on February 8th of 2022, just 10 days after these events, you never mentioned to the police during that interview that Karen was snarky in any way, correct?
I don't know if I did or I didn't. I don't know if it would be in their report.
If you saw that report, would it refresh your memory as to whether or not you mentioned snarkiness?
I don't think I mentioned snarkiness that day, no.
Okay. All right, well, that answers my question.
Okay.
But after that interview, and of course, even after January 29th of 2022, you went back to your neighborhood, the same neighborhood that you lived in with Carrie Roberts, correct?
Correct.
Do you still live in that neighborhood?
I do.
Does Carrie Roberts still live there?
She does.
So you and Carrie Roberts have continued to live in the same neighborhood for years after January 29th, correct?
We have.
And before you ever encountered Karen Reed that day, you had interacted with Carrie Roberts in the past, correct?
Briefly, yes.
Well, you were both on the same neighborhood Facebook page, were you not?
Yes, that's why I volunteered to bring the fire truck to the
Right.
block
So
party.
one time she had posted on that neighborhood Facebook page that she wanted to have a fire truck at the neighborhood block party, correct?
Correct.
And that's when you replied and volunteered that you would bring the fire truck to that block party as she requested, correct?
Correct.
And you also worked with Carrie Roberts on the Ponkapog Civic Association, did you not?
I did not know. She worked on the board prior to my arrival on the board.
So you both worked on the same board, but just at different times?
Different times, correct.
All I think you had touched on this earlier. In addition to knowing Carrie Roberts, having been with the Canton Fire Department since 2006, there have been many times when you've worked in conjunction with the police, correct?
Correct.
And in addition to the 2 police officers that you mentioned having seen at 34 Fairview on January 29th, that being Sarath and Merlaney, you know many other officers at the Canton Police Station.
I do.
And as you say, Canton's a small town, correct?
Relatively.
People know each other, correct?
Correct.
You also knew former state trooper Michael Proctor before you arrived at 34 Fairview, correct?
I did.
Michael Proctor actually was 2 years ahead of you in school, was he not?
He was.
And you learned at some point that your school classmate, Michael Proctor, was the lead investigator into the death of John O'Keefe, this case, correct?
Yes.
And in fact, when you spoke to the police in February of 2022, Michael Proctor was one of the troopers to interview you, correct?
Correct.
You did not go to school with Karen Reed, right?
No, not to my knowledge.
You didn't help coordinate neighborhood block parties with Karen Reed, right?
Nope.
You were not in a civic association that Karen Reed belonged to at any point, correct?
Nope.
She was a stranger to you on January 29th, 2022, correct?
She was a patient of mine, yes.
Well, as far as you knew, she was an outsider to Canton, correct?
I did not know that.
You didn't live in the same neighborhood with her?
I'm not sure if we did or did not.
You had no personal contact with her either before or after January 29th of 2022, correct?
No.
All right. Now, as a result of your having gone to the scene, there's a patient care record that is generated, correct?
Correct.
And on this issue of the snarkiness and the demonstration that you just did, there's a contemporaneous report of your team's observations from January 29th, right?
Are you referring to my partner's run report?
Yeah, the patient care report.
Yes.
All right. And that patient care report is dated January 29th of 2022 and is timed at 9:03 and 34 seconds a.m. Does that sound right?
Sounds about right.
All right. And that 9:03:34, from your knowledge of how patient care reports are generated, would that be the time that you arrived on scene or the time that the report is written?
I mean, I would have to see what time, the exact time you're referring to, but it could be the time the call is closed, or it could be the time you finish the report. There could be multiple reports. I'm not exactly positive which report you're talking about.
Okay. In any case, it was from that morning, correct?
Well, it did, I assume so.
I mean, there was only one morning that you went to 34 Fairview.
Well, no, but there could be 2 reports. So the engine has to write a report and the ambulance has to write a report.
But they're both about that morning, correct?
Correct.
All right. Now, there are boxes to fill out on the patient care record, correct?
Correct.
One of the boxes is primary impression.
Yes.
What does primary impression mean?
That is just what we believe the patient's not complaint is, but what we believe the patient is suffering from.
Okay. And that is listed on the patient care record for Karen Reed as a behavioral/psychiatric episode, correct?
Yeah. So that's a box we check for just about any Section 12.
Sure. And of course, that mentions nothing about snarkiness, correct?
No, that is my partner's report.
Okay. There's also a box for secondary impression, correct?
Correct.
What is secondary impression?
That might be like just a secondary complaint most of the time. A lot of the times, patients don't have a secondary complaint.
Okay, but in this case, it's listed as anxiety/emotional upset, correct?
Yes.
All right. And again, that mentions nothing about snarkiness, correct?
That's my partner's report, yes.
There's also a box for signs and symptoms, right?
There is.
And nowhere in the signs and symptoms box is snarkiness mentioned, correct?
No, I don't think that would be medically appropriate.
And then in the patient care record, it's recorded that Karen was found sitting in the front passenger seat of a friend's car, crying and visibly upset, but cooperative, right?
If that's my partner's words, yes.
All right. And those words, actually nowhere in the patient care record is it listed that she was snarky in any way, correct?
Again, that would not be something we would put into a patient care report.
And you did not put it in, correct?
It was my partner's report, and no, we did not put it in.
Okay. And once Ms. Reed agreed to go with you in the ambulance, it's fair to say she was still upset and crying, correct?
At times.
If I may have a moment.
Sure.
Actually, if I can just get my glasses so that I can see. Thank you. Okay. You had just testified that you said at times she was upset and crying when she got in the ambulance, correct?
Correct.
You testified on April 21st of 2022 before the grand jury, did you not?
I did.
And that was 3 months after the events that you're testifying about today?
Roughly.
And your memory back then was fresh, was it not?
Yes.
And you were asked the question, once she was in the back of the ambulance and she agreed voluntarily to go to the hospital, did she appear to calm down at that point? Do you remember that question?
I do.
And your answer was, I mean, she wasn't arguing against us at that point. I mean, once she, agreed to come with us voluntarily, I mean, she was still upset, crying, and talking on the phone. Do you remember that answer?
I do.
All right. You didn't mention in that answer that it was only at times that she was crying and upset, correct?
No.
Okay. The whole time, from beginning to end, Ms. Reed was constantly worried about John, was she not?
Objection.
Sustained.
You recall that she was on the phone at one point speaking to someone that she called Papa, correct?
Correct.
Did you later learn that Papa was John O'Keefe Sr.?
I am just learning that just now.
All right. And in any case, you heard her say to Papa, is he dead? He's dead, isn't he?
Sustained.
You could hear on the other end of the line that Papa was saying something to her, correct?
The objection sustained.
May I approach?
The witness or me?
Sidebar.
Okay.
So I'm no lawyer, but my understanding is that it's okay to ask the question, ask the witness to talk about what he heard in terms of and what he observed in terms of Karen's reactions and stuff like that. But there's a hearsay rule. So I don't believe, he can talk about what Karen said because she's the defendant, but he can't in any way refer to something that could be a reference to a conversation. So he wouldn't be able to talk about what he might have heard Papa saying from the other end. If I got that right. So if Heather is here, our YCC lawyer, let me know if I got that right. Or if we can send Thomas to ask Gronk. And to be sure, Kara, that was not Thomas that thought it was Gronk. Tom said it correctly. He said Gronk. When I first looked at it, I thought he said, I was talking to Gronk. Papa is Mr. O'Keefe, yeah. I haven't been outside today, but I'm on the second floor. Not in the attic, as the other side likes to say, but I am on the second floor, so it's getting warm up here. I think it's like 70 outside, but when it's 70 outside, it's in the 80s up here. A beautiful day outside, so hopefully you guys get to go outside. So we got Gretchen Voss as a reporter this week. The other guy, I forget his name, he was in Discovery ID documentary for one of the news channels. He did a good job. I forget which channel he reports, I forget who he works for. And I think that's Matt, the Court TV in the white shirt. That's Matt, the Court TV reporter. I think it sounds like they put in, they approve a new list of court reporters for the week. So no John DePetro this week.
Folks here until 4:30. It's been a long day. So
No,
I'm going to release you today.
no Christina Rex.
Tomorrow we'll make every effort to start right at 9 tomorrow. Please follow those cautions. Do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know, and be very careful on your social media. Okay?
Thomas Gronkowski has had numerous medical procedures in his life. Gronkowski had 2 back surgeries before the Patriots even drafted him. So it's okay to get. I also am in the Merrimack Valley. I forget who just said that. The chat scrolled before I could see it. But the Merrimack Valley seems to be, has slightly different weather. It's always at this time of year if it's 65 in Boston, it's 72 here. During the winter, we get bigger storms. And we also, it seems like, thunderstorms get drawn up the valley too. But for some reason, even though we're north of Boston, it draws in some warmer
All right, so we're
weather,
still in
warmer
session.
temperatures.
Court is still in session. Please be seated.
All right. Court's still in session. Another motion discussion.
It's my-
All right, so I would like to move things along a little bit more expeditiously tomorrow. What would be very helpful to me, Mr. Brennan, are these clips. I haven't watched anything on television about any of these. Do you have them all in one compilation that I can look at in advance? If you don't, you don't.
I thought we had provided it to the court. If we haven't, we will. May I have a moment?
Sure.
Kara, I do not know if Kate is doing that Discord again. I sat quietly in there to listen to parts of that while I was watching the Red Sox game. I talk enough during the day, so I figured it'd be best to stay quiet. But I was listening, so I think it's a good thing that she did that. But I don't know if she's doing it again tonight.
100 hours or something, or is it?
No, we sent the share file, but it's my oversight. We should have brought in a hard copy for you as well.
I don't know that I have a shared file. Was that?
Dropbox link on Monday that we sent,
all
but
right.
I can put it on a zip drive as I should have. And I can.
All right, because I couldn't open that. It needed an email and it didn't accept mine.
Didn't
That's what
realize
that
the
was.
court didn't have access. We will get a zip file and
All right, you talk to Tori about it. Okay, Tori, you'll get it for me. All right.
the intention was that you'd have an advanced opportunity to look at them. I'll fix that failure.
All right. Have your associate talk with Tori.
I will.
All right. All right. Anything we need to know before tomorrow?
No, Your Honor.
All right. We'll see you tomorrow.
See, I don't even remember from last year. Did the trial I felt like the days went to 5 last year, but I guess they went to 4. I don't remember. Last year feels like a long time ago. But I mean, I guess 5 is a burden. The whole thing is a burden on the jury. But obviously, especially considering the sidebars and delays. So Chick and Deb say that it was at 4. Okay. Maybe Yannetti is right. Maybe memory does fade over time. Obviously, memory fades. but it's more complicated than that. It's not as simple as something that happened. I mean, I'll leave this on for a second in case there's something else that comes on, but because we missed something yesterday, emotions hearing, but there's not going to be emotions hearing now. I guess I'll just turn it off. All right. Memory is complicated. And this is actually why I really don't, from my limited time looking into true crime cases, that I decided before this case even that I don't trust eyewitness testimony in general. Now, it's not about lying. It's just memory is fallible. Now, some things, types of witness testimony, I do trust because when there'd be no reason for the witness to be confused or to make it up. So, for instance, I 100%, and also if it's verified by some other data. So for me, the general rule is I want witness testimony that is verified by other witnesses or by some other evidence. Now, in the case of Carrie Roberts, the memory of Karen calling her and saying John's dead and hanging up, that's a very dramatic, specific memory. And also because Carrie Roberts was not connected to anybody except the O'Keefes, there's no reason for her to lie or to make that up. But in addition, her testimony that Karen called right back and said maybe John was struck by a plow, that's corroborated. Now, it was interesting yesterday. Hank Brennan chose at this point, he may later on some rebuttal, but he chose at this point to not play. Last year in the trial, Lally had played the clip, the audio of Carrie calling the hospital. So after Karen said John maybe got struck by a plow, Karen called up the Canton police and talked to Sergeant Good. And he did play that yesterday. Hank Brennan had that played yesterday. Some people said it was less clear. To me, it sounded more clear, like they had cleaned up the audio. But so I guess it's subjective. But they didn't play, unless I slept through it. They didn't play the call to the hospital yesterday. So, I mean, that call to the hospital really kind of verifies what Carrie Roberts said. Is he saving that to play that later? Or did he just decide that it wasn't necessary? I don't know. But memory is complicated. Anybody who's studied scientifically human memory. So, for instance, all of us, every single one of us has memories that we think we remember very vividly. We all have vivid memories that are false. Every single human being on the planet. Memory formation is very complicated in the brain, and the brain, and scientists have still studying it. They've been studying it for a long time. Goes through these various processes to create a memory. Now, sometimes because it's creating a memory, it could create something false. It could create. It's been shown that very much people's memories can be created by what they heard later on. This has been demonstrated in so many scientific examples, where, for instance, they'll have a fake scene where a bunch of people come into the room while they're recording the subject, and nobody's wearing a red shirt, and then they ask the witness, they ask the subject of the test, who was wearing the red shirt, and half the time, at least half of the witnesses will point to someone that was wearing a red shirt, even though nobody was wearing a red shirt. So human memory is very fallible. But the idea that human memory is automatically fades over time, no. Because let's say you witnessed an accident last week. So it's relatively fresh in your mind. I'll give you an example from my own personal life. So last year, I was leaving the gym, which is in a plaza, and as I was waiting at the light coming out of the plaza parking lot, that thing on the light goes up to show that there's a fire truck or police coming. That little white thing and so I look, and a motorcycle cop from the town came flying up the street, flashing blues. So he went through, and as soon as he got through the light changed. So I was probably maybe only 20 seconds, 30 seconds behind him. Now, we drove up quarter mile or less to a right-hand turn. Now, that's a right-hand turn that goes by the post office, and I always make it on the way home. That's my route home. That day I took it out of habit and then realized, in a moment later, I shouldn't have gone this way because all the traffic was backed up because there was there was obviously an accident. I didn't know what it was at first. So as I'm stuck in this bumper to bumper traffic, but it wasn't that because I got there not long after the motorcycle cop. I was maybe still, again, only like, I don't know. It's hard to put memory, 30 seconds behind, minute at the most. So, thank you, Deb. We'll check that out. Thank you. So I get to, as the cars are catching up, and I can see the motorcycle with the light still flashing parked ahead of me, and the trooper now off his bike, and he's walked up, helmet on, and he's talking to a black SUV. No, it wasn't Karen. And he's talking to the driver. And so I'm trying, now all this traffic is there because this is right when the high school is getting out. And so there were more cars there than normal. And I'm trying to process what happened here. Was there a shooting? Probably not in this town, but you don't know what happened. You just see this black SUV stop there. Was that in an accident? I'm looking around for the other car and I don't see another car. But then pretty quickly, as I get close, now the traffic is slowly moving. I get to, as I'm right about to pass the SUV with the cop standing there talking to the driver, I see on the right in the yard was clearly a motorcycle driver on his back and I knew he was a motorcycle driver because he had a helmet on. I couldn't see his face. My impression it was a young person. And there were 2 or 3 girls that were tending to him. The girls were local high school girls because they were jogging by. They're on the track team, and at that moment I had seen a bunch of other girls jogging around that time from the track team, and so they had obviously been jogging through when the accident happened. So they were over helping this, I think, a young person in the yard. Now, my memory. So I drove. Now that was the first glance was seeing that, and then I only saw one glance at that though because he was the motorcycle was slightly forward of where the Lexus was, but as I passed the Lexus, now I could see the motorcycle on the ground, basically up against the bumper of the Lexus, and so I quickly understood what happened. The Lexus didn't do anything wrong; was driving forward, and the motorcycle lost control, slid into. I think there's a little bit of a curve there. So he was going too fast, lost control, slid into the Lexus, and then was thrown quite a distance into the yard. So but I didn't look back to see the condition of the driver. I didn't quite make that connection for sure. It all happened very quickly after I saw the bike. So I was home a minute or two later. And who do I call? Thomas Fleming. I wanted to see if he was eating ice cream with sprinkles on it. He probably calls them sprinkles now because he's down there and he's no longer in England. But no, I was calling him to tell him what I had just seen. And it was also interesting to me trying to see the relevance or comparison to the Karen Reed case at that time. So what I told Tom was that the driver was in this area, in this property divider between the 2 houses, and that he was lying on some boulders that were surrounded by, there were bushes and boulders in the area. And it seemed to me that he was surrounded. He seemed to me that he was lying on the boulders at the property divider. And that's what I told Tom, that I remembered seeing this motorcycle driver lying uncomfortably on the boulders. That was in my head. Now, I drove by that very same site the next day because I've driven it by it a couple hundred times since, because I go by it. That's the route I go to the gym. And I was able to find that property divider where the driver was for sure. But there were no boulders. My memory had created that because I only took a glimpse at him. In 1 second, I saw that there, and then the car continued to drive. And then a few seconds later, I saw the motorcycle, and I put it all together. And somehow, when I put it together in my mind, I remembered that driver lying on a boulder or on rocks or something like that, and the two high school girls attending to him. It was wrong. There were no boulders there. Now, did my memory get better over time, or did I just create a better memory? I don't know. But you could be triggered. So if I piece it together now, I know for sure that he was between the properties. He was in that property liner because I definitely can remember the shrubs and trees and little trees that people plant in between that. And I knew the house. I knew where he was. Why did my mind insert boulders? Well, there are boulders in that area in some of the other yards. It could be that reason. But I would say maybe it just might even be because often in those dividers between the property lines, there are boulders. It's something that the contractors, as they're building these houses, might put there because they're too big to move, and they establish the property line. So I don't know. I had that memory, but again, my memory was false about the boulders on that one detail. But if I was to testify now, I would not include those boulders in my statement. Does that mean I'm lying in my testimony? No, it mean does it mean my memory has improved? Well, in this case, maybe not, and maybe I'm just explaining what I must have seen. But in some cases, your memory can be improved because something else can trigger your memory. So if you see an accident and you try to piece it together later on, and maybe it may be days later or weeks later, it might even be years later, somebody says, "Oh, by the way, there was also a fire truck going by." And you might not have registered that initially, but then later on, you remember the fire truck. That triggers something in your memory, which triggers a better memory. You may trigger a memory of something that you forgot about that accident that you witnessed. So your memory has actually improved over time, not faded. So I'm just saying it's the way these defense lawyers continuously throw this out there, I find annoying. Now they're doing their job. Don't get me wrong, but I think they do it. They did it so frequently in the first trial, and it's so false that they really needed. I think at some point Hank Brennan needs to establish that no, it's not that automatic that memories automatically fade. And Deb, I want to thank you for recommending Thinking Fast and Slow covers things like memory bias and to some degree mob mentality. So that sounds like a good recommendation. So for everybody out there, Thinking Fast and Slow. Actually, I'm going to write that down somewhere else. Thinking, so I don't forget. Thinking Fast and Slow. Yeah, because I am actually very interested in human memory, false memories. I think anybody that investigate or is interested in true crime should be very interested in the concept of false memories, memory planting, recovering memories, all of those different things. So I know this question wasn't for me, it was for chat, but how do people feel today went? I think it went, it's basically a tie, but I think it went well for the prosecution. The prosecution is not trying to score a victory in one day, and neither is the defense, but the prosecution, well, to a certain extent, the defense is. They need to, at some point, have a witness where they really show, boy, there was some kind of framing going on here, right? And they failed to do that today. I think the prosecution is not trying to score a win in one day. They're trying to just meticulously go through and establish all the things that they need to establish to get their case done. So today was not dramatic in that regards. It was obviously dramatic in terms of seeing John's mother testify, and Carrie Roberts' testimony was very emotional today. So I think all of the witnesses were very effective. None of the witnesses were in any way dinged up in any serious way by the defense team. Even Carrie Roberts, she had managed, they had the grounds to impeach her a little bit, right? Because she's changed her statements a little bit over time. But she was so confident and so unperturbed by any of that that it didn't really work, in my opinion, for the defense. She just came across as a very credible person whose memory is not perfect. But her most important memories of this case were not in any way influenced. Her memory of the phone calls from Karen, her memory of Karen's behavior inside when they went searching for John, her memory of uh, what happened when they went inside the house looking for John, and how Karen behaved inside the car. Her memory of the phone call from Karen to with Jen and Karen as they talked over the Bluetooth speaker inside the vehicle on the way to John's. So there was not, I felt like Carrie came across as extremely confident and credible. And I think she knew it too, because when she stood up from that stand at the end and she smiled, she felt relieved it was over, and she felt you could tell she felt extremely, she knew she did a good job. And she stood up to Alan Jackson, stood toe to toe with him, and said, yeah, I'm not lying. I didn't do anything. I haven't done anything intentionally wrong. This is my friend, So I thought it was effective. They did not destroy any of the. So the main job of a defense team is to destroy the witnesses of the prosecution, and they didn't put a ding in any one of these witnesses. And it's clear also from what was said there that Trooper Garino's going to be back at other points to testify about different aspects of this. And I think I'm very glad. And I didn't know if I didn't know, not being a lawyer, is this strategy legal? But I always wondered why Lally wasn't using it last time to break this up. And then I saw in following the Delphi murders that, at least in Indiana, it is legal to have the witness appear more than once, and not just on rebuttal, but to come in at different points during the prosecution's case. So let's just say the thank yous. So Heisenberg, thank you very much for your contribution and for being here. As always, he said, even if we do end up having to do it again, all of these exhibits and contradictions from Karen will get her convicted. The evidence is strong. And that's the thing. So I think that if you're looking at, if there's another hung jury and any reliable information reaches the prosecution as to how close it was. So for instance, if it was 11-1, maybe even 10-2, then you're going to see this tried again. And because you're talking about jury pool tampering at that point. So they're not going to quit after something like that. So if you guys are watching, I just got 2 messages that the 2 Facebook streams ended. Don't know why. Maybe it was just too loud. Too long. That's probably what it was. Too long. We've been on for a long time. All right. So again, I don't know if Kate is doing the Discord again. That was very successful last night. So on the chance that she is, check out her channel, Masshole Mafia, at 8 p.m. tonight. I am not on Court TV tonight, so I'll probably watch the Red Sox and watch Kate. Also, Deborah, thank you for joining. New member. Thank you, Deb. So tomorrow, Kate will be running my channel. I will be gone all day, but I will be probably commenting in chat if I can. I'll be watching all day. This will keep me occupied. And so I'm grateful to have you guys with me tomorrow. And Friday, if there is something Friday, Kate will be running it then too. But it doesn't sound like there's actually going to be anything Friday. So Jen, True Crime Junkie, wants to know. So it says she can't wait to hear from Matt from Court TV to how the jury reacted to Peggy O'Keefe's testimony. So yeah, we'll have to see. Mariners are playing the Red Sox, and Red Sox are on a roll right now. I think they've gone 9-1 of the last 10 games, and the one that they lost, they were ahead in the 6th or 7th inning, and it fell apart. So they've been pretty strong. Thank you, Joan. Appreciate it. And you guys will be in mine too. So thank you. Friday is a half day, but I think it's a I don't think it's a half day of testimony, Katie, right? It's a half day of the jury is going to go visit the crime scene. So that won't be on camera. So you guys can let me know. Do I have that right? I don't believe so. You may see a little bit of the court in the morning when I don't even know if you'll see anything. You may see Friday is the viewing of Fairview, so that won't be televised. So I don't think there'll be there may be no reason to go live with anything Friday. And I'll leave that up to Kate because I'm back in Boston for a treatment on Friday too. Boston News reports that Peggy was joking on the witness stand. I don't know. It's when I watched Channel 7's report on the 5 o'clock news last night from this case, it bothered me because it feels just as biased as their political coverage. And now they're biased. They're just putting out the defense talking points. And I find it really troubling. I don't understand why. There's no basis for it. And part of it is just, it's this echo thing where so many people that have busy lives, right, that have not had time to follow this case to the extent that I have, that many of us have, that Kate or Jen has, or Matt. So all they know is the superficial stuff, and all the superficial stuff, all of it is put out by the defense. All of it, 100% of the superficial stuff that people know about this case, from dog bites to butt dials to everything else. All of that is in control of Karen Reed's defense team because a prosecution can't conduct a trial by the media. Now, the prosecution can put stuff out through the hearings, but if the news doesn't cover it, it doesn't exist in terms of the public mind. The news media could, if they chose to, put out the truth about what's inside a motion, for example, or a ruling. They do not. They choose not to. They'd rather just go with the salacious stuff that's put out by the defense. And this seems to have largely duped a lot of people, including people in the media. So I'm going to bet that if I went to Channel 7, they let me in and they let me talk to who made that story, most of them are going to probably point to all the same seemingly odd things. Well, aren't those dog bites? Why did the chief of police find taillight pieces 10 days later? And on and on and on. They're just going to list all the points, and they're not going to be even aware. I'm talking about those reporters. They're not even going to be aware that all of this stuff has been debunked or explained. They're not even going to be aware of it. They're not going to be aware of the fundamentally overwhelming evidence against Karen Reed. They're not even going to be aware of it. And they're reporters. They have an obligation to be aware. They have an obligation to learn the truth before they go to the news. Now, if you're going to go to the news, if you're going to cover a story, it doesn't just mean you look through the most salacious reports during a 5-hour trial, 6-hour trial, whatever it is, and just take the bullet points of what is most salacious. No, you have an obligation to get to the truth. Now, if Alan Jackson is a little more presentable than Hank Brennan, but you have an obligation to get to the truth. So Alan Jackson has a flair for the dramatic in a way that Hank, maybe Hank has that same flair if he needs it, but he's wisely choosing not to go that route as a prosecutor. But if you're a news media, you're going to find those moments because they're more media savvy and put them in there. And so Channel 7 led off with a multi-minute report. They started out by saying they said Karen Reed trial started today, but the word on the streets is mostly about the defense or something to that effect. I didn't think they said streets, but it was something to that effect. And then they went right to, even though in the trial, the order was the state went first, and then the defense went first, Alan Jackson. But on Channel 7, and they know people pay attention more in the first couple minutes, they put out the defense's arguments. Then They brought in a different reporter and weekly went back to discuss the prosecution's case. And on this goes every day. And this is why the massive amount of the public is misled, misinformed on this case. But there's a duty for them to do the right thing. There's a duty for any news reporter, a journalist, a real journalist, not a turtle boy journalist, to do the right thing, to do the responsible thing, not just what is the most salacious. So I don't think it's that they don't like cops in the media. I really don't think that, because most of these media people are pretty well connected to the power sources in society, as are the cops. So I would say normally the media is going to be a little bit more likely to be in tune with the prosecution, but they're not in this case. And it's because I really think that it's largely because they don't know how fundamentally powerful the evidence is. And they miss the stuff that comes up every day because they don't know the evidence. So, for example, today, that paramedic, I think Whitley was his name, his testimony destroys the idea of 227 search for how long to die in the cold. It destroys it. There's going to be other experts that will destroy that, but it destroys it. And 227 is the heartbeat of the Karen Reed conspiracy. Is the news going to highlight that? My guess is no. My guess is Court TV is not going to talk about it tonight. My guess is none of the news stations, local stations, are going to carry it. It's not because it's boring. It's not as salacious as saying, wow, that information shows John climbed stairs. That's salacious. So they're going to go with it. That evidence obviously didn't come out today, but when that evidence comes out, they're going to go with that. And so this is the problem. This is why this is a threat to the jury system, because those jurors are doing their job and they're being asked to tune out not only all that noise, but all the pressure that comes from that. So the media, which is now, the way the process went was like this. Karen Reed, and it wasn't brilliance on their part. They didn't know it would work out this way, but they knew they had to get this story out in some way. So they went to Turtle Boy, because here's a guy that will run with anything because he's opportunistic. So they went to Turtle Boy. And they know that Turtle Boy had exposed a story in the past about state police corruption. So maybe that was a reason too. But they went to Turtle Boy, and he turns out to be everything they want, because he's more than just someone who's reporting on it on his channel and on his blog. He's a street performer, essentially. He's going to take out his bullhorn. He's used it before with minor effect in other cases, and he's going to try to whip up a crowd, and that's what they wanted. And as they saw him doing this, they encouraged it. And this created the social media phenomena that really trapped a lot of us into the web, including me. That's how I got brought in. But eventually that created this upswelling of support for Karen that was only at a certain level, but it was vehement with all these crowds showing up at court, and the media slowly started to catch on. But so from the media's perspective, you're doing your job, you're not paying attention. This has been going on for a year, and now you're saying, well, all right, why are people interested in this case? And they go and look at it, and what they hear are what the defense tells them, and that's all they hear, because that's all that's prominent on social media. And it gets exasperated because it gets repeated by every other station, and it just compounds. So this creates enormous pressure on that jury, because that jury is going to go home knowing that 90% of the public falsely believes all this stuff put out by the defense. And that's the problem. So now that jury exists in that pressure situation. That jury's going to have family members and friends that that fall under the same sway of the conspiracy theory. And so those jurors now have to have the fortitude to sit there and ignore what the media and what social media chooses to cover in this case. They have to ignore it. Now, the judge gives them those instructions every day. Do your job. You're the only one that's hearing all the evidence. Channel 7's not hearing all the evidence. You and the jury, you're responsible. But it's very hard to be in that position. You're told that, but you're aware of that media pressure. So this is a problem with our justice system, and everybody's grappling with it. Everybody that really cares about the truth, which doesn't seem to be a whole lot of people, but they're grappling with it. What do you do here? So if you're prosecutors in this state, what do? You want Karen to have a fair trial. You don't want to take away her rights to defend herself. Or to Karen Reed's rights, her First Amendment rights are intact. You can't. So, for instance, when the judge applied a gag order, it doesn't apply to Karen Reed. It applies to her lawyers, because in their professional capacity, they do surrender some of their First Amendment rights, or they do because they're in their capacity to cover this case, as working for the defendant. But Karen, you can't take away the First Amendment rights of a defendant. So she's always allowed to say what she wants. So, and nobody wants to take away her rights. We want her to have a fair trial. And the prosecution wants her to have a fair trial. All the prosecutors in the state want Karen Reed to have a fair trial. So what are they going to do here? What do they do all the prosecutors want Turtle Boy to have First Amendment rights. They believe in his right to speak his mind, to talk about this case. Of course they do. So everybody's at this gray area where people that want to do the right thing aren't sure what to do. How do you stop this? And what I've been saying since I've been covering this case, this has never changed. And certainly this has been the case since I flipped too. And trying to confront that mindless mob, it has never been my opinion or my preference that mob be stopped, or that anybody be stopped by laws, by law enforcement, by prosecution. What I've always hoped for, and maybe it's a naive hope, is the public being interested in getting to the truth. And that also includes the media being interested in finding out the truth. Unfortunately, been very disappointed in that so far. We don't see the media having any interest at all in the incredible abuse of justice that was put on by the U.S. Attorney's Office, Josh Levy. Incredible abuse of power to interfere with a murder case, to have improper communications with the defendant, to not protect grand jury witnesses that are appearing before a federal grand jury and who are being surrounded by a mob. And part of that being hounded by the mob came in coordination based on information given to them by the U.S. Attorney's Office. So there's someone leaking from the U.S. Attorney's Office to Karen's team. The media has no interest in that. Why? Why does the media have no interest? The U.S. Attorney's Office is way more powerful than the Attorney General in Boston, the state Attorney General. Way more power than the district attorney. There's a lot of power invested in the Boston U.S. Attorney's Office, in any U.S. Attorney's Office. The U.S. Attorney, the only people over him are the Attorney General in Washington and the President of the United States. Enormous power. 120 assistant U.S. attorneys assigned to Boston alone, doing the biggest cases, some of the biggest cases in the world. Enormous power is given to them, and very little oversight over the feds. The only people that have oversight over the feds are the feds. And yeah, as we know, a lot of times police don't like to police each other. And same thing applies to the feds. So there is no interest in the media as to what went wrong. So when Josh Levy, the U.S. attorney himself, did something no one else has ever heard of that I've ever talked to, any lawyer, anybody in law enforcement, including former FBI, came down and questioned the witnesses in front of that federal grand jury himself. It's unprecedented. And he used Turtle Boy's blog, a blown-up version of TB Daily News, to hound, because he grilled those witnesses. He brought some to tears. This is the U.S. Attorney General in a case that produced zero evidence of a conspiracy. The feds dug hard into this. And they have communications of people. They got the content. They got the actual messages. They know who Brian Higgins called at 1:33 or whatever it was outside the Canton police. They know everything. They found zero evidence of a conspiracy. And if they found any exculpatory evidence of Karen, if they found any evidence of a conspiracy, that would be exculpatory to Karen. They are required. People like Broken Baker don't understand this. They are required by Brady versus Maryland, U.S. Supreme Court case, and subsequent additions to that, such as Tui Rodriguez, that when the feds have, or any branch of the government has, but if this applies as it applies to the feds, if they have any exculpatory evidence for a defendant that is on trial in another prosecutorial agency, so that could be a state or a different federal agency, they have no choice. If they get a formal request from the prosecutor or the defense asking for that evidence, they begin what's called a TUI process, and they put all of that evidence that they have that is exculpatory. That's the only stuff they're required to provide. They aren't required to provide non-exculpatory evidence. But if it's exculpatory to the defendant, they have no choice. This is something that Sean McDonough didn't understand. It's the law. It's been approved by the Supreme Court. And it's also common sense. The idea that the feds are going to let Karen Reed go to jail for murder while the feds are sitting on evidence that proves she didn't do it, that's not real world. That is not real world. And it's not the law. Okay? So they had no choice but to give over any exculpatory evidence. And whatever they gave, the defense had last year. They had the opportunity to use. What did they use? All they had was the messages that were from Proctor, which didn't show a conspiracy, didn't show evidence planting, didn't show any lying or any corruption. All it showed was some inappropriate comments. So the feds dug deep, way deeper than a state agency could, and they found zero evidence of a cover-up or conspiracy. This is something that the media ignores. This is something that Karen Reed's followers completely ignore because they're not interested in the truth. Now, so the feds, back to my point, though, the feds found this evidence. They found no evidence of a conspiracy, of a cover-up. Yet, now most of that was known by the feds by the time they grilled their witnesses on the stand. These witnesses many of these witnesses you're seeing before us here, they questioned Carrie Roberts. You're seeing, I don't know if Carrie was just questioned by federal agents. I'm not sure if she went before the federal grand jury. I think she might have just been questioned by agents, but they have that evidence too, though, right? So the feds had seen, but so by the time they took the witnesses and put them on the stand for a federal grand jury, they had already seen all this evidence, and they've had found no evidence of a cover-up. So Josh Levy knew that there was very likely, by the time, I don't think Josh Levy knew when Karen walked into his office in the summer of 2022 with their lawyers and said, I'm innocent, there's a cover-up. I don't think Josh Levy knew. I think they duped him. But by the time he was questioning the witnesses on the stand and the federal grand jury in the summer of 2023, he knew. He knew that there was he knew at that point, he knows now there was no conspiracy, but he knew then that there was no conspiracy. He knew it was very, very unlikely there was a conspiracy, that they hadn't found anything at that point, and that it made no sense. Yet, despite knowing that, he, in desperation to defend his own reputation, grilled those witnesses on the stand, desperate to do anything he could at this point to help Karen Reed. Because helping Karen Reed at that point helps himself. Because this case is now embarrassing to Josh Levy and the feds. Josh Levy, first or second in his class at Princeton, elite partner at Elite Ropes and Gray. These guys are the best of the best. This guy he's lived the best life, right? He eats all the best restaurants, hangs out with a la-di-da people. He's had a good life. And now he's effed up. His big move, his big ambition was to become U.S. attorney. He leaves Ropes and Gray takes a job as first assistant U.S. attorney. He campaigns to become U.S. attorney right away when we had the new Biden administration. He knew there was going to be a change. And so he gets on the list of 4. The other one, Rachel Rollins, was another person on the list. Now, Rachel Rollins was always going to get that. She was the kind of person, the kind of prosecutor that the Biden administration, especially in that moment coming off certain political things that were going on, they were going to choose her. I don't know how he didn't see that. In fact, well, he did see it. The only way, Josh Levy knew the only way he was going to get selected as U.S. attorney over Rachel Rollins was if Rachel Rollins dropped out. And he tried to get Rachel Rollins to drop out. He, on the phone, tried to get her to drop out. She didn't. She became U.S. attorney, and he seems to have set about immediately trying to undermine her. 30% of the U.S. attorneys at the U.S. attorney's office are said to be people that used to work for Ropes and Gray. It's kind of a revolving door. They go from one to the other and back. So Josh Levy went into that office with probably 40 or 50 lawyers, say 40 lawyers, assistant U.S. attorneys that will now be working under him, because the first assistant U.S. attorney is like chief of staff. And so he goes into that job with 40 U.S. attorneys that are already there, that are already kind of beholden to him, because 40 of those attorneys used to work for Ropes and Gray themselves. Interesting, right? What kind of connection was going on? What kind of backroom door connections were going on between Josh Levy and those other Ropes employees before he took office? Well, it seems to have been a lot. And he was already trying to set up Rachel Rollins for a fall. That way he could become U.S. attorney. That was his goal. That was his ambition in the first place. So he becomes U.S. attorney in May of 2023, about less than a month after Turtle Boy started publishing articles on the Karen Reed case. But it's at that time he's preparing to question the witnesses in the grand jury. Strangely, he does question them. Now, these people follow the media very closely. U.S. Attorney's Office is driven by headlines. They eat up headlines. They follow headlines. That's mostly what they care about. That's the key. They're ambitious, and that's a key part of their ambition is headlines. You want to get ahead? Generate a headline. And so as they're following, so you're going to tell me that Josh Levy wasn't following the headlines that showed this huge storm whipped up by Turtle Boy and Karen Reed and the defense team, and these hearings that were suddenly packed house and drawing dozens and hundreds of people outside? You're going to tell me that Josh Levy wasn't aware of that? Don't bother telling me that, because it's stupid. Of course he was. So he's aware. I guarantee he was aware that these witnesses, it wasn't just that these crowds were showing up at court. Turtle Boy was taking a mob and bringing it to hound the witnesses that were due to testify before a federal grand jury that he was going to question. So he knows this. He's got to know it. Got to know it. And despite knowing this, when he questions them, he uses a blow-up, so a chalk, if you prefer, blow-up chalk of TB Daily News. It's big enough that the witnesses can see it. And they know that he's basing his questions to these federal juries off an article on TB Daily News. I bet they didn't teach you that at Princeton, did they? Mr. Levy, they didn't teach you that at Princeton. What do they think about that at Ropes and Gray? Is it that cold and ambitious that like, oh, well, all's fair and whatever. So if you had to terrify these witnesses by using that, oh, well, everything's fair. If it's legal, it's fair. That's what I talked about this morning, right? A lot of lawyers, it seems to be, they don't have ethics. They've replaced their ethics with, if it's legal, it's ethical. For them, ethics is the law. Not all attorneys, but it seems to be there's a little problem there. And so maybe these guys at Ropes and Gray say, you know what? Josh Levy has every right to use a blow. In fact, I've heard this from other lawyers who told me this. They've said that he has every right to do it. So there's nothing wrong with it. In their mind, there's nothing wrong with using a blow up of TB Daily News because it's, as they might say, it's been done. It's common to use a blow up of a newspaper article or something like that. So no problem. That's their opinion of it. They have no curiosity. So He uses that while he knows those very witnesses are being terrified by that mob that's created by Turtle Boy. He knows this. And yet, as I said, Turtle Boy refuses to respond to this instead of his normal bragging. So there's something really strange going on there. But these are all things that the media has to cover. Not this little guy with a stupid yellow sign behind him. Even though David Yannetti did wear the yellow cottage tails tie today. No, this has to be covered by Christina Rex, Ted Daniels, David Bienick. It has to be covered by mainstream reporters. Those are the names that I just had at the top of my head. But I mean, there has to be legitimate reporters that work for the Globe, that haven't been co-opted by David Yannetti, that want to get to the truth. There's a story here. There is a story. Come and get it. Go digging. Don't be afraid. I know everybody's afraid of the feds because they got the IRS in their back pocket. They can make your life miserable. But you're in the media. This is what you got into. You're a liberal working for the Boston Globe, a liberal journalist. Who's your inspiration? Right? Your inspiration is Woodward and Bernstein. The reporters that exposed Watergate. That's your inspiration, right? Go be Woodward and Bernstein. Don't be afraid. Get to the truth. Ask the questions. Go knocking at the U.S. Listen, it seems like Leah Foley, the new U.S. attorney, maybe wants the truth to come out herself. Go ask her. Do your job. It's not that hard. Don't just sit there and regurgitate stuff that gets the most clicks and views. Be an actual reporter. Get a scoop. Uncover the story. You can do it. That's called integrity. Integrity applies to all kinds of people. It should. It applies to prosecutors, law enforcement, defense attorneys. It should apply to U.S. attorneys. And it applies to reporters. Do your job. Get to the truth. Don't leave it to me. That's not fair. I don't have the power. I can't call the U.S. Attorney's Office and get a meeting. They wouldn't even take the call. I guarantee it. I'm a nobody. But if you have Boston Globe, Boston Herald, unfortunately, there's not a lot left. You got Channel 5. If you have that, you can call up and say, this is so-and-so from Boston Globe or Channel 5. They're going to call you back. They're probably going to lie to you at first, but that's what happened in Woodward and Bernstein. They ran into a lot of dead ends, but they dug and they dug and they dug. And look, if you want to absolutely do it, I think you should do it because that's what a journalist does. But if you only care about yourself, okay, let's sell it on that reason too. Look, Christina Rex did a fantastic job in the other guy, I forget his name, in the Discovery ID documentary. So maybe Christina Rex becomes a little bit of a star out of this, right? She's covering the case in court. She's covering the case on TV with the Nope My Objection lawyer. I forget her name. And so maybe she becomes a star out of this. Well, go and get this story. Get to the truth. Do the hard work. And maybe you'll get a book out of it. Maybe you'll be this part of a documentary. This is your chance, man. You may never get another chance like this in your life. This is a rare. All right. So I just had to ban someone. Sorry, I haven't had to ban someone all day. So felt good to do. It's someone trying to say that I'm shameless for attention. Like I'm looking for attention here. No, I'm trying to do the right thing. This matters to me. It bothers me. This case is under my skin. I've stuck with it for that reason. It bothers me. It should bother you. Any fair-minded, intelligent, reasonable person that cares about the truth, this would bother. So the dude abides. Good to see you. The dude got me that neon yellow colored sign back there. So I very, very much appreciate it. And every time I see it, I feel encouraged by him. So thank you, dude. And he said, "Been so damn busy with work, trying to get caught up. Always appreciate the coverage. Justice for OJO." That's Officer John O'Keefe. So thank you, dude. Glad you could make it. Just scanning through chats. See if anybody else had interesting. Okay. All right. I said my piece. Sorry about the sorry if I was looking for attention. I mean, no, sorry about I got long-winded. I mean, this is important to me. I'm passionate about this. I don't understand. Look, even I grew up thinking that Woodward and Bernstein were the ideal model. I saw the movie. What is it? All the President's Men. You know, what they went through to try to get to the truth on Watergate. I was just a little kid. But so Joe says live with Kate tomorrow at 10:45. So that's what time they'll be on. Good. So I should be I'll be in the middle of my treatment, but at that point, I think I could be able to watch. So very good. Thank you, Seasons. You know, and thank you, Jackie. You know, that's all I care about is trying to get to the truth. I would say this if I had 48 hours to live, and that's nobody would care about attention if they have 48 hours to live. I will try to keep everybody up to date with tweets, but also check out Masshole Mafia. I think it's her same name on Twitter, and she'll be keeping everybody up to date as to when they're going to start coverage tomorrow, if they're going to start coverage tomorrow. I'm not sure if there's going to be anything to cover tomorrow, but I'm sorry, I forget. I stand corrected. Tomorrow, there definitely will be stuff to cover. So court starts at 9. So hopefully Kate can do that. I'll give her a call later to make sure she can still do that. As of yesterday, she said she could. So I'm thinking of Friday. Friday is the day that. So yeah. So Joe is corrected. It live with Kate at 8:45 a.m. Correct. So Kate will be live at 8:45 tomorrow. Correct. Thank you. I know Joe's in a different time zone. So, but I should have realized, and I got it wrong. So let me repeat. Tomorrow, the show, this channel, Kate's channel, and presumably Jen and Matt's channel will all have this coverage back at 8:45, by 8:45 at the latest tomorrow. It's Friday that things are up in the air because the jury is going to the crime scene. It was my mistake. Tomorrow, Thursday, trial is back, and you'll be able to find it on these channels. Thank God, because I'll be watching from it too. All right, guys. It's okay, Joe. So everybody, I will be commenting tomorrow in chat, and I will see everybody when I see him. I'm not sure when I see you, but I'll see you maybe this weekend.